Good morning and welcome to the Environment and Natural Resources Committee. That's right, that's what we are, a committee. And we now have a quorum so we can begin to meet. This morning at this time, we will have a briefing from DEP regarding waste generation and disposal capacity. And then when this has finished, we will begin public hearings on two bills, which will not necessarily go in order. 2210 will be first, in part because I don't have a co-chair right now. And then after we take a short break for lunch, we will have a public hearing on 2174 and 2187. So 4 public hearings following our meeting today. And we're going to start with introductions, beginning with my friend Rep. Ankeles on my left.
Good morning, everybody. I'm Representative Dan Ankeles. I represent House District 100, which is a central portion of the town of Brunswick.
I'm Mike Soboleski. I represent the 73rd District in the Western Mountains, parts of Franklin, Oxford, and Somerset counties.
Good morning. I'm Lori Osher. I represent District 125. That's a majority of Orono. It's the home of the University of Maine. It's named after Chief Orono of the Penobscot Nation, and my pronouns are she, her.
Good morning. My name is Joseph Martin. I represent Senate District 19, the central parts of Oxford and Franklin County, north to the Canadian border. About 28 towns and 71 townships. Thank you.
Hello, everyone. I'm Bill Briggio. I represent District 60, which is the east side of Augusta.
And I'm Art Bell, House District 103, Yarmouth, and it's really lonely over here.
Yeah, I was thinking that, Art. I'm sorry. Rep. Bell, my understanding is your friend Rep. Riley will be here in about 15 minutes. He's only going to be half an hour late. So with that, I also want to introduce our analyst, Mr. Dan Tartikoff, to my right, and our clerk, Ms. Ashley Malsbury, to my left. They are both important to our work. And I also want to say that I have a cold, so if my voice falters, please excuse. And with that, please take it away, Suzanne and Carla, from the department.
Thank you. Good morning, Senator Tepler and members of the Environment and Natural Resources Committee. Thank you for having us today. As you know, my name is Suzanne Miller. I'm the Director for the Bureau of Remediation and Waste Management, and I'm joined by
Carla Hopkins. I'm the Director of the Division of Materials Management at DEP.
And today we're going to talk about waste generation and disposal capacity in Maine. First, before we get going, I just want to ask, did you want to just ask questions as we go, or did you want us to kind of throw all sorts of information at you and then ask after the fact?
I think I would ask your preference because some people don't like to be interrupted in their flow, or you're okay. Okay, well then I'll just keep looking around, and if somebody has a question, we'll interrupt.
Okay. Also, I just want to point out that as I do this presentation, I'm going to ask some rhetorical questions. I don't expect you to answer them. I just want to kind of pose some questions for you to consider as a committee. So the objective of this presentation is going to be to focus on waste, capacity for disposal, waste generation, and then basically the lay of the land here in Maine. And I'm going to refer to the most recent report that we just submitted to you in January. It's the 2026 Waste Generation and Disposal Capacity Report. It's based on years 2023 and 2024 because of how long it takes to get the information into the department and then to analyze that data. So the next report that we issue will be for subsequent years. So this is always going to be a little bit of a time delay. Okay, so this report, it is required under statute. The data comes from municipalities, licensed facilities, and transporters. And basically, the data in this report is only as good as the data we're receiving. So we may not have, the perfect, most complete picture of what's happening in Maine, but it's pretty good. It's based on what gets submitted to the department in annual reports. I just wanted to mention that. We focus on municipal solid waste and CDD that's generated, imported and exported. And then I also wanted to mention.
Suzanne, could you elucidate municipal solid waste and yeah, thank you.
Yep.
Just because I think people who might be listening in don't know those terms.
Yes, thank you, Senator. So MSW stands for municipal solid waste, and this is waste that's generated by at the municipal level. So basically your residential waste, some of your business waste, anything the municipality collects and then has to manage as solid waste. CDD is construction and demolition debris. So it's, let's say you're taking apart a building or a house, you often have big kind of bulky pieces of waste. That's essentially, brick and mortar, that kind of thing. So I want to also mention that the data in this report talks about Maine's solid waste goals, and included in that calculation is the percentage of waste recycled from our bottle bill and our other recycling stewardship programs. And I wanted to point this out because Senator Tepler and I were at a meeting about a week or two ago, and I misstated this. So I just want to make sure it's on the record that all of those other recycling programs are integrated into this report for the purposes of Maine's solid waste recycling rate. And that rate's at about 36% as of 2024. It's a little bit higher than the national average. It's a little bit higher than what we've had in past years, which was around 34%, but it still falls short of our 50% goal. So in this report, I'm just going to walk you through quickly. Part 2 of the report, you'll see a lot of nice tables and charts and data pertaining to waste generation, what kinds of waste and where and all of that sort of thing. The third part of the report talks a lot about the recycling rates and what's recycled in Maine. And then part 4 of the report is the conclusion section. I'm going to focus on that a little bit right now, which basically reconfirms some of the recommendations we had from the 2024 Maine Materials Management Plan. You also have a copy of that in front of you. And those recommendations were the following. The need for the expansion of the Juniper Ridge landfill, getting the Orrington incinerator and the Hamden mechanical recycling facility up and running, looking for alternative options for managing sludge. That was from 2024. Those were some of our recommendations. And then also in this report, we want to continue forward with implementing infrastructure for waste diversion and recycling, as well as regionalization for waste management. So I just will say one thing that, if you look at the population of Maine and where all the city centers are, the vast majority of Maine is being generated on the southern half of the state. Is that where all of our infrastructure is for dealing with waste in Maine? So just something to, again, one of those rhetorical questions I mentioned that I was going to have as we go through this process. So waste generation in Maine, this quick slide here is just, again, to point out that our waste generation is increasing at a speed much faster than our population. So that's probably boils down to behavioral, our consumerism and our choices in terms of how we manage our waste. That's all I really wanted to mention about this, but this graph gives you a nice depiction of that. Oh, here we go. So the big picture in this report is, I think, summarized nicely in this slide, which is that we are generating more municipal solid waste. We're generating more sludge and bulky waste, and that needs to be disposed of. And that's due in part to our land application ban for sludge. And then on the other hand, we're losing places to put these wastes. So I think that's the key message, right? Generation's up, places to put the waste going down. Yes.
Can you say whether the bulky waste is CDD or some other kind of bulky waste that you're referring to here? And is this Maine generated bulky waste that you're talking about?
Yep. So this slide wasn't really meant to go into that level of detail, but what I will say is the bulky waste is definitely things like CDD, like construction and demolition that we talked about. And also a subcategory of that is oversized bulky waste. And that's what we talk about a lot when we're talking about what we want to mix with sludge to provide stability in landfilling. And what was the other question you asked? I'm sorry, I lost that. There was a second part.
About whether or not the bulky waste is primarily from in-state or out-of-state.
Yeah, the report itself goes into that level of detail. Off the cuff, some of it is from in-state and some of it isn't. And we'll actually talk a little bit about imports and exports in, I think, 2 or 3 slides.
Thank you.
Yep. The only last thing I want to mention about this is that, and we'll talk more detail about this, is that licensing for new facilities, the time required to do so is significant. And I'll go into more detail about why that is in a minute. I would be remiss to talk about landfill, not just landfill capacity, waste disposal capacity and waste management handling in Maine if I didn't talk about the connection with sludge. So there's clearly a connection. Obviously, we know that we have more waste going to our landfills now because we have a land application ban. I wanted to point this map out to all of you on the committee because Maine is not the only state now that has a ban. Connecticut also has a ban. And other states are doing things similar to a ban. They're limiting how much land application can happen. New Hampshire has, I believe, a bill in the legislature to talk about possibly having a land application ban. And some of the states, like Texas, are creating limits that are low enough that, in fact, it may be a what we call de facto ban, meaning that the limits are low enough that there won't really be any land application. And I bring this up only in the context of what does this mean, all these changes at the national level, what does that mean for Maine? And I think the takeaway is that more and more states are going to be looking for places to handle and put their sludge. And that might affect Maine because we might be in more competition to find locations to do that. So I think that's a really important consideration. It also may affect new facilities that we have coming online that are available to take sludge. If Maine's generators aren't able to take advantage of that new option to manage sludge, it may be that other states start to swoop in and take advantage of that option. I was talking about new facilities that are coming online to manage sludge, like the new sludge dryer at Waste Management, for example. So where does Maine's waste go? I love this particular slide because I think it's very illustrative of what's happening with Maine's waste. 68% of Maine's waste is going to landfill. 45 of that is going to Juniper Ridge. 16% is going to incinerator. 10% is going to EcoMaine. 5% of the waste we generate here in Maine goes out of state. And so I think the key takeaway message from this pie chart is that we are relying on 2 landfills to handle 2/3 of Maine's waste. So I want that to really sink in because we're relying on 2 facilities to handle all the waste for the state. And I think the key thing we need to think about is maybe we need to diversify. Maybe we need to build in some more redundancies because if any of these entities shut down, then what? And that's the big question, then what? So if Juniper Ridge doesn't get expanded, then what? If Waste Management decides it doesn't want to take any more waste, then what? If EcoMaine has a problem and they have to shut down for a long period of time for maintenance or whatnot, then what? Right? These are all big then what questions to have answered.
Yes.
And the 5%, is that going to Canada or is that going to other states in the US?
I don't,
I'd say it's probably a variety.
Thank you.
Some of the border towns go to New Hampshire, there's a landfill there. And then some will go to Canada as well, the more northern and, far eastern parts of Maine.
Thank you very much, Ms. Hopkins.
all right. Now we get to talk about the imports and the exports. I think this might help answer the question you had earlier, Senator Tupler. So waste that's generated in Maine is about 95%. We said 5% is going out of state. We know that 12% is coming in state. And all of that comes from the data that's in this report. And so I highlighted that in purple because what that shows is everything in purple in this pie chart is actually disposed of in Maine at a Maine disposal type facility, whether it's a landfill or incinerator.
Thank you, Director Miller. So does that, is that 12% on the increase or on the decrease in the 2 years since the data in this report was created?
So in the past 2 years,
Yes,
I don't think we have the data fully available to ascertain that right now. For instance, disposal facilities report in April for the previous year, so we won't even have the 25 data till
till
next,
April.
well,
Okay.
2 months from now.
Do you have a guess or is that something you're uncomfortable
I would,
making?
I'm a person who deals with data, so I'm
Okay.
uncomfortable without having
Understand.
looked at it.
Thank you.
Yep.
Yes, Rep. Sobolewski and then Senator Martin.
Thank you, Senator. Good morning. Good morning. That number of 12%, I believe that's down. I think in 23, when we were talking about sludge and the amount we were bringing in of OBW, was 20% at that point. We were down by that much. So I think that was what that was. The 12%, is that also taking into account the waste food that we import for like Exeter? We bring in 25,000 tons, I think, a day for that facility. Is that in that figure as well?
No, because that's not a disposal facility. That's a processing facility. So no, it is not. This is just disposal.
So that's looked at as a business product instead of a disposal. That's what you're saying.
Well, they have
Basically.
some, we'll call it residue that they have to dispose of. They have a depackaging unit there, so that has to go for disposal. But most of the waste that comes there is run through the digester, creates gas that they use for energy to power the facility. Then the digestate, what comes out the back end of the facility, is dewatered. The liquid is spread on the fields at the co-located dairy farm, and the solids are used for bedding the cows that are at that dairy farm.
Is the 12% all OBW or is there anything else involved in that? It's all OBW.
No, there's also waste that goes to like the waste management landfill. They take waste from out of state as well. And I think the other thing too, to clarify on this, because I think this is what some of the questions are getting at, is this is waste that comes into state from out of state and goes to either a processing facility or a disposal facility. It does not necessarily differentiate whether the waste started out of state after it leaves the processing facility and moves on from there, because something's already happened to it. The waste has already been processed. And then from that point, it may end up, there may be a portion of it that goes to landfill and there may be a portion of it that does not.
Thank you. One final one. Do you know where they stand at waste management on that dryer? Is that up and running yet?
It will be up and running by the end of the second quarter.
Thank you.
Okay, Senator Martin, do you want to?
Yeah.
Okay, please go ahead.
Looking at the, going back and looking at this pie chart here, what would happen and where would all of the waste go if Juniper Ridge had to close down and this pie chart was still in place?
I'm so glad you asked that because I was going to touch on that in just a minute. So I think what I'll do is answer that question now. There are a couple things that could happen. That waste could have to go out of state. So we have to think about shipping our waste out of state as an option. Let's say theoretically, Waste Management were to step in and take that waste at their facility because they're a commercial landfill and they have a good amount of capacity compared. All the other landfills are really small in comparison to Juniper Ridge and Waste Management. And that's why I really focus on those two landfills. So let's say theoretically, Waste Management steps forward and says, okay, we're going to take what Juniper Ridge can't take anymore. Their landfill capacity would be shortened. Right now, we estimate about 12 years left at that facility. You'd have to cut that down to about 4 to 5 years to cover, just based on the numbers of how much Juniper Ridge is taking in every year, how long it would take for that facility to fill up. So you're still left with, it's like a temporary, we have 4 years instead of 2 years, right? So we're still left with a problem. We haven't solved the problem.
One more question. I know this is going to be more of a guess than anything else, but I can't think of anybody better to guess at it than you two. If that happened and the waste management goes to 4 years and all this stuff has no place to go, what's the extra cost going to be to the taxpayers in the state of Maine?
I think that's a really good question. It's probably one neither Carla nor I can answer. I'm not going to speak for you, Carla, but I feel like what I can say is that I get mixed messages from different we have a bunch of folks here who run some of the different waste processing facilities and have a better sense of what the market prices are out there for tipping fees and things like that. But I think we have to consider that there's going to be transportation costs in addition to whatever the tipping fees are out of state.
Okay, would it be fair to say that the prices would probably double because they did on the bill 2 years ago when the sludge had to be hauled to landfills?
Senator Martin, I don't feel that the directors from Department of Environmental Protection can answer the financial questions that you're asking right now.
Oh, okay. Well, I'm just, could you try to answer that one? And that's my last question. I understand what you're saying.
I would be surprised if they didn't increase. I mean,
Okay.
that's about as comfortable as I feel. I imagine they would.
All right, thank you.
Okay. So I already kind of covered what I wanted to talk about with this, but I just want to draw your attention to this, this table because this was based on 2024, the year of 2024. So if you subtract 2 years from each of these estimating lifespan years, that's what we're at right now in 2026. So I'll just leave it at that. You can look at those numbers later. But again, the key thing is you'll see that total remaining license capacity available. It's Crossroads and Juniper Ridge that have the highest amount of capacity statewide. I will also mention that the two landfills up in the county, the Presque Isle and Tri-Community landfills, one of them is operating now. The other one's on kind of closed in the interim until such time as the other one's going to close, and then they're going to start up the other one. But in the long, what that means is that they have about 18 years or so capacity, I believe, on each of those. And so they're doing pretty well up in the county for long-term planning, considering the population. However, if you look at the rest of the state, this shows exactly what capacity is left.
Representative Briggio has a question.
Thank you. A couple of questions, please. So in my district is Hatch Hill. Fond memories. How are they doing on their application for expansion? And I understand it's a vertical expansion.
Correct, vertical increase. They've received that. So, but this was put together before that was issued, so that's why.
So they
it
have
looks
that.
like correct, and I'd have to look to check to see exactly how many additional years capacity that's providing.
So when you say they have, that they're permitted, are they good to go?
Correct, they're permitted.
Okay.
I mean, they haven't begun construction yet.
And how much capacity does that add?
I'd have to check to make sure,
Okay.
but I can find that out.
Second question. There was talk a while back about the idle landfill that was associated with the J paper mill. And the possibility that there might be an opportunity there to reopen it and add to Maine's capacity in the process, either through a private operator or the state. Is there anything to report on that?
So the state did not, in fact, move forward with that. The short answer to that question is that Municipal Waste Hub now owns it. That's the entity that operates and owns the, I may be misstating in terms of ownership, but they're the entity that, operates the Hamden facility, what was the former Fiberite facility. So they have purchased the J landfill, and they are looking, I believe they're still looking at options for how they're going to be using that facility.
Question, I'll hold off on until we're done with this presentation.
Okay, thank you. Write it down. Please proceed, Director Miller.
Okay, so with that, I think Representative Briggio's questions were right on point because he started asking about infrastructure. So I want to talk about what we have and kind of what we need, and things for you to consider as we go forward. So we talked a lot about landfill capacity, where Juniper Ridge is, where Waste Management is, where Hatch Hill is, the J landfill. So the question, maybe the rhetorical or not so rhetorical question for the committee is, should we be considering new landfill locations in Maine? Going on to incinerators. We have the Eco Maine facility, which is taking about 10% of Maine's waste. We have the Maine Waste to Energy facility in Auburn, which is taking about 6%. We also have the the Eagle Point facility in Orrington, which has not been taking any waste. It's been idled, still idled. We're told that it will begin operations sometime in mid-2027. Can't really speak to if that, if that's going to be the case or not. But I think it's important for the committee to understand that if this license and if this facility is fully operational, the facility is licensed to take about 200,000 tons of waste per year on average, and that's about 11% of Maine's waste. So I just want to throw that out there. But while that facility is idled, that's 11% that's going to landfill. I mean,
Yes,
So what's the
Representative.
holdup with that one? Why will it take another
I think
year?
I can answer that if you don't want to. We were there, Representative Brigio. Did you go on the
No,
tour that included that?
no.
They had a terrible fire there some years back, I think 2 or 3 years back, and the facility is not in good shape at all right now, and will take an enormous amount of dollar investment in order to be up and running. Okay, I see Rep. Sobolewski and then Rep. Osher, and are you conversing or are you asking questions of Director Miller? Okay, thank you, Rep. Sobolewski. Go ahead.
Thank you, Senator. We should consider new waste facilities, new landfill facilities. Are you talking about private or are you talking about the state staying in the landfill business?
Yep. Fantastic question. And that was a question I was going to ask the committee to consider as well, which is right now we have a moratorium on any new commercial landfills in the state. And one of the questions I wanted to ask the committee to consider is whether that should be the case. And I say that in the context of we do have a state-owned landfill and we just seem to hate it. We seem to hate how it's operating. We seem to hate the operator. So is it better to have a commercially owned and operated landfill? I don't know the answer to that. I'm not advocating for one thing or the other. I just want to throw that on the table that it's another thing to consider.
That moratorium, could you speak to that at all?
It-
When did that go into effect? Is it perpetual? I mean, forever or? Because I feel the same way that way. We should get out of the landfill business. So that's important to me.
I can't recall if it was 89 or 93-ish when the moratorium went into effect. And it was basically, as I understand it, to limit out-of-state waste into Maine. The only way that that could be controlled is if the state owns the landfill and decides what goes into it. So that's my understanding of it, as it does predate my involvement with DEP, but based on what I know.
Thank you.
Rep. Osher?
So it's my understanding from our tour that the incineration facility was not working at the time of the fire. And so they had waste to the ceiling of the shed that caught fire. This is why when we went to the shed, which is now mostly empty, it looked like there'd been this terrible fire, but that the incinerator wasn't working then and still is not working. So when they say that they're going to get the place up and running, I'm sure for their investors, that's the right thing is to say short term, but there didn't seem to be a lot of activity tinkering to get that incinerator working while we were there on the tour, even for show. And I don't know. I know that in the 80s, I worked for an environmental consulting firm. I changed jobs because we did a lot of getting sites prepared, approved, permitted to do waste to energy facilities. And I wasn't supportive of the idea of burning waste. It's been many years since I thought about that, but I know that that was in vogue in the 80s, and that's when we got this facility in Maine. I don't know what the state's rulings are on whether someone could build a new one. I know that old technology is often really hard to get started again, except in the case of the 50s cars in Cuba. But for the otherwise, to get things going that meet present day requirements, it's often easier to start new. Is it legal for someone to come in and build a new waste to energy facility as opposed to fix one that's old and hasn't been working?
So incinerators are also disposal facilities. So the moratorium we discussed, I think, would apply to that as well, unless municipally or state owned. So no, sort of, I guess is the answer. It depends on who's the owner.
Thank you.
But I think to just kind of put a finer point on that, I don't think it's the technology per se that would prevent a new facility from coming in. It's the ownership. So if there's new technology that meets, all the bells and whistles of air permitting requirements, solid waste incineration requirements, then it should be, and the community wants it, it should be an option.
Yeah.
Okay, I'm going to turn on to processing facilities. So processing facilities are those types of facilities that actually reduce the volume of waste before it goes to a disposal facility like a landfill or an incinerator. So I want to talk about some things that we do here in Maine to process waste. We have a new facility up in, or maybe it's not so new, but the facility is going to be newly operational this year up in Hampden with the Municipal Waste Hub. They're licensed to take in approximately 180,000 tons per year of waste, which would equate to about 10% of Maine's waste stream based on that pie chart we looked at. That's pretty big. My understanding is they're going to also be online in the second quarter of 2026. So something really exciting there. So that can help reduce some of the waste going to Juniper Ridge landfill. But again, with a new facility, we have to factor in that there may be some bumps and starts. And also, again, sort of to my original point, which is if one entity shuts down, what then, right? Do we have enough redundancy built in to handle the whole system of what we're generating? Representative Sobolewski asked about Exeter. Exeter takes in about 46,000 tons of food waste, silage, fats and oils, and grease. And then those wastes are mixed with manure, and that's used to primarily create energy. So basically, they take in that waste, it's used to create energy. And as Director Hopkins mentioned, some of that waste, there's a little bit of residual from depackaging that goes into, I think they send it over to EcoMaine.
Okay, Director Miller, we have a question from Representative Angeles.
Thank you so much, Madam Chair. Thank you both for being here. So just on the prior slide where we have sort of the remaining lifespan of each facility, when we talk about this slide where there's new things coming online, I'm assuming that lifespan slide doesn't factor in. So do we know how many years it adds to the Juniper Ridge capacity when we talk about things like the Eagle Point coming online and Municipal Waste Hub in Hampden coming online? What does it do for the Juniper Ridge's timetable?
I love that question because I was really trying to get at that when I put this presentation together. And I don't have a direct answer for you, but what I can tell you is that's why I gave you the percentages. So like we know that in 2024, it was 45% of Maine's generated waste going to Juniper Ridge. If you take 10 and 11% from Epic and Municipal Waste Hub out of that 45%, theoretically, maybe it'll go down by certain percentage points. But again, I don't know what exactly that will be when a lot of this is based on conjecture and projection. So it's really hard.
I just wanted to make sure it's clear that the waste from Municipal Waste Hub goes to waste management except for the waste swap materials. So Municipal Waste Hub is not actually contributing to disposal at JRL except for the community waste swap that goes on just for transportation, cutting down on transportation. I just want to make sure that's clear. We do have Mike Carroll in the audience, and so I think he would want that corrected.
But it would be fair to say that, and then it would increase waste management's lifespan a little bit. Okay.
Of course, yes.
Thank you.
Okay. Okay, so other processing facilities, I really wanted to mention the sludge dryer at Waste Management. I talked a little bit about that up front, about how, this is the time for a lot of Maine generators of sludge to take advantage of an opportunity before other states might start taking advantage of that opportunity. This facility is going to basically take in sludge. I think they estimated it would be about 80% of Maine sludge could be taken in that facility. If Maine generators opted to make that choice and do that, that facility will be online by the end of the second quarter 2026. So that's really soon. The facility is currently taking customers, but I think it's important for the committee to know that only 2 waste generators of sludge in Maine so far have signed up for this opportunity. So, you know, that is something I want to mention because it's unfortunate. We have technology available. We have an option in front of us, but it doesn't seem like a lot of that opportunity is being met right now.
Yes. Oh, Rep. Osher.
Is there an increased cost to sending the sludge to a dryer, either transportation cost, or is there a tipping fee for going to a sludge dryer versus going directly to a landfill?
So there are costs to both of those things. I don't know that we have the most up-to-date or accurate information, as this is the kind of thing that's handled by market forces and not by the department. I'm sure there's a cost. Maybe the cost for the sludge dryer might be a little bit more, but I don't know that, and I don't want to overstep my knowledge about that.
Question.
I have one as well, and then I'll get to you, Rep. Gio. Do we know what is happening to the water that comes off of the belt dryer from the sludge dryer at Crossroads?
Yes. They've also installed a PFAS treatment system for the landfill leachate. And so that material from the dryer, the liquid will be mixed with that and go through the treatment process.
Thank you. That's helpful. Yes, Rep. Gio, you have a question.
So you said there are only two, those are public entities, I assume, those two. Who are they?
I don't know the answer to that. We do have a waste management official here in the room, and I think he would be better to ask about these kinds of questions.
All right, follow up. Forgot my follow-up.
Okay, I
Sucks to
have
get
one
old.
if you
Go
don't. So my follow-up question with that is, it was my understanding that the use of the sludge dryer in Norwich Walk by municipalities would depend on their getting out of or not having contracts with other facilities. Is that your understanding as well?
No.
I would say I think this goes really into the issue of, this is an area where the state shouldn't be meddling. These are private contracts and market forces. So I think the best folks to answer those questions are going to be the sludge generators, as well as the entities like Waste Management or, say, Juniper Ridge Landfill, who can actually take the sludge and find out what they have to say. Because I think coming from us, we're getting some bits and pieces and dribs and drabs of information, but I don't think we have the full picture.
Okay, and we don't have anybody here today from the municipal waste group, wastewater group, MWW.
Maria.
Yeah, yeah. Yes.
So if I could politely just push back on that a little bit. I respect what you're saying about, the private sector in this. But half of that dynamic is public utility entities, municipal wastewater treatment facilities, and they're the ones generating the product or the problem, not their fault. But so it would seem to me that there is a role for the DEP to play in terms of requiring reporting from all of those licensed municipal wastewater treatment facilities around Maine. I still have a little bit of PTSD over where we were a year or two ago with regard to the crisis in dealing with the sludge and its potential adverse impact on our streams and rivers. And so, am I off base or?
So when you say required reporting, I'm not sure I understand what you meant by that.
Well, every municipal solid waste disposal facility, not solid waste, every wastewater treatment plant in Maine is regulated by the DEP and the EPA, is my understanding, right? So the vehicle for gathering data and for actually telling them what to do should, at least in theory, be in place. And if it's not, we can fix that. So I would say we ought to avoid just defaulting or staying away from closer oversight and scrutiny of this piece of the equation than than getting more actively involved in it. We may be the state may be the only entity with the authority to affect a proper outcome here.
I'm going to take a leap of faith on this, that I'm going to answer this correctly. I think you are absolutely correct that we do regulate these facilities. And I think what we do is we regulate like how the sludge is managed once it leaves the facility. Like there has to be a plan for that sludge to go somewhere, and that somewhere has to meet certain requirements. But I think when there are multiple options like landfill, sludge dryer, out of state, I don't think we have the authority per se to dictate which of those a specific generator has to take it to. That I think might be something, I'm not sure if the legislature can do that. I don't know what this isn't my wheelhouse, right? So I don't know, this is all covered by I believe it's covered, is it ours or is it water quality?
NIPD's.
NIPD's, yeah.
NIPD's, Maine.
This is all covered, I believe, by the wastewater licensing process, which is the Bureau of Water Quality, and that's what I'm saying, it's not my wheelhouse. So, but I think that it may be, there may be some further discussion that should happen about that, because I don't know, like I said, I know that we can't tell them you have to go to a landfill versus a sludge dryer versus out of state or whatever, but we do have the authority to say you have to manage this as long as it meets, licensing and state and federal regulations.
Correct. It would have to just go to a legal location, which a landfill, sludge dryer, or out of state to a location out of state, like a landfill.
All right. Seeing no further questions, please proceed. And I just want to remind the committee that as interesting to us and as important as the waste issue is, we do have a lot of work to do today, so questions might hold off a little. Also, before you go ahead, I'm going to ask Representative Woodsum and Representative Riley to introduce themselves.
Representative Dave Woodson, District 139, North Waterboro, Limerick, and Parkersfield.
Representative Riley, representing House District 127, which includes Westbrook.
Did you introduce? Yes. Okay. Thank you. Please proceed.
Okay, I'm going to try to wrap this up pretty quickly. I have just a few more points
That
to
was,
make.
excuse me, more directed to my committee
Okay.
than to you.
I appreciate your time constraints, though. Okay, so other infrastructure. So we talked about the different processing facilities and where we're at with infrastructure and opportunity there. Now moving on to other infrastructure. So you'll see in the little box there, we've got Aries. I think everybody probably on this committee might have heard about this new potential gasification treatment system that we have received an application for, both a solid waste processing application and an air application for, that would be located down in Sanford. That's a facility that would be used to treat PFAS. And so that's an example of new technology and potential infrastructure. There may be other infrastructure we don't know about or technologies we don't know about that also might come to the department in coming months and years. And to that end, I want to point out LD25. This was the biosolids bond that I think was introduced last year. It was a $50 million bond, and the whole purpose of that bond is to help make sure that we're adequately providing opportunities for clean water as it relates to PFAS. And so a big piece of that bond has to do with infrastructure and PFAS, potentially PFAS treatment. And so that I wanted to really mention, because the money that potentially could come from that bond, should the legislature approve it, would benefit new types of infrastructure and technologies as they come to Maine, potentially. And then finally, I talk about this all the time, but the new stewardship program for packaging is going to be coming online soon. We think that by 2027, the municipalities will already we'll see some return on investment for signing up and jumping into the program. And there is the potential for some of that money to result in new infrastructure at the municipal level. And so that might be an opportunity for more investments in new technology and infrastructure. But I do want to just emphasize the point that again, looking at that big pie chart that we talked about, where 68%, 2/3 of our waste is going to 2 different landfills, there is a need for new technology and infrastructure. And I just think it's really important to build that into our redundancies. Okay, 2 more slides. This one I wanted to mention, we did mention at the beginning how it takes a really long time to license these facilities. And I think this is just really important point to make because we're not talking like it might take 6 months. We're talking years. It takes years to license any new facility. And so where we're talking about the fact that we need to expand existing options or create new infrastructure and allow new infrastructure to come into Maine, we have to factor that into what our overall capacity is right now. And, I think the biggest thing that takes a lot of time is there is a lot of public concern. I don't want to in any way negate that there's a reason for public concern. I think there's a whole reason we have the Maine Administrative Procedure Act and an opportunity for the public to talk about what concerns them about new facilities. So I want to make it clear that I'm not in any way speaking against that. But there are a lot of concerns because there's a lot of unknowns with a lot of these new facilities and infrastructure. And so just sort of to set the stage, I want to talk about a bunch of different facilities where because of all the concern, it has taken years to move forward on these facilities. So we've got the Juniper Ridge expansion. We're all aware of what's going on there. The new Aries facility where we've already heard a lot of concern and we just got the applications in like weeks ago. There's a lot of concern about that new facility, requests for public hearings, all of that. There was a lot of opposition to the new anaerobic digester that was talked about going into Brunswick, and Brunswick basically said, nope, we don't want it here. And so that facility is out. The waste management expansion a couple years back, we had to have a public hearing because there was a lot of opposition to that. So I'm not saying that there's anything wrong with that. I think people should absolutely, we should absolutely be implementing our Maine Administrative Procedures Act and hear all the concerns that people have. This is one of those rhetorical questions I wanted to throw at the committee, which is, every one of these types of facilities involves some kind of opposition, which expands by another year or two how long it takes for the license to be completed. And I think as we think about long-term planning and infrastructure, we have to factor those years in. And so that's just something I want the committee to think about as we move forward and think about future options. It's just how long this process takes. I don't know if there's anything that can be done about that, but it is something that needs to be contemplated.
Representative Riley has a question.
Thanks. Does it take years for new licenses in other states? Is it standard? Is there other states that have more streamlined the process and been able to cut down on some of that?
I don't know the answer to that, so I think that's something we'll have to look into.
Okay, thanks.
Yeah.
Thank you. And I have another comment / question. So in the Marine Resources Committee, we've worked hard on issues around permitting as well. And one of the things that we've done is limit the kinds of comments that DMR can take to heart when it holds a public hearing. If that becomes something that would be useful to DEP, where comments that are very clearly based on not in my backyard, it can help us determine whether public opposition is reasonable or not reasonable. Please let us know if that's something we can help you with. Also, is that adjudicatory at any point?
So public hearings are adjudicatory. Public meetings are not. Public hearings, because they're adjudicatory, really take a long time to plan.
Mhm.
I've been a presiding officer for several of these. And it's usually at least a 9-month process just to plan for and conduct a public hearing. And that depends on how many interveners there are and stakeholders involved.
Thank you.
Other delays with regard to licensing, here are some specific things that are called out in the report that are issues that are statutory in nature. So it's not going to fix the overall huge big picture issues that we talked about, but there are steps towards that. And so one of the things that we mentioned here is the public benefit determination language. As you know, that's we are wrestling with this right now related to the Juniper Ridge expansion. We had a court remand required. The department is working on evaluating next steps for that. We don't know what the outcome of that will be, but one of the issues that came out of that court remand is that the language in statute is vague. And that's why everybody's having a hard time understanding what does it mean, what needs to be in this public benefit determination. So that's an opportunity potentially for the committee to maybe provide some support. Financial assurance language, one of the things we've been grappling a lot with both landfills, incinerators, and waste processing facilities is that our language is not aligned with the federal requirements. And it means that we need to have a certain level of expertise within our staff to review really complicated banking and financial documents, to the point where even our attorney generals, assistant attorney generals are struggling with these documents. And it has taken us many, many, many months and a lot of staff time to try to pour through these documents. Other states use the federal requirements. There's guidance out lots of guidance and templates available that all the other states use or most of the other states use. And we would recommend aligning with the federal requirements so we can draw on experience that's already out there. So that's an opportunity, again, for the legislature to make some statutory changes. And then finally, as I think it was Representative Sobolewski that asked before about the commercial landfill moratorium, that's something that, again, is something in terms of licensing to consider if that's something that the committee wants to think about, is opening that door back up. So where does this leave us? What's ahead for Maine? Where are we? I see this as it's a philosophical question. But there's a lot of change that has to happen to get us to this point. Do we want new and expanded infrastructure in Maine? Do we want to clean up our own waste? Or do we want to start looking at outside Maine, shipping it out? Because that's kind of where we're at this moment in time. And we really need to start making some decisions and thinking about what do we want to encourage and what do we want to promote more of in Maine. And so that's the big question that I'm leaving with the committee. And I appreciate you taking the time to listen to us today, and we're happy to help answer any questions you may have. Thank you.
Thank you very much, Director Miller and Director Hopkins. We appreciate the presentation. I think there are still a few questions around the committee. I know Rep. Angeles has one, and I believe Rep. Riley has one as well.
Yeah, so thank you. I have two that I've been saving up. Earlier in the presentation, you talked about the potential increasing competition around the country as more states do sludge application bans or the equivalent. Was that sort of a suggestion that the new dryer that is about to open here, that we may need even more of those? Was that kind of where you were going with that?
I think that's possible. I think the other point that I really wanted to make is that if our sludge generators don't want to take advantage of the new opportunity, there are other states out there that will. And that means we'll be bringing in sludge from out of state to handle in Maine, which is, I don't think, what a lot of folks would like to have. And it also takes away an opportunity for our own generators of sludge in state to take advantage of an opportunity that exists.
Okay, so my second question was just how does any of the report we just went over, or any of this presentation we just went over, how do we know how EPR and the food waste legislation, I think from Senator Renner, might affect some of the timelines that were mentioned in the briefing?
I can say that the food waste ban begins in 2030. So, and we are talking 2 years for Juniper Ridge. So that's 2028.
Okay.
So the food ban won't really necessarily help the situation we're in right now. Carla, do you want to talk about EPR?
I think as far as EPR for packaging, it's too early to tell because we don't know which municipalities will be taking advantage of that program. I think the numbers I've heard are, maybe 30-ish% of the waste stream is packaging. So it has, I think, potential to have an impact on disposal rates. But it's a voluntary program. So we can't require municipalities to take part. And we don't know yet because we're still in the infancy of the program to know who will take advantage.
I would also just throw in there that even if municipalities do sign up in droves and participate, the money is not likely to get to the municipalities till at least 27. And then when you think about licensing new infrastructure, that's probably building out to 29 before you actually have something new and operating in place at least. So again, not going to solve the problem of the immediate capacity situation we're in right now.
Thank you. Rep. Riley, go ahead.
Thank you. So in the 2026 report, if you go to page 29, down there at the bottom, it says municipalities are not required to meet the statewide goal of 50%, but are required to demonstrate reasonable progress in achieving that goal as determined by the department. The law does not provide for any consequences to municipalities that do not demonstrate reasonable progress or fail to report as required. I'm just wondering, could we have like an example of like maybe a report and also what you're looking at for when it comes to reasonable progress? And is that something that the legislature should make any changes there to either incentivize further or require municipalities to share with you these reports?
So I think in recent years, we've seen a lot of municipalities actually stop recycling or stop recycling certain waste streams. And, you know, there's no consequence to that because it's a goal. Obviously, if you're backsliding, that's not demonstrating reasonable progress toward meeting a goal. So I think it could be helpful for this committee to consider doing something to further push municipalities toward meeting the goal.
Do you have like a list of municipalities that are currently complying and not complying?
No, not off the top of my head, but I mean, we could.
And I think I'd be careful, it's not compliance per se, right?
Correct.
It's
Okay.
a goal. And I think that's the issue. Like, if it's compliance, then we have something to measure against. We can, you know,
Right.
typically we would be able to do enforcement.
Okay.
Right.
That's not how things are structured right
That's
now.
correct.
Okay, thank you.
Do you have an enforcement tool for municipalities that are not reasonably making the effort toward the goal?
Well, that's a really difficult question. You know, what is reasonable progress? And that's a tough one for us. And you know, we try to work with municipalities as much as we can to try to get them on track, but
Mhm.
at this point, we haven't, you know, gone full-blown enforcement on municipalities because it's kind of a squishy term.
And I guess also right now we have some issues with the market for recyclables.
Exactly.
Yeah, so I do know we have a question about this. Is this something that you, this is a bill to update financial assurance requirements for certain solid waste facilities. This came from the department, and I assume Mr. Tartikoff created the draft. Is this something you would like us to move forward on now?
It is something that we were recommending for the committee as part of this report out. And that goes along with that. That's the issue I brought up about the financial assurance requirements being aligned with federal requirements.
Right, so this would just change us to being in the federal requirements and not having our own requirements in section 38. Okay, so it's my understanding for this process to take place, at some point, we have to vote this as a committee bill, which will then be referred back to us. Am I correct, Mr. Tartikoff? Yes, so thank you. So I'll ask Mr. Tartikoff to address this briefly. Thank you, Director Miller, Director Hopkins. We appreciate it. Oops, don't trip over all the stuff we've got.
Sorts of tripping hazards.
At least we don't have those chairs that sink when you sit in them. Please go
Yes,
ahead,
so,
Mr. Tartikoff.
You have the yellow bill draft, which came out of the recommendation in Appendix B of the report. which is on page 41. The chairs had directed me in advance of today to work with DEP to write up a formal bill draft. It is getting later in the session, but the intent here, as I understand it, would be to report this out, have it printed and referred back to the committee for a hearing and a vote before the session ends. It's a little late, but I do think that's feasible. If that vote were to happen today, if it were to happen next week, I don't know. It's a good time processing wise right now because AFA hasn't started voting the budget sections. So there's a little bit more leeway, although committee amendments are starting to be in processing. So that is, I think, what the chair's intent was for today. I can answer any questions about the bill, but I think it was summed up pretty well by department staff.
Thank you. Rep. Riggio and then Rep. Anglese.
Maybe this is better directed to the commissioner, but this appears to me to be an opportunity to address the staffing pressures on DEP. If what I heard from Director Miller
Or Hopkins.
one of them, indicated that a considerable amount of staff time ends up being devoted to our unique set of financial surety requirements as opposed to what apparently a number of other states can deal with. So I, for one, would be in favor of moving forward with this.
Is that a motion?
It is.
Okay, all right. So second from Rep. Anglese, a motion is second. I want to be very clear that I do not yet fully understand the issues that are contained in accepting this bill. That I don't know if there's a reason for our states, for the current situation, and the complications in the financial assurance. So in voting to move this forward as a committee bill, I assume and hope that those issues will come out as we have a public hearing. So this is just a vote to move this forward to become a bill. And are there any other comments or questions before we take the vote? Yes, Rep. Riggio.
Just a request to the department, when we do get to the point of a public hearing on this, to be able to identify which states are unique and which states follow the federal. I mean, if we're one and there's 49 others going the other way, then that's one thing, but you know what I'm saying?
Yes, I think that, yes, Commissioner is nodding her head, so I think that makes sense. Any other comments or questions before we move to a vote? Okay, is this just a hands, show of hands? Okay, show of hands for those who would like to move this forward as a committee bill. Unanimous of those present and voting. Thank you. And with that, this is another bill that will come back to us. Assuming that it's allowed to move forward by Ledge Council. No Ledge Council. Okay, never mind. Yes, Rep. Sobolewski.
Thank you, Senator. Before we move forward, I'd like to have just a brief statement here. When we stopped land application of sludge, shortly afterwards, a bill was passed to stop bringing OBW into the state. We had 31 facilities, municipalities that were contracted with Juniper Ridge. We didn't have any bulking material, so they had to stop taking their sludge to Juniper Ridge. We were in serious trouble. We ended up trying to find a way to deal with it, and that was to take it to Hawkridge, load it on trucks, take it to Canada. The municipalities, and to Senator Martin's question, Bangor alone went from $240,000 a year to $600,000. And when we got it up to Canada, even though they agreed to take it, they were not happy. And there was tremendous pressure for taking it out of state. So it's a very touchy, complicated situation in dealing with sludge. And I just wanted to throw that out there, that it's caused some serious problems in the past. We should tread carefully with it.
So
Thank
are you referring to this last slide where we as a committee will have to be discussing whether we're going to be handling our own sludge and or waste through new and expanded infrastructure or sending it out away?
It answered the senator's question, what would it cost and what would the
Oh,
expenses be? And
okay.
additionally, as soon as waste management is up and running, I think that's going to tell us a tremendous amount of what our capacity will be. Those contracts from JRL will start moving over there one at a time as they expire. It'll start taking pressure off in our state landfill. And I think that's going to be huge once waste management gets going.
Mhm. Well, and I do think that the question that Director Miller posed is a policy question and not a philosophy question. So it will come down to us
Yeah.
eventually in some way or another.
All right, thank you.
Okay, so with that, Mr. Kardikoff, was there something you wanted to take on right now? Or are we moving into public hearing?
Well, we're running a little behind schedule, but since I don't think there'll be another opportunity today, can I pass out a quick language review?
Yes. Representative Riccio, I don't think that's your job. Yes, you may.
So I'll just hand this out, very briefly touch on it. And then if you'd like to have a further discussion about this when we meet next week, I won't end up reporting it out. But if I don't hear any concerns, I'll move forward with that process.
Great. And
Um,
reporting more out is helpful to me in terms of the pressure I
Yeah,
get from
yes.
leadership.
We're all
Thank you.
starting to hear that pressure. This is an act to establish the Municipal Shoreline Protection Legal Fund. This was a bill from Senator Nangle. It was voted majority ought to pass as amended. A minority ought not to pass. The vote sheet is at the very end of the packet. The language is something that you've already seen in substantial parts. So the focus here is the fiscal piece. If you recall, this established a new fund to be overseen by DEP to provide financial assistance to municipalities that have incurred or expect to incur legal costs in pursuing shoreline zoning violations. There was a $100,000 one-time general fund transfer intended to capitalize the fund, and then some other discussions that led to the language there. If you recall, DEP had suggested that regardless of the capitalization of the fund, they would require one staff person to administer the fund. That is included in the appropriation section that's on the second page of the packet, funding for that one new DEP position. You will recall that the majority report intends to transfer some portion of fees collected under the Natural Resource Protection Act, penalties collected under the Natural Resource Protection Act. The fiscal note indicates that those penalty amounts are variable, and so the staffing needs can't predictably be met by those penalty amounts, and the $100,000 is a one-time transfer, and so that's what the additional staffing costs are incorporated for. You will also note that because those penalty amounts have been deposited into the general fund, the fiscal note for the majority report also includes a general fund biennium revenue decrease. So there's a revenue loss to the general fund in here as well. For these reasons, it can be expected that the bill would be placed on the special appropriations table prior to enactment following votes in the House and Senate if it were to be approved by both chambers. So again, wanted to get this out to you. I can answer any questions now, but I'm also happy to defer discussion on this to next week if anyone has any concerns about it.
Any questions or comments about this from anyone on the committee? Nope, seeing none. Thank you very much, Mr. Todikoff. Please go ahead and report out. Okay, yep, okay, the committee has a 2 to 3 minute break. Quick restroom trips or refills on water or something are possible. But nothing else, please come right back because we're gonna start our public hearings. And I also want to say to those present that I will be running a 3-minute clock for anyone testifying other than the department or legislators. The meeting will please come to order. Thank you. And always our 3-minute breaks end up being a few more than that. But we are at a point now where we're going to hold the public hearing on LD 2210, an act to clarify Board of Environmental Protection procedures regarding appeals of licensing or permitting decisions of the Commissioner of Environmental Protection. This is essentially a bill from the from the Board of Environmental Protection. So we're going to invite the executive director of the board up to present the bill.
We can't have the chair do that?
I do the next one. Sorry, Dick, you only get to run one meeting.
Good morning, Senator Tepler and members of the committee. If you'll reach back in time a few weeks, I think you'll remember I was up here presenting the Board of Environmental Protection's government evaluation report. Sorry, my name is Bill Hinkle. I'm the executive analyst for the Board of Environmental Protection. Sort of a spinoff of that GEA report was a department suggestion about some changes that could be made to statute with regard to the board's appeal process. Representative Dudera introduced a bill, and so my testimony today in this hearing today is regarding that bill, LD 2210. So with that, I think I'll provide my testimony now. Yep. Okay. So again, my name is Bill Hinkle. I'm the executive analyst of the Board of Environmental Protection, and I'm here today speaking in support of LD 2210 on behalf of the department. LD 2210 would amend the statute that governs board appeals of licensing decisions made by the DEP commissioner. Because the bill clarifies key points, increases the efficiency of appeal processes, better aligns the board's administrative appeal procedures with judicial procedures, and promotes the submission of information about proposed projects during the review of license applications, the department supports LD 2210. The bill clarifies who is permitted to submit proposed supplemental evidence to the board. Typically, the board makes its decisions on appeal based on the same record of information that was available to and considered by the DEP commissioner before the license decision was made. However, the statute allows the board to consider supplemental evidence that was not considered by the commissioner, provided that that supplemental evidence is relevant and material to the appeal and was presented to the department at the earliest time possible. The department interprets the current statute to allow persons who are neither the licensee nor the appellant, including people who would not have standing to appeal the license decision, to offer supplemental evidence during an appeal proceeding. Anytime a person offers proposed supplemental evidence, it slows the appeal process. As currently structured, this provision could be abused to intentionally delay a board decision on appeal, which is wasteful of department resources and reduces regulatory certainty for licensees. Furthermore, allowing a person to submit proposed supplemental evidence to the department during an appeal proceeding discourages participation in the licensing process while the application is pending before the commissioner. LD 2210 clarifies that the appellant and the licensee may submit proposed supplemental evidence. If the legislature is satisfied with the current structure, which may result in licensees having to potentially wait well over a year for their license to be upheld on appeal, no changes to this aspect of the statute are necessary. However, if the intention is to make the overall permitting process faster and allow licensees to proceed with major investments after they've obtained their license, the legislature should make the changes that are proposed in LD 2210. Additionally, the bill defines the record on appeal that the board considers when deciding appeals. The department's existing Chapter 2 rule defines the record on appeal. However, adding this detail in statute would add clarity, especially considering that the existing statute provides for consideration of supplemental evidence. The bill also adds a provision that each appellant must include all information required to be submitted to the board when an appeal is filed. Well, that seems straightforward. It doesn't always happen. Again, although a statutory change is not required for the board to continue its current practices under Chapter 2 regarding the filing of appeals, the proposed amendment would highlight this important requirement and strengthen the board's authority to dismiss an appeal that fails to provide the minimum amount of required information. LD 22 would add language to incorporate the board's long-held practice to allow the licensee to submit a written response to the merits of the appeal. Although a statutory change is not required for the board to continue that practice under Chapter 2, clarifying this in statute adds clarity regarding this due process right of the licensees and strengthens this aspect of the Chapter 2 rule. The department suggests additional language changes for consistency and clarity regarding references in the statute to the record on appeal. I have circulated to the committee a markup of LD 22 with those additional proposed changes shown in double strike through, double underline, and yellow highlighting. Those proposed changes do not alter or substantively change the intent of the bill. In conclusion, LD 22 would result in important and helpful clarifications regarding the board's appeal procedure, incorporate practices of the board that are outlined in the DEP's Chapter 2 rule, encourage early participation in DEP licensing proceedings, and ensure due process and improve regulatory certainty for appellants and licensees. Thank you for the opportunity to provide testimony, and I'm available to answer questions of the committee now or later at work session.
Questions for Executive Director Hinkle from the committee? Seeing none, thank you very much for your testimony. And you are the representative of the department then, so no one else from the department will be testifying?
So Mr. Duchesne, Board Chair Duchesne is here.
Okay.
So at your pleasure.
Okay. Only about birds. Okay, welcome, Honorable Mr. Duchesne.
Thank you. Nice to be here. Thank you, Senator Tepler, members of the committee. My name is Bob Duchesne. I am from Hudson. I am currently board chair, although I'm not really testifying in that capacity, so I'm actually neither for nor against. I know, right? But my reasoning is I'm on the board. I don't tell you what to do, you tell me what to do. And I just follow your directions. So if you want to keep it the way it is, fine. I'm going to tell you why maybe you don't want to, and you can take that as you please. But I do have some history with this, and I certainly have some hands-on experience with it currently. So let me just say what the history of this is. It's always been this attempt to have a balance between the people's right to challenge a permit that may endanger human health or environment, and the balance is then balanced against the applicant's right to get some kind of decision in an exponential, in a relatively quick manner, so they can go ahead with their project, or if the answer is no, to stop worrying about their project and move on with their lives. There's always been this balance between public input and the right to something that is relatively quick to make a determination, and that's not easy to do because they are polar opposites. So the legislature has tweaked this law many times over the years, trying to get that balance just right. And what it has settled on is when the application is submitted, just about anybody can comment. Anybody can comment. If it's adjudicatory and requires a hearing, some people can look to establish themselves and prove to themselves they can be interveners. And when you're an intervener, you get to present witnesses, sworn witnesses. They can be cross-examined by the other side. You can cross-examine their witnesses. So all this public process goes into determining the fate of the permit. And just about everybody can play in one way or another. But once all this process happens, the case has been made, the department reaches its decision and issues a permit, often with conditions that were inspired by the opposition in the first place. Once that happens, and the permit is then validated and issued by the department, who gets to appeal And what the legislature has decided in the past is you can't go in and re-argue everything you just lost on. Only the people who are aggrieved persons, who are personally affected by this permit, would have the ability to appeal. And that has been, a point of discussion for this committee and for policymakers in general for a while, because appeals slow down the process even further. There is at one time where Governor LePage wanted to get rid of the board altogether and replace it with a tribunal of 3 judges, a 3-judge panel. But that had some real serious problems with it, and that was unanimously rejected by both sides. That was a nonpartisan rejection to that idea because it has certain complications. So he wanted to tweak it. Senator Saviello in the 125th legislature wanted to make sure that only people who were aggrieved persons, who were personally affected by a decision, would have the right to appeal. That went through in law. It has since been upheld by at least 2 judicial decisions I'm aware of. Last session, I think, or last year, Senator Rick Bennett wanted a bill in that you actually ultimately passed with some substantial changes to clarify the process. And his goal was to make sure there was enough public input in the appeal process, but also that the decision be made faster. So on one hand, you want to slow it down. The other hand, you want to speed it up. What you eventually did was clarify, but what that also included in it was this idea that interested persons could contribute supplemental evidence during the appeal. Who is an interested person? Somebody who previously showed interest and can document that they had commented or something. So it turns out it kind of created a bit of a loophole, and the consequences are happening right now. I've got a case on my desk right now where the department made their decision in one day. It was just a permit by rule, but some of the abutters didn't like it. It's been appealed. The appellant and the licensee submitted their comments relatively early, but then a letter comes in from an interested person. Now both sides have time in order to comment on that, and the process that took one day for the department to approve is going to drag out for months. So that's the loophole, if you want to call it a loophole, that was created with that bill and that the department is looking to clean up now. Because I don't think you want to slow down this process. That's not been your intention in the past. I suspect it is something you would like to clean up. So, there's the difference between an aggrieved person and an interested person. And I think that has to be established in statute because that's where it currently rides.
Okay, thank you very much, Mr. Shane, for your testimony. Are there questions from the committee relevant to the bill for Mr. DeShane?
I know. I do have to apologize to Representative Campbell. I had loaded a bunch of his stolen notepads in my car to return to him today, but it started snowing. I brought the other car.
I wonder if Denise Harlow went to her grave with some of mine. Okay, yes, okay, Representative Campbell.
Yeah, just a
I
really
did.
important question. Where can I get a sweater like that?
I know. I was just thinking, did we get the same shopping done for Christmas? Thank you.
Thank you very much. Okay, with that, I will turn to proponents of the bill. And again, we're running the 3-minute clock. So is there anyone in the room who'd like to speak in favor of LD 2210? Yes, please. Yes, and before you begin, sir, or while you're signing in, I'm going to have Representative Dudera, my co-chair, introduce herself.
Hi, everybody. Nice to be here. Sorry I'm late today. I have a little bit of laryngitis going on. I'm Vicky Dudera, represent House District 41, Camden and Rockport.
You do.
I'm just letting her pass it out for a second before you start the clock. You want me to start? Okay. Thank you. My name is Jeff Thaler. I'm from the town of Yarmouth, represented by Representative Bell. Here today, not representing any client or others. I've been involved in BEP hearings and processes for decades. If any of you remember who Yogi Berra was, he had a saying called deja vu all over again. So I do feel like there's a lot of history repeating itself. Just as an aside, I was involved in all the landfill and MSW fights in the 80s, 90s, and the legislation you just talked about for an hour. So it's a little ironic that I happen to be here today for that. But bottom line is, I'm here to testify in support of the bill. As indicated in the testimony, I just have two discrete suggested corrections that I think were omissions for consistency's sake. But I've been representing a wide range of clients and groups since the early 80s, and from Audubon to private parties to municipalities to Washington County, among others. More recently, University of Maine, where I was in-house counsel. I've taught statutory interpretation and administrative law to Maine law students and others. So I'm here because also I'm on the committee for the Maine Supreme Court, updating the rules about appeals of agency and municipal decisions. So this issue that was just being talked about is actually relevant for judges as well, as to who gets to participate and when, and what kind of record goes up on appeal to the judges from the DEP or the BEP. So the suggested edits, again, I'm in support of the bill overall, are just outlined in the bottom half of my one pager to you. There's language in here that if the licensee or permittee is not the appellant, may submit a written response. Now that may seem logical and make sense. It's actually not in the rule currently or in the statute. And so that's where if their permit is challenged, but they're not directly a party, then they don't get to say something, which seems a little crazy. So bottom line is there's language that was inserted in section 4A that addresses that, but it didn't get carried over to two other parts of the LD. So the suggestion is to have it at line 2 on page 2. And then also I said in the 8th line or so in section 4D, that's actually line 22 of the LD. And for internal consistency, just so it's not missed. And with that, I'm happy to answer any questions, or otherwise, I will not be at the work session on this bill, but I will be here this afternoon on another hearing. Thank you. And I got under 3 minutes.
Yes, you did, Mr. Thaler. Thank you very much. Excuse me, I may sneeze. My question for you is, have you spoken to Executive Director Hinkle about these concerns?
No, I had not had a chance to do that. Hopefully they'll find it acceptable, because it's really, he's nodding his head. It's just to fill gaps for consistency, not substantive change.
Okay, well, thank you. That's what I wanted to know. Is there anyone else on the committee who has a question for Mr. Thaler? Seeing none, thank you for your testimony.
Thank you. Thank you for your time.
And I don't have anyone online in regards to this bill. Is there anyone else in the room interested in testifying in favor of this bill? No, okay. With no one else in favor, I will turn to those. You're in favor. Oh, okay. I will turn to all those who are opposed to this bill. Is there anyone opposed to 2210 in the room? Seeing none, I would call for those who are neither for nor against this bill. Welcome, Mr. Frankel.
Thank you.
Good morning, Senator Tipler, Representative Dudera, and members of the ENR committee. My name is Luke Frankel, and I'm the staff scientist at the Natural Resources Council of Maine, or NRCM, and I'm here today to testify neither for nor against LD 2210. As an environmental advocacy organization with nearly 20,000 members and supporters statewide and beyond, public involvement in legal, legislative, and regulatory processes is critical to our work. Well, we recognize, however, that the infrastructure to support this public involvement is not free and does come with a cost. In this case, when it comes to issues like rulemaking, appeals, and other proceedings before the Board of Environmental Protection, this cost comes in the form of DEP staff time. We greatly appreciate the work that DEP staff do to ensure that there is a transparent public process for proceedings before the BEP, and believe that the current process sets a high standard that other governmental bodies should look to. We do agree that there are likely ways that this process could be streamlined to save time without sacrificing public input. One example of this, which is included within this bill, is prohibiting interested persons from submitting supplemental evidence into the record as part of the BEP appeal process, which we do not oppose. DEP staff has stated that sifting through vast amounts of supplemental evidence submitted by people who are not direct parties to an appeal has cost them significant staff time through the years. These entities would still be entitled to submit information into the record during any public comment periods prior to a final license or permit decision. We would, however, like to propose a few amendments to the bill that would clarify current practices around interested persons during appeals to the BEP under DEP's Chapter 2 rules. These include the following additions highlighted in gray. So in lines 21 to 23, it currently reads, for the purposes of this paragraph, interested person means any person that submitted written comments on the application that is subject of the appeal. I also am recommending that language be added, or who request in writing receipt of materials related to a particular application that is subject of the appeal. And it is our understanding that's kind of the current practice under the rules. And then another addition that I'm proposing is in lines 39 and 41 of the bill. It reads, the license or permittee, if the license or permittee is not the appellant, and I'm proposing to add the language, and any interested persons may submit to the board a written response on the merits of the appeal. So currently, the licensee can submit a written response, and so it is our belief that interested persons who also commented on the appeal should be able to write to the merits of the appeal when that process moves forward. And so we believe that these practices should continue to allow interested persons to remain engaged in a license or permit proceeding before the BEP. We encourage the committee to clarify this by adding the language recommended above or something similar. And I'd like to thank you for your time and consideration. I'd be happy to answer any questions.
Thank you, Mr. Frankel. I have a question for you, which is the same one I asked the last person who testified. Have you spoken to Executive Director Hinkle about this concern yet?
We have not.
Okay, so I guess I would ask that before we get to work session, you do have that conversation.
Okay, great. Yeah, will do.
Thank you. Okay, any other comments or concerns for Mr. Frankel? Nope. Thank you very much for your testimony.
Thank you.
All right. With that, is there anyone else present in the room who would like to comment neither for nor against, who would like to testify neither for nor against the bill? Seeing none, I'll bring the public hearing on 2210 to a close. And with that, I will ask my co-chair to open a hearing on LD 474.
Okay, we'll be starting the hearing on 474, and we have Chair Tepler to introduce that bill.
Thank you very much, Representative Dudera and distinguished fellow members of the Committee on Environment and Natural Resources. I am Senator Denise Tepler, representing all of the 10 towns of Saginaw County and the town of Dresden in Lincoln County. I am here today to present to you an amendment to LD 474, which now has the title, An Act to Establish a Stewardship Program for Primary and Rechargeable Batteries. This bill began its life last session when Senator Bennett presented us with a bill to ban single-use vapes and create a study to establish an extended producer responsibility program for all types of batteries, including those embedded in the vape pens. As Senator Bennett worked with the Department of Environmental Protection on the bill, it became clear that creating such a bill would take time, and a study was not needed as DEP was ready to take on the project. We carried over Senator Bennett's bill, But the department was not quite ready with their version of battery stewardship until after our deadline for carryover bills. Thus, we agreed not to pass LD 754, Senator Bennett's bill, and we transferred the department's bill for battery stewardship to my placeholder concept draft. As we try to both limit the amount of waste we are landfilling and prevent the fires that can result from certain types of batteries in our waste stream, this bill contributes a significant solution to both those problems. Battery producers will not be able to sell their products in Maine if they refuse to participate in some form of stewardship. The bill allows for a number of ways to fulfill this responsibility by the manufacturers. They can hire an existing stewardship organization. They can join with other manufacturers to create a joint stewardship program, or they can go it alone. Whichever route they choose, the DEP must approve that plan. The program begins with stewardship of standalone portable or medium format batteries, but by 2030 should cover embedded batteries as well. The bill defines the number of battery collection points and that each plan must have a method of collection, transportation, and environmentally sound waste processing. In fact, the words environmentally sound are not found in the bill, so I think that perhaps that's something this committee might want to add on the processing side. This battery stewardship program developed by DEP is quite complex, and questions regarding its various components would be best addressed by those who follow me, the experts. I hope you will see the value in this program in meeting our waste reduction goals and appreciate that the department is now ready to take on this additional work to keep our Maine lands and waters clean and safe. Thank you for your time and consideration of this bill.
And thank you very much. Do you want to hang out just a minute and see if anyone has any questions? Does anyone have any questions?
Looking
of
at
the Senator?
you. Yes, you can get this blouse.
Okay. Yeah, it looks like we don't have any serious questions for you. So
Okay,
thank you very
thank you.
much. Would the department like to come up now and offer their testimony? One, that was hysterical.
Sorry,
That's
I had to
pretty.
tweak it.
I actually do want that blouse. It's very pretty.
Thread up. I mean, what can I tell you? It's a used blouse.
Can't have the shade sweater.
Oh, your sweater's LL Bean, I think, isn't it? Yeah.
All right. All right. Thank you. Senator Tepler, Representative Dudera, and members of the committee. My name is Brian Beneski, and I am the Supervisor of Recycling Programs at the Department of Environmental Protection, speaking in support of Senator Tepler's amendment to LD 474. The department supports a legislative update to the current rechargeable battery program laws, regulation of certain dry cell batteries set by 38 MRS Section 2165. 38 MRS Section 2165 requires manufacturers of nickel cadmium and small sealed lead acid batteries to provide a system for recycling their batteries. The law has not been updated since it was enacted in 1991. Only batteries with a nickel cadmium chemistry are a covered product in Maine's current rechargeable battery program. Other modern battery chemistries, such as lithium ion and primary batteries, are also known as single-use batteries, are not included in Maine's program as they are in other U.S. jurisdictions. As discussed in the department's 2026 Annual Product Stewardship Report, the absence of a proper collection, transportation, and recycling system for modern batteries has led to safety issues within Maine's waste stream operations. In 2024, the National Waste and Recycling Association estimated that more than 5,000 fires occur each year at U.S. recycling facilities, many of which can be linked to improperly discarded lithium-ion batteries.
Fires at U.S. and Canadian material recycling facilities and transfer stations are up at their highest recorded level, with the rate of catastrophic losses up 41% over the last 5 years. That increased risk has also driven up insurance costs for waste and recycling facilities from less than 20 cents per $100 of insured property value to as much as $10 per $100 of insured value. Here locally in Maine, EcoMaine has reported 12 fires traceable to lithium-ion batteries, and Casella has reported 12 fires due to these batteries since June of 2023. And these are semi-old figures that were reported in the product stewardship, so you may hear updated figures today. Many of these fires were due to smaller lithium-ion batteries found in power tools, cell phone chargers, and e-cigarette vaping devices. In addition to the fire hazards created when batteries are placed in the waste stream, improper disposal of batteries ensure the loss of the critical minerals within them. In 2025, as part of an evaluation of Maine's current battery recycling law, the department hosted 2 public meetings to allow for input from interested parties and the general public. The department received many comments during and after both public meetings, and department staff performed an extensive review of these comments, along with existing battery legislation recently passed in other jurisdictions, to determine the most feasible and cost-effective pathway for expanding Maine's battery recycling law. From this effort, the department developed draft conceptual language, which was presented in the 2026 Annual Product Stewardship Report. During the public comment period to the report, the department received additional comments which are attached to that report. The conceptual language and additional comments during the public posting of the report provided the foundation of the proposed amendment to LD 474. In summary, the bill requires producers of both primary and rechargeable batteries of up to a specified size and rating to participate in a battery stewardship program and submit a stewardship plan outlining their program to the department for approval. The bill also requires producers of products with embedded batteries to report their sales of these products to a stewardship organization starting in 2027, with the requirement for the collection of embedded batteries to start in 2030. The bill outlines the minimum requirements the battery stewardship plan must address, including a minimum standard for collection location convenience for the battery stewardship organizations to meet. It also requires the stewardship plans to be publicly posted for comment prior to department approval. The battery stewardship programs must be free of charge for consumers who are dropping off batteries and free for the collection locations to participate. It should be noted that covered batteries does not include large format batteries such as those used for electric automobiles and large-scale home or solar storage, or batteries within a medical device that is not principally designed for consumer use. Thank you for the opportunity to testify before you today. I would be happy to answer any questions from the committee, both now and at the work session.
Thank you very much, Mr. Berneski. We have questions for him? Yes, Rep. Brigio.
Good morning.
Good morning.
So what are other states, to your knowledge, doing in this regard?
So a lot of them are updating their laws to similar, to the similar style of programs and similar changes of chemistries.
Any idea how many states we're talking about?
I think we're talking around to about 10 to a dozen, but I could get a more specific list for the work session.
Thank you.
Yeah.
Do we have any other questions? Yes, Rep. Osh.
So the fires that we mentioned, are those for the embedded batteries?
They are from various products with batteries and batteries themselves.
Is there may I continue? Is there an attempt to reduce the amount of products that have embedded batteries to facilitate recycling of batteries in this?
This is to begin the collection of, I'll call them loose batteries, with a ramp up for embedded batteries. And what could happen though is as producers realize they have to deal with embedded batteries, then they may shift to more removable products with more removable batteries.
Do we have another question? Any other questions? Thank you so much.
Thank you.
Great. Now we will move to anybody here in the room who is in favor of this bill and would like to come forward and testify. So come right up so we can keep it moving.
But didn't jump in front of anyone. Good morning, Senator Templer and Representative Dudera and esteemed members of the committee. I'm Victor Horton, Executive Director of Maine Resource Recovery. I've been with the organization since 1997, so probably not the oldest one in the room. The Maine Resource Recovery Association supports this bill. We've spoken to many of our members and interested parties. They're probably handing out the letter now that we generated for our members. We had about 26 sign-ons so far. Also, we're just unanimous in support. This bill needs to pass. So these 26 individuals, this was a staggering number with just having a short notice to get this out. With the Snowmageddon forecast, which shut down the state Monday, most of those came in before the weekend. Pretty confident if we had more time, we would have been able to add to that list. So we're happy with the inclusion of the new battery chemistries in the Maine battery stewardship proposal in the bill. We also hope that any interested entities can participate in the collection of the batteries. It seems that sections 7C and D with regards to medium format and damaged and defective batteries does exclude participants if they're not household hazardous waste handlers. Adding lithium-ion rechargeable batteries and primary batteries, now with the embedded batteries later on, is a great leap forward. Having the financial responsibility of managing the material at the end of life stay with the producers. It'll keep far in keeping the program reasonably priced and should garner participation. Public education is a must. We hope that's in the forefront of the program. If people don't know you're doing it, they're just going to keep throwing them away. So we want to make sure we reach as many people as we can. Drop-off sites being conveniently located will also ensure participation from the consumers. So we appreciate the opportunity to provide the feedback on this battery stewardship bill. To make these programs more effective, we recommend the following. We support the proposed modernization of the stewardship bill, inclusion of those additional chemistries, ensuring full participation from battery manufacturers is great. Establishing central accumulation facilities for the damaged and defective batteries, providing proper collection bins and training, there's that word again, training, to collection sites for safe and convenient disposal across the state. We require coordination between one or more stewardship organizations to facilitate the collection for municipalities and consumers also seems like a must. And that's all I have. And I made it.
Yes, you did. Thank you, Mr. Horton.
Thank you.
Very interesting. Do we have any questions for him? Yes, Rep. Campbell.
Thank you, Representative. On your second point, establish central accumulation facilities. Is this to be combined or separate?
It would probably be separate. It's mostly for those bigger batteries than the damaged ones. Just for example, someone from Millinocket probably won't be able to make the trip to Lewiston to take one of those damaged batteries to the household hazardous waste site. So we need to have a little bit more leeway to have folks not have to drive so far. That's what I was trying to get at.
Thank you.
Any other questions for Mr. Horton? Okay, seeing none. Thank you so much
Thank you.
for being up here. You didn't have a question. No.
No, I can't anyway.
Oh, okay. All right.
Dave. Bill's got to buy his coat.
Good morning, Senator Teplar and Representative Dudera, and to the committee. My name is Michael Carroll. I'm the Executive Director for Municipal Waste Hub. We represent 115 Maine municipalities for the municipal solid waste. This bill addresses critical safety issues, and we're for the bill. This bill addresses critical safety issues affecting our 115 Waste Hub member municipalities across Maine. Pneumatic batteries pose a serious hazard to the municipal solid waste stream. Whether during collection or processing, these batteries can crack or be crushed on our tip floors or in our collection trucks. Creates a significant health risk to the communities, waste workers, and first responders. As the bill moves forward, I respectively offer the following considerations for the committee. Collection procedures. As collection procedure volumes increase, there is real risk that batteries will be tossed into bins and rather than handled with care. When we buy these batteries now, they are carefully packaged for the sale. We recommend that you really look at the procedures in that these batteries are have some kind of containers for collection, and similar to how we collect hazardous waste or e-waste in separate rooms. Reporting requirements. Some of the bill's current reporting requirements are very ambitious. A tiered approach that scales over time as collection patterns and material volumes become better understood may be more practical at first. Third-party seller coverage. I want to flag a potential gap in the bill's language. If I understand it correctly, the bill addresses producers participating in the battery stewardship program, but is unclear whether the coverage extends to products brought in to the state by third party, such as vendors at concerts, fairs, and festivals. Thank you for the opportunity to support LD 474. Municipal Waste Hub looks forward to working with the committee as an important legislation moves forward.
Thank you so much, Mr. Carroll. Thank
Thank
you.
you.
Do we have any questions for this gentleman? It looks like we do not. Thank you very much
Thank
for
you.
being here. Anyone else here who wishes to speak in favor?
Want me to sign your name? Good morning, Senator Tepler, Representative Dudera, and distinguished members of the Committee on the Environment and Natural Resources. My name is Mark Draper, and I am the Solid Waste Director for Aroostook Waste Solutions. And I will note that my testimony might be a tad over 3 minutes, but I'm making an 8-hour round trip to get here today, so I hope you will indulge that fact. AWS is a not-for-profit corporation owned by the municipalities of Fort Fairfield, Limestone, Caribou, and Presque Isle. We own and operate the Tri-Community Landfill in Fort Fairfield. We operate a transfer station in Presque Isle. We own a closed landfill in Presque Isle, and we operate a drop-off recycling program serving 14 communities in central Aroostook County. Tri-Community Landfill currently provides disposal capacity for more than 70% of the county's population. As I noted, I made the long trip to Augusta this morning to enthusiastically support the proposed bill. In recent years, we have experienced numerous fires at the landfill caused by batteries in the waste stream. In 2025 alone, we experienced 11 fires, 9 of which were positively identified as being caused by a battery, and those were lithium-ion batteries to be specific. Those 9 were relatively small fires. They were caught early and extinguished by AWS personnel. However, 2 of those fires required response from the local fire departments, and 1 of those required a multi-day response over a weekend, of course, to extinguish. As you might expect, landfill fires are quite unpleasant. They are unhealthy, they are difficult to extinguish, and they're expensive for local communities to respond to. That is why I'm excited about the proposed bill. With batteries becoming an ever-increasing part of our society, this bill places a responsibility of creating an alternative system to collect and manage them at the end of their useful life on the producers who put them on the market. This is very much in line with other previous product stewardship programs in Maine. And as with those previous efforts, the program must be free and exceptionally convenient for the general public to participate. So it is with that intent that I make the following suggestions. While the bill includes a specific convenience standard of at least 1 permanent collection site within 15 miles of 95% of Maine's population. For covered batteries that are portable batteries, no such standard exists for, no such standard is prescribed for damaged, defective, or medium-duty batteries. I respectfully suggest that the specified convenience standard should apply to all covered batteries. Similarly, sections of the bill include language that damaged, defective, and/or medium-duty batteries can only be accepted at locations that meet, quote, state requirements for the management of household hazardous waste, unquote. Frankly, I'm not sure what those standards are, but I respectfully request that this language be removed and replaced with a requirement that the stewardship organization provide adequate training and collection containers for any collection location that is willing to accept them. In any event, to maximize convenience and participation for the general public, we should remove as many barriers as possible that potentially dissuade or exclude drop-off options. And I'll close in this. It's pretty rare that everyone in the solid waste industry agrees. Usually we have bills that will either be detrimental to one entity or the other, or one organization or the other, or one type of management or the other. But in this case, everyone I talk to in this industry is having issues with these batteries. And as others have mentioned, that includes haulers, recycling facilities, landfills, incinerators, so on and so forth. So happy to provide this testimony. Appreciate the indulgence of going over the 3-minute limit, and I'd be happy to answer any questions that you may have.
Thank you, Mr. Draper. Have a question for this gentleman? Came all the way from Aroostook County. Come on. Oh, here they come. Okay. I saw Representative Virgil Burgess first.
Well, I agree that you guys all agree on this, but how do we make people do this?
So, yeah, so I hear from my staff all the time, well, just tell people not to throw them in the trash. Well, the problem with that is we don't have really a good alternative to tell people. You can tell people to not throw them in the trash, but unless you have again, free and extremely convenient option, say, okay, don't put it in the trash, take them here. You really can't tell them not to do that. That's what this program provides. I think it provides the option that people will need that we can put forth that people can then take advantage of. And then, as I think Mr. Horton mentioned, education, and others have mentioned education, there needs to be, and I think there is in the bill, significant incentive to educate folks and let them know that this is the alternative. This is what we would prefer you to do with these units instead of throwing them in the trash. So I'm hoping that voluntary compliance will certainly be helpful. Yeah.
This puts me in mind of the lobby of the Augusta Police Department. You can go and drop off on a secure box any medications that you that you don't want to use. Presumably something convenient like that could occur. Having grown up on the banks of the Aroostook River, I suspect that there's plenty of brain power still left in the Care Board.
Oh, there is.
to
Yeah,
handle
absolutely. Yeah.
challenge.
Yeah. Yeah.
Okay, well, I don't see
A
any
little
more.
less while I'm down here.
Oh, there you go.
So-
Well, we thank you for your thoughtful testimony and your
Thank you.
suggestions. Drive safe, drive safe. Anyone else who wishes to speak in favor? Okay.
Thank you. Senator Tepler, Representative Dudera, members of the committee, thank you for the opportunity to speak here today. My name is Lucy Sullivan. I'm with EcoMaine. We serve nearly 500,000 Mainers with recycling, waste energy, and landfill services, and I'm here to speak in support of LD 474. So lithium-ion battery fires, as you've heard, are an increasingly frequent threat to our ability to operate safely. We had 26 reported lithium-ion battery fires in 2025. That was up 50% from over the prior year. In fact, while I was drafting this testimony, I learned of the fire that you'll see on page 2 of your materials was actually actively being suppressed by a member of our recycling team. It is a persistent threat. And that threat is expensive for Mainers. We're a quasi-municipal nonprofit. We're co-owned by our member municipalities. We've invested at this point $1 million in fire suppression systems in our current facilities. We're investing $1 million in fire suppression at our emerging facility that we're building, our new recycling facility. But those are far from the only costs. Rising insurance costs, lost revenue from materials that are damaged, lost operational time, cleaning, repairs, specialized equipment so our team can do immediate response. And the higher the frequency of the fires, the higher these costs become. And right now they're all being borne by our municipalities and those residents who we know are already stretched very thin. To date, all of our fires have been very quickly contained thanks to our tools and our team. However, we're talking about a battery that's the size of your hand in a pile of single sort material, but it's mostly paper and cardboard that is sometimes the size of your house. It takes one fire that burns out of control before we get a chance to contain it to substantially damage our facility. As you learned in the waste capacity study earlier, there's not infinite capacity for waste management. We manage the waste for about a third of Maine's residents. Stopping recycling operations for any period of time, we'd be dealing with about 800 tons a week of recyclables that would have nowhere to go. That could be catastrophic for recycling. And the higher the frequency of these fires, again, the higher the risk of that happening. The answer we know is safe disposal. Keep these out of recycling bins. It is a challenge. We've been in recycling since the early 90s. We know a little bit about behavior change when it comes to residential waste. Convenience and clarity are the key. Think about when you think of recycling, you think about the convenience of curbside, the clarity of single sort. These are things that really move the needle and change participation for people. We believe LD 474 is going to provide the convenience, more disposal locations, and the clarity of a single drop-off location for all your household batteries, the kind of thing that actually will increase safe disposal and keep dangerous batteries out of the waste stream so we have lower frequency and lower risk of these fires. So once again, on behalf of EcoMaine, I strongly urge the committee to vote to pass on LD 474.
Thank you, Ms. Sullivan, very much. Do we have any questions for her? All right, thank you for coming. Anyone else here present wishing to speak in favor?
Good morning, Senator Templer, Representative Giordera, and the committee. My name is William Andrews. I work for North Coast Services, TerraCycle Regulated Waste, and am a Hamden resident. So in all aspects, this affects me. I'm definitely for this for lots of different reasons. First of all, we right now deal with a large amount of these batteries that are collected at transfer stations and other centers like that. I think Vic said the greatest thing, education. One of the downfalls that didn't happen in the EPR for CRT collection, the covered devices under that, was education. It took about 5 years of people to realize that there was a program for this. So I think that's a huge thing. I also think that there's a pretty good framework already set up to handle this as an EPR for the state of Maine. And that's the EPR that covers the e-waste, the printers, the monitors, and the televisions. There's a good reporting structure for it. There's a good management structure for it. And on top of it, a lot of the manufacturers that actually do TVs and printers and stuff actually also manufacture batteries like Samsung and Toshiba and stuff like that. So I think there's a lot of ease in making that transition between the two. I definitely think that there needs to be some kind of stakeholder commission or something like that to understand the actual cost analysis of this, because, I mean, look, one of the biggest places is going to be going to transfer stations with these. That's what makes it easy for the residents to do this. So how do we set up the transfer stations to safely and effectively take these? I mean, on the town side of it, is it putting in a concrete pad with some kind of flam container to house battery buckets and stuff like that? Then from that point, is it the manufacturers to pay for all the recycling and any kind of record keeping? You know, they talked about the damaged battery portion of it. We already train our customers, which is 99% of the transfer stations in Maine. We train them how to package these, how to identify them. And we also provide what we call a damaged battery bucket. You get what in the industry is called a pillow top battery. If you've ever seen them, they look like a pillow, and they're not supposed to. They're supposed to be pretty flat. When that's a recognized battery, we have a battery bucket that we have for our transfer stations and whatnot, where it's got vermiculite in it. It's a sealed metal battery bucket that you keep outside to mitigate against getting, you know, any of this taking infrastructure with it. Sorry, I didn't have notes. I kind of shoot from the hip most of the time. I think as Vic and Mark both said, education is huge on both aspects of it. Education to where it's primarily going to be collected initially, which is the transfer stations. Getting them up to speed on how to tape them, how to, you know, keep terminals away from each other, how to put them in plastic containers or in, you know, with damaged batteries into a secure container. I think there's also that education that just, you know, and especially in today's time with social media, I don't think it's hard getting these people to understand recycling your batteries is free. You just got to get them to the recycling centers. I think that will take out of the 100% that wouldn't recycle them, it would bring that down to probably about 20. If they know when they got to drop their bag of trash off, they can just give the batteries with no cost. Some of these batteries are pretty expensive to recycle. Lithium primary batteries are typically about $4 a pound. So luckily they're small, but you say $4 a pound to someone and they grab a handful of lithium batteries they have, now they're scared. So I think to get that free concept in there, and I think also if you do the market share like the e-waste program, it takes care of that battery that no one knows. You know, the batteries from China, the batteries from trade shows, stuff like that. It falls under that market share program and just splits out the percentage to the responsible people. Thank you for your time.
Thank you. And can you tell us your name again?
William Andrews.
Okay, Mr. Andrews. All right. Thank you. Anyone? Yes, we've got a couple of questions. Okay, we'll take Rep Campbell and then Rep Regia.
Yeah, thank you. I caught Hamden. Are you
Yeah.
representing Fiberite?
No, no, North Coast Services.
Okay.
Yeah.
So, with these towns coming to you, and in a lot of cases, we've got more transfer than we are actual, solutions.
Yep.
To managing this product. How do you get those who come to you to signify that this isn't contaminated with these batteries before it gets to you? Do they separate?
So again, talking back to that, you've got the embedded devices, which is a problem right now. That is definitely something that needs to be addressed in the future, and I think could be addressed under this program as part of a market share program or something like that. Typically, we don't have people, just to clarify, bringing to us. We're not a transfer station. We go to the transfer stations and pick up from them. Right now, we deal with the transfer stations on the e-waste side of it. Most of them typically right now, we deal with their batteries as of now. So we'll actually pick up, we'll go and we do free training for them and stuff like that at the transfer stations.
So how do you know if that is a contaminant, if there's a battery in the waste that comes to you?
I'm not sure I understand the question.
How do you know that there is not a battery in the waste that comes to you?
We actually go through everything. So we know, like, so we'll get a keyboard. We have to strip that battery out. A lot of times there's a battery in that. Headphones, you know, there's many devices that you already know there's a chance of a battery being in it.
Yeah. Good. Thank you.
Yep.
Rep Regia, you want to go ahead?
Yeah, two questions. I guess
Sure.
the first one is, who's the 1% that you don't have in the state of Maine?
I actually don't know. Sydney.
Sydney.
Yeah.
Okay, well, we'll have to talk to Sydney.
Yeah.
Representative Collins, I think.
Well, they're in good hands too, so we
Yeah.
won't.
Second, is your organization, the people, when they have an free e-waste collection in Augusta,
Yep.
like they do
We're
sometimes
the
at the
guys.
Civic Center, are you the people that are doing it?
Yep.
Okay, well, it's nice to meet you.
Yeah, thank you. Yeah, we've dealt with Leslie and the people at Hatchill and stuff like that for many years with that. I've known Leslie for about 25.
I don't see any more questions, so thank you so much for
Awesome.
coming.
Thank you.
Great. Anybody else wishing to testify in favor? It's snowing. Go quick.
All right. Senator Tepler, Representative Dudera, and distinguished members of the ENR Committee. My name is Vanessa Berry, and I'm the Sustainable Maine Program Manager for the Natural Resources Council of Maine. I am also suffering from some laryngitis, so we've got some commiseration here. Thank you for the opportunity to testify in support of LD 474. This bill expands Maine's battery product stewardship program to include primary and small to medium format rechargeable consumer batteries and requires producers to fund and operate a statewide take-back program. It also phases in coverage for batteries embedded in products after 2030, allowing DEP and producers time to develop safe and workable solutions. According to DEP's recent waste characterization study, at least 8,200,000 pounds of batteries are discarded annually in Maine. When these batteries enter the waste stream, they pose serious fire risks to facilities and workers. At EcoMaine's Portland facility alone, there have been more than 60 fires in the past 3 years, with more than 3/4 attributed to consumer batteries. Municipalities and waste operators are bearing the cost and safety risks of products they did not design and cannot safely manage at end of life. Maine already has a clear framework for when product stewardship is warranted. A product qualifies when it contains hazardous materials, poses risks to people or the environment, creates costs for municipalities, would see improved recovery through a program, has successful models elsewhere, and when voluntary efforts are insufficient. Primary and rechargeable consumer batteries meet every one of these criteria. Producers are best positioned to solve this problem. A comprehensive stewardship program would reduce fire risks, protect infrastructure and workers, and deliver recovery of valuable materials that would otherwise be landfilled. It would also create clear, consistent recycling options for consumers. LD 474 includes convenience standards to ensure accessible collection sites near where people live, work, and shop, making proper recycling the easy choice. Expanding the program to cover a full range of everyday consumer batteries will also simplify public education and increase participation. Other states, including California, Colorado, Connecticut, Illinois, Nebraska, Vermont, Washington, and Washington, D.C. Have already adopted comprehensive battery stewardship laws with language very similar to what you see here. Aligning with these states reduces compliance complexity for national producers and builds on proven policy models. LD 474 closes a clear gap in Maine's current program. It protects public safety, supports municipalities, recovers valuable materials, and ensures producers take responsibility for the products that they put into the marketplace. And NRCM would respectfully urge the committee to vote ought to pass on LD 474. Thank you for your time and consideration.
Thank you, Ms. Berry, very much. Anybody have any questions for her? For NRCM? No? Okay, thank you so much for coming.
Thank you.
Good morning, Senator Tepler, Representative Dudera, and distinguished members of the ENR Committee. My name is Sarah Woodbury. I'm the Legislative Director for Maine Conservation Voters. MCV is a statewide nonprofit organization with 13,000 members and supporters, building a just, thriving future for all by acting on the climate crisis, protecting the environment, and safeguarding our democracy. And I'm here to testify in support of LD 474. Product stewardship has a long history in Maine, from the Bottle Bill, which was passed in 1976, to the Extended Producer Responsibility Bill that was passed in 2021. Maine is a leader when it comes to these programs. We already have a battery stewardship program, which passed in 1991, but it needs to be updated to include newer battery chemistries such as lithium batteries. This bill would do just that. I'm going to skip a little bit of my testimony, mostly because we've all heard about the safety issues and the fire hazards from people that are living that day to day. We would like to point out that LD 474 puts the onus for the cost of disposal on the manufacturers, not municipalities, saving Maine taxpayers money. It will also help us conserve resources. Batteries are made out of finite resources that are expensive to extract, manufacture, and dispose of. Requiring recycling keeps these materials out of our already limited landfill space and helps limit the need for virgin materials. And just because I can't not talk about it, these batteries also are comprised of toxic chemicals that are harmful to the workers, particularly at the facilities that are dealing with the fires, whether those batteries are crushed or they catch on fire. There's hazardous chemicals in them that harm both the environment and human health, including lead. There's no safe level of lead exposure, particularly for kids. Cobalt, which can cause asthma, cancer, and neurodevelopmental issues, and nickel, which you can get allergic reactions, and higher exposure can lead to respiratory issues and organ damage. So based on all these issues and everything that you've heard from the folks that are actually in the field doing the work, we urge you to vote ought to pass on LD 474. And thank you for your time.
Thank you, Ms. Woodbury, very much. We appreciate it. Any questions for her? No?
Thank you.
Okay,
Thank you very much.
Okay, anybody else in the room in favor who wishes to speak in favor? If not, we're going to go to online in a minute. Okay, I think we're ready to go to the folks online. Yes, in favor.
Great, good morning. Senator Tepler, Representative Dudera, and members of the Environment and Natural Resources Committee. My name is Sergio Kaweke, and I'm an organizer at Defend Our Health. We work to make sure that everybody has access to safe food and drinking water, healthy homes, and products that are toxic-free and climate-friendly. And I am here to testify in support of LD 474, an act to establish a stewardship program for primary and rechargeable batteries. We're in full support of requiring producers to participate in a statewide take-back program of primary and small to medium format rechargeable consumer batteries in order to protect the environment and people from toxic chemicals. According to the EPA, and this is on their battery take-back website, which I linked on my testimony that I submitted, and I quote, "Batteries are manufactured using different mixtures of chemical elements designed to meet customers' power and performance needs. Batteries can contain metals such as mercury, lead, cadmium, nickel, and silver, which can pose a threat to human health or the environment when improperly managed at the end of their service life. Some batteries might also contain materials such as cobalt, lithium, and graphite that are considered critical minerals by the United States Geological Survey. Critical minerals are raw materials that are economically and strategically important to the United States and have a high supply risk potential and for which there are no easy substitutes. Consequently, every effort should be made to recycle and recover these materials to ensure they will be available for generations to come. Chronic exposure to battery chemicals can lead to serious health problems. Lead exposure from lead acid batteries may cause brain damage, kidney harm, reproductive issues, behavioral problems, memory loss, and high blood pressure. Cadmium from nickel-cadmium batteries is toxic and can result in kidney damage and cancer. Long-term inhalation of toxic gases from lithium-ion batteries, such as phosgene, can damage the lungs and other organs. So in short, requiring producers to support this recycling and proper handling of used batteries will keep these heavy metals and toxic materials out of landfills and out of the environment, and will support the reuse of important finite material. And this is why I urge you to vote ought to pass on LD 474. Thank you.
Thank you very much, Mr. Kweke. We appreciate it. Who has any questions for him? Anybody? For Defend Our Health? Okay, thank you so much for waiting and for being with us. Is Ms. Riley there too? She was there.
I am. It's saying
Oh,
I
she's-
cannot start my video because it's been disabled.
Okay. Hang on, you're in opposition, Ms. Riley?
Correct.
All right, we might make you just wait a little bit more then. Let's just make sure we're done with. Anybody else that's in favor in the room that we didn't get to? Okay, great. So now we will go to those in opposition, and why don't we let you start, Ms. Riley, since you're right there and waiting.
All right.
You can be our first. Go ahead.
Thank you, Chair Tepler, Chair Dudera, and members of the committee. My name is Katie Riley, and I represent the Consumer Technology Association. We go by the acronym CTA. CTA is North America's largest technology trade association, and our members manufacture the consumer tech devices that you likely are using on a daily basis. We respectfully oppose the sponsor's amendment to LD 474. Our main concern is the inclusion of battery-embedded products targeted in the amendment. At the core, products should not be lumped into a removable battery EPR program. Did just want to touch on the removable battery component of this. I strongly encourage the legislature and Maine DEP to reference those state laws mentioned earlier. There are 7 states plus the District of Columbia that have adopted legislation in line with the Rechargeable Battery Association's model legislation, and there are actually 20 state legislatures right now in 2026 evaluating that model legislation. So worth pointing out, I think there's some misalignment in the proposal here with existing law and model legislation, so strongly encourage Maine to seek harmonization with existing and proven approaches for managing removable batteries. Specific to our concerns, the battery embedded product language was part of the draft annual product stewardship report from Maine DEP. The public comment period just ended on February 12th and the report isn't finalized. I am aware of several public comments submitted, including our own, in opposition to the embedded battery component of that language. So just wanted to flag that. But second, we strongly oppose the inclusion of battery embedded products in a battery stewardship program. We've been consistent in our messaging, with our engagement with Maine DEP over the past year, including in meetings and written comments. DEP had indicated they'd be conducting additional evaluation on how best to handle battery embedded products in September 2025, but it's unclear what, if any, evaluation occurred before the publication of the draft annual report. The scope of what falls into battery embedded products is still being discovered. It includes a really wide-ranging list of sometimes very dissimilar products, everything from vapes to textiles to consumer electronics. I think it's really important to note that collection and recycling infrastructure for products is vastly different than for batteries. And products are not compatible with the collection infrastructure that's been built out for batteries, including that's operated by the product stewardship organization that exists for batteries here in the US. We'd be forcing through this amendment products upon a stewardship system that doesn't want products, nor is it equipped to handle products. It's worth pointing out there are studies underway in Illinois, Vermont, and Washington on recommendations for managing battery embedded products that will yield additional information that can better inform Maine's approach to these products. California just began its program requiring consumers to pay a fee at point of purchase for any battery embedded products on January 1 of this year. And up in Quebec, they've been taking a phased-in approach for battery embedded products via small groupings of product categories, recognizing the need to build unique collection and recycling infrastructure from the ground up.
Ms. Riley, I'm gonna stop you because you're at the end of your time, and I do see that you gave us a great testimony.
Thank you.
In our packet here with a whole bunch of pages, so we
Thank you
can
for
read
the
through that. And I'm curious what city you're in.
I'm in Washington, D.C., and I apologize I couldn't make it up to Maine today. I had to testify in Maryland yesterday. So unfortunately,
Gotcha.
complexity of flights didn't work in my favor.
Got you. Well, thanks. Do we have any questions for her? Yes, Rep. Campbell.
Thank you, Representative. So in terms of embedded batteries, are you concerned that it becomes such a part of a product it can't be separated?
By concern, what do you mean in the collection and recycling system, or what we're here advocating for is to treat products different than loose batteries. They require a unique collection and recycling infrastructure, and we just don't want to see products lumped in with a removable battery program. The product stewardship organization that operates for batteries here in the US has done a really great job of creating unique collection infrastructure that includes boxes where if there was a thermal event, they're self-contained to prevent fires from spreading. Those boxes aren't designed for products. And again, the scope of battery embedded products is very, very broad and it includes, like I said, textiles, it includes traditional consumer electronics, it includes lawn and garden equipment, it includes, my daughter's light up tennis shoes, it includes vapes that have issues with both nicotine and cannabis in terms of moving across state lines. So we just want more understanding this is a complex issue. We want a more thoughtful discussion. I'm going to turn my camera off to not give anybody a headache.
Okay, thank you. Any other questions for Ms. Riley? All right. So now we're going to go to the folks in the room who are opposed. If there's anybody here that would like to speak in opposition, come on up.
Good morning, Senator Tepler, Representative Dudera, and members of the ENR committee. My name is Christine Cummings. I'm the executive director of the Maine Grocers and Food Producers Association. I'm here this morning submitting testimony in opposition on behalf of MGFPA as well as the Retail Association of Maine. We certainly recognize the public safety concerns that you've heard much about this morning, and certainly a well-structured stewardship program can reduce these risks, support municipal waste systems, and ensure producers play a meaningful role in the end-of-life management. However, while this program is structured as a producer-funded cost, inevitably move through the supply chain and are ultimately reflected in higher prices at retail. At a time when Maine consumers are highly price sensitive, we encourage continued discussion to ensure the program is practical, regionally aligned, and workable for businesses. One point we wanted to reiterate is that we appreciate that retailers are not mandated collection sites. Still, retailers face compliance challenges in determining whether products on the shelves are associated with participating producers. I've certainly seen similar confusion as products have been discussed that are part of the bottle bill or not. For many independent retailers, this creates additional administrative burden on already limited staffing models. While we are here testifying in opposition today, there are 4 areas that we would like to see improved that could potentially move our position to neutral. Those include, as we heard previously, addressing the embedded batteries, marking requirements, the treatment of e-cigarettes and vapes, and also an addition of a salvage retailer exemption. And so, as highlighted in my testimony, we too oppose the automatic 2030 expansion into included battery-embedded products. Most model legislation adopted in other states have focused on portable batteries only. One point we wanted to make note of is that New Hampshire is actually in the process of considering EPR for batteries as well, and their legislation does not include embedded batteries. Second, marking requirements. We just would like to ensure that any requirements for the batteries to be marked do align with when other states look to implement that requirement for consistency across state lines. Third, e-cigarettes and vape products, as we testified last year on LD 1519. Many of those products being sold in the state are currently illicit and unauthorized anyways, and so additional state requirements to would primarily burden compliance for Maine retailers while doing little to curb illicit market activity. And finally, as I noted, a salvage and closeout exemption, as we saw with EPR for packaging, would be appreciated. In closing, we look forward to working with you and happy to be a part of any continued discussions, and we appreciate your time.
Wait a minute.
Thank you.
Thank you, Ms. Cummins. Thank you for being here. Do we have any questions for her? Looks like no. Thank you for being here. Anyone else that wants to speak in opposition? Okay, seeing nobody else in opposition. We don't have anybody online because we did that. Okay, great. Anyone here who is neither for nor against?
Good morning, Senator Tepler, Representative Dudera, members of the Environment and Natural Resources Committee. My name is Ashley Lusky, and I'm here on behalf of the Maine State Chamber of Commerce. We are testifying neither for nor against LD 474 as amended. First, just want to recognize and extend our appreciation to the Department of Environmental Protection and their work to address the growing challenges of battery disposal. And we believe there's broad agreement that batteries should be managed safely and responsibly, as you've already heard today. A well-designed stewardship program can help reduce the risk of fires while also improving environmental outcomes. While we believe it's critical that any battery stewardship program adopted in Maine align as closely as possible with programs in other states, a consistent framework across the U.S. is essential for manufacturers and stewardship organizations that operate nationally. Stewardship programs involve significant reporting, compliance, and administrative obligation. Aligning standards across jurisdictions helps ensure timely, efficient, and cost-effective implementation while minimizing unnecessary complexity. The Chamber was involved in the stakeholder meetings that were conducted in August and September of 2025 by the department, and appreciates, the department very much acknowledged that not all batteries can or should be treated equally. So to better align Maine's program with the handful of other states that have adopted battery stewardship laws, we respectfully request the inclusion of some exclusions under Section 1617, specifically when it comes to what a covered battery is not. So those being a battery contained within a product developed or manufactured for the purposes of public health, environmental, or water quality testing, a battery that is a component of a motor vehicle or intended for use exclusively in motor vehicles, and a battery containing product that is not intended or designed to be easily removable. Regarding batteries contained in public health, water quality, and environmental devices, these products are often subject to strict federal regulatory oversight. With respect to motor vehicles, I often think of them as the large format traditional lead acid battery, but there are so many other batteries that are included in vehicles, from their electronic systems, tire sensors, safety components. And so we think these should also be excluded from this initial legislation as they're handled differently. This proposed language closely resembles language adopted in other states, as well as that's being considered in New Hampshire and New Jersey, and would help ensure consistency across state programs. Following stakeholder feedback, as mentioned, we do think battery embedded products that are not easily removable should not be included in the program beginning 2030, and really should wait to see what other states are looking at in the findings that they find around feasibility, safety protocols, and cost impacts. See, my time's up, but do appreciate the work of the department on this. These EPR stewardship programs are a huge undertaking for the department, recognize their limited resources, but also the importance of this. And so happy to take any questions.
Thank you, Ms. Lusky.
Yep.
Any questions for her? All right.
Right,
Thank you so much for
thanks.
being with us. Is there anyone else who wishes to speak, neither for nor against? Okay, and nobody online left. So then I will declare the hearing on this bill, LD 474, finished. And I think now it's time for lunch, right? Great. Okay, so we'll come back. Well, we don't, yeah, let's come, committee, let's be back at 12. Test 1, 2.
Testing 1, 2. Testing.
Good afternoon and welcome to the Environment and Natural Resources Committee afternoon session. This afternoon we'll be hearing the public hearing on two bills, beginning with LD 2174, followed by LD 2187. For those who are not legislators or departmental members, we will be using a 2-minute clock this afternoon. Yeah, I know we usually use 3, but we have an overflow room also. And the overflow room is the state and local room across the hall, which is cross 214. Am I getting that right, Ashley? Yes, okay. So that is where those who are not able to sit down in this room, Mr. Bell, that may include you. Well, you know me, I'm a good sport. That's where we're at right now with this bill and the next one. So we'll get started by asking the sponsor of 2174, Representative Kessler, to present his bill. It's on, Chris.
Thank you.
Is there a sign in there for you?
There is a sign in.
Great.
There's all 25 copies in there, so. Ignore the first paragraph as well, please. Okay. Okay. Senator Tepler, Representative Dudera, and members of the ENR committee, I'm grateful to be before you today. My name is Chris Kessler. I think you can hear me loud and clearly. I represent House District 121, which is part of South Portland and a smidgen of Cape Elizabeth. And today you're going to take a little deep dive into EUT territory. I know that our House Chair has some familiarity with that, and so I'm glad that there's a little bit of a bridge there. The bill before you today came about to address the criticism that Maine's regulatory environment has made it impossible for energy projects to get permitted and built at the scale required to lower the cost of energy we all pay. I want to set the table for this discussion first by explaining the underlying problems that we're trying to solve for and to establish a common truth, a common ground. If we're unable to agree on a common truth, then we're going to be doomed to repeat the same mistake of engaging in the same old partisan battles that have been keeping us at a standstill. So what are these problems here? And this is going to be like a little bit of EUT education here. So the first is that the cost of energy is a significant concern for the poorest people in our state. It's stating the obvious. Data from a recent study on affordability that we commissioned with the ERAC committee concluded that approximately 200,000 households in Maine, or about 34% of all households, are having a hard time affording to pay to fuel their vehicles and heat their homes. 164,000 of that total are paying 30% of their income towards energy costs. So the common truth and ground is that we want to help relieve this burden on these households. Number two, the cost of energy is a significant concern for doing business and attracting new business in Maine. Having some of the highest electricity costs in the country makes it harder to compete with businesses in other regions of the country and the world. We want to keep jobs here We want people to see Maine as a place to invest in new and emerging industries. The third, Maine is still the most fuel oil reliant state in the nation, with 50% of homes heating with oil, down from 60% just 8 years ago. 98% of people still fuel their vehicles with gasoline and diesel. Over 80% of this fuel comes from the Irving refinery in St. John, New Brunswick, which sources their crude oil worldwide. We are exporting about $4 billion a year from Maine, and most of it goes out of the country. This dependency is a major drain on the Maine economy and a major trade imbalance that we want to fix. 4, our regional electric grid is fueled by a variety of sources. Power is primarily dispatched based on price. The least expensive power plants get dispatched until demand is satisfied, and the price we pay for that last generator is the price all generators get paid. Natural gas consistently sets that price because it still accounts for over half of all power generation in the region. And during peak demand times, more expensive and polluting oil-fired plants set that price. The goal is to increase the supply of less expensive, cleaner resources on the grid. 5, the price of natural gas and oil is greatly impacted by factors outside of Maine's control. Tariffs could add another 15% to already high prices. Extreme heat and cold are becoming more common. The latest threat of U.S. conflict with Iran is impacting global oil prices. Although the U.S. is at peak natural gas production, pipeline capacity into New England remains constrained. In spite of calls from some to expand the use of natural gas, there's a reality that New England states are unwavering in their determination to not expand pipeline capacity. Not. Thanks for catching that typo, Senator Tepler. This means our grid will continue to rely on imported liquefied natural gas from foreign countries to meet demand. Because international demand for LNG has spiked due to the war in Ukraine, New England has to compete with the rest of the world for the same natural gas, resulting in the major price spikes we've seen. But ultimately, I hope that we can all agree that continued exposure to international energy markets is an economic and energy security risk for the state of Maine and for the region. And 6, this is about one of the aspects of the bill with home rule. Home rule is arguably one of the most cherished parts of the Maine Constitution. It is as Maine as lobster and wild blueberries at this point. Article 8, Section 1 states, quote, "The inhabitants of any municipality shall have the power to alter and amend their charters on all matters not prohibited by Constitution or general law, which are local and municipal in character. The legislature shall prescribe the procedure by which the municipality may so act." So I repeat this in wanting to establish that home rule authority is not absolute. Ultimately, it is the legislature that determines the boundaries of that home rule authority. So the debate before us should be about the wisdom of making changes to that home rule authority in this area of law. Similar to other actions this body has taken to address the urgent needs of our citizens. Since the bill's submission to the Legislative Council, I've spent many hours talking to people across the spectrum about their take on what the holdup is. What I've identified are four main problems. One, the Department of Environmental Protection, under the leadership of Commissioner Loisem, has done quite a bit within existing resources to make things go faster and more smoothly. The department deserves recognition for these improvements, which get at the root of the issues we will debate. However, there is still a real human resource constraint, measured in headcount, experience, and pay. I believe we need to give the DEP the resources they need, and that could be accomplished with a fiscal note to this bill. I know what fiscal notes do to bills, but I'm ready to take that risk. Project review can get delayed due to a variety of factors like incomplete applications, departing staff, and the experience of the reviewer, just to name a few. Regardless of those reasons and what's behind them, there needs to be a deadline to improve predictability. Setting hard timelines on project review functions as a mechanism for the DEP to prioritize these types of projects and bring them to the top of the stack. And that would be a policy priority for us, if you so choose to adopt. There are smaller projects that don't require the same level of review as others. Rather than have to go through a longer review process, there can be a prescriptive path that can move things along faster, but still adhere to our environmental standards. The bill proposes to expand the use of permit by rule to accomplish this. And what has been cited by many as the biggest obstacle is also the most controversial part of this bill. The towns that have been identified as the next logical location for generation and transmission projects have created ordinances that make these projects impossible to build. We must recognize that the reason for these ordinances is rooted in legitimate concerns about the impact of development on their homes and their communities. This is a long-standing moral dilemma. Do we advance policy which seeks the greatest good for the greatest number, knowing that there will be negative impacts to some? I believe that this is required if we want to reach a future where we can be assured that the cost of energy will not be the reason for Maine's economic stagnation. The bill that is posted to the legislature's website contains the proposed solutions I just described, and the proposed amendment before you today is a result of working with the DEP and others to accomplish those same goals within the existing statutory framework rather than create new bureaucracy. And as many of you know, the sausage making that goes into creating a law requires a lot of back and forth. And this amendment reflects a lot of that work. However, there's still some work that needs to be done. What this bill does not contain, and what I would like to address, are solutions to concerns of the people who live in and around these potential future projects. I can proudly say that my colleagues and I on the EUT committee, in a bipartisan way, have done a lot of work over the past few years to improve transparency, increase participation, and strengthen their hand in these matters. And in my opinion, I believe we need to go further for these people. Even with the changes we've made, I believe our laws around compensation for land, impacts on property values, or community benefits can be strengthened further while still achieving our goals of cleaner air and affordable energy. I've come to the conclusion that if we are to reach this future, we need to pay the price for that future. The NECEC AKA CMP corridor, is proof that this is possible. In spite of legal delays that added $500 million to that transmission project, it still penciled out. Now we know the kind of wiggle room we have in negotiating for projects that can be a win-win for developers and for the people of Maine. We must not shy away from working this out. So I appreciate your time. Happy to answer any questions that you may have.
Thank you very much, Representative Kessler. I have a question for you, and then I'll see if other committee members have a question. So your original bill replaced the Maine Waterway Development and Conservation Act. Does this bill not replace that act, the new amendment to the bill?
That's correct.
Okay, thank you. That's very helpful.
Yep.
My other question is, if you can explain what you mean by penciled out, that would be helpful.
Yep. So in order for a project to move forward, it has to be able to make a profit. So it's still profitable.
Okay.
Yep.
That's what you mean. Got it. All right, Rep. Sobolewski.
Thank you very much, Senator. Representative, hello.
Hi.
I have a couple of questions first. I'd like to figure out what the playing field is here. You're running this bill for Pretty Flaherty, the lobbying firm. Do you know who their client is?
I'm not running this bill for Pretty Flaherty.
It's a Pretty bill.
So the idea was brought to me by Jeff Thaler, who works for Pretty Flaherty. So the concepts of the bill around permitting and log jams are a discussion that we're having. The version of the bill that you see now is not their work. It is my work. And my goal here is just to be a catalyst to have this discussion in a public forum and really try to come up with a good policy solution that addresses all the issues that I had just mentioned.
So do you know who the client is? That was the question.
There's no client that I'm aware of.
Okay, thank you.
So
Additionally-
one second, Rep. Sobolewski. So I want to make sure that we're talking about the amendment that Representative
Yes.
Kessler, okay,
Yeah.
and I want to make sure that
And
also that
origination.
anyone in the room or in the overflow room who wants to address the committee on this bill is referring to the amendment on the yellow sheet. Thank you. Go ahead, Rep. Sobolewski.
Just
Thank you, Senator.
Sorry.
just to further answer that question, of course, Pretty represents people who develop
Exactly.
transmission
That's right.
and renewables, sure. But that's not, I am not working for any of these folks, so.
I'll take that as a no. My next question, sir, is you painted a very bleak picture of our environment here in our state. The latest report on our carbon emissions and our goals show that as the end of 21, we were 91% of the way there to being carbon neutral state. So we're making great progress. Combine that with the EPA's recent rescission of the endangerment findings based on the original finding being flawed information and exaggerated climate science and a misinterpretation of the Clean Air Act. Why do we need to keep going that this is so critical when we have very easy solutions to electricity with at our hands? We can do it. Why?
That's a great question, and that's why I want to try to reach a common truth with you. It is, absolutely true that as a matter of state energy policy, we have pursued renewables as a way to lessen greenhouse gas emissions. I think there's not going to be an agreement on how dangerous those are to the atmosphere and to our climate. However, in my time in the legislature, the climate change issue, I think right now is secondary to being able to afford electricity, being able to afford the energy that we need to heat our homes and everything else. And through all of the research and analysis and business plans that folks have looked at, renewable energy just so happens to be the least cost energy as well. And so I want to frame the conversation not about climate change necessarily, but about what is the least cost way that we can achieve our goals. So
I have more. I'll wait.
Okay, Senator Martin.
Good afternoon.
good afternoon, Senator Martin.
In your testimony, you stated that home rule authority is not absolute. Probably means the Maine Constitution is not absolute, which probably means that the legislature doesn't have to change the Constitution and can just make its own rules. I think that that's disgusting. I think that I have a lot of different towns that have contacted me wondering why this bill takes away home rule. And I would like to know, I'd like you to address what you mean by home rule authority is not absolute. And I've got a couple of
That is that's a,
Okay, but I will ask you, Senator, to please avoid pejorative terminology when referring to other people speaking.
I didn't think I did.
all right.
Oh,
I'm not offended,
Well,
but I'll be glad to
didn't-
answer your
I didn't mean
question.
to offend you.
Yeah, no, I'm not
you
offended.
don't know what the word pejorative means? Look
Because
it
this is a hot button issue. This is a lightning rod issue, no doubt about it. And there
Well,
are.
it's a constitutional issue.
Yes, absolutely. So, of course, the Maine Constitution can be altered by 2/3 of the legislative body.
Yes, but not
So-
by a bill.
Correct. So in the Constitution, it states that the inhabitants of any municipality shall have the power to alter and amend their charters on all matters not prohibited by Constitution or not prohibited by general law. So this would be the change in general law, which is permitted by the Constitution.
I don't agree with you, with what you're saying at all, but okay, thank you.
Okay.
In number 6 on the amendment, the time limits of the application says that the permit for proposed renewable clean energy project is deemed approved if the department does not notify the applicant of a decision within applicable review period. That deviates from what the current law is. That basically circumvents home rule. And you did say in your testimony that there was people that were already passing laws that were stopping projects, and that was one of the reasons for this bill, was to basically sidestep the people that are making these laws at the planning board meetings and select boards meetings in these small towns, because they might not want something.
Thank you.
Could you please speak to that?
Okay, let me start with the first part, that it would be violating, I believe you said that the automatic approval would be violating home rule authority. Is that what you had said?
Yeah,
So
it deviates from the current law.
So the current law that aspect of the bill is dealing with is around how the DEP does their permitting process. So separate from local or state jurisdiction, it's mainly about how the DEP does their process. So in this case, it's separate from the home rule question. So.
Okay.
Yeah.
Thank you. That's all for now. Save the rest for the workshop.
So Representative Kessler, I have a question for you. So looking at 3A, which is the local control limitations, this reminds me to some extent of the state's decision at one point, although I can't remember if we've changed it since then or not, that we abrogated home rule on whether or not municipalities could limit the permit on guns locally. Is this a similar structure as that?
So the particular home rule edits in this bill are a similar exercise to what the legislature has done to set the boundaries around home rule in other areas of our economy, most recently around housing and
Yes,
like what
so
we
ADUs.
like ADUs, you know, things like that. It is an example of just that, you know, the state, the people of the legislature can make that determination of where the home rule authority ends and begins.
And
So-
this is in some ways similar also to when we told municipalities they couldn't limit guns in public places as well. Does that?
I don't know exactly how to answer that, but
Okay.
let's say yes.
Thank
Sure.
you.
You're talking about guns or solar panels?
Yeah.
Well, in this case, we are
But it's
talking
just about
about
home
solar
rule.
panels, but I'm trying to understand the structure of the home rule change here.
No questions on this side.
Okay. Yes, Rep. Sobolewski.
Thank you again, Senator. Representative, you talked earlier about the affordability issue, and it was the way to bring down electricity prices. But you serve on the EUT committee, which is the Energy Utilities and Technology. We brought bill after bill after bill into that committee to deal with the repeal of 1711 from the 129th, which created net energy billing, to alter net energy billing to make it more affordable to everybody, to get into small nuclear reactor, things of that nature, hydro. And your committee and you have voted no time and time and time again in favor of solar panels, and my bill has tripled. How do you justify saying it's the affordable way to go?
That this path forward is the affordable way to go.
In this,
So
under these conditions, never
Yep.
mind the DEP, we're
That's an
just going to build
excellent
it.
question. So I will speak briefly about our net energy billing laws and what's transpired over the past 8 years. We are not going to get into that debate right now. That's not this bill. But
That's my question.
that particular program, we sort of had a saying after a while that we spent 80% of our time in EUT focusing on 10% of our bill. And so the debate around NEB is worthy. And that's why we made changes to the program, because we realized that it needed changing. This bill before you now is addressing the major underlying structural problems of our energy grid. And one of the major cost drivers is around what the fuel supply is. And so trying to get at the biggest cause of our high energy prices.
Our energy's been coming down and down and down. Oil prices and gas prices are dropping. We just received 800 million barrels of oil from Venezuela. So those prices are coming down very well on their own, and yet we're not causing more damage to our environment. As I said, sir, 91% carbon neutral. So I don't see the justification.
Noted, Representative Sobolewski. I would also just want to respond that if you go to the State of Maine website that tracks fuel prices, you will see that even if global crude is going in certain directions, the price that we pay for oil coming into Maine still largely stays around the same, which is pretty expensive. Like I think it was around $3.80 a gallon average statewide. And in the context of what we're trying to do in energy policy, $3.80 a gallon fuel oil to heat your house still costs a hell of a lot more than if you were to be heating your home with electricity fueled with a heat pump at today's prices. And so as an energy policy, what we are trying to do is shift to the technologies and sources that are less expensive and get ourselves away from the whipsaw that happens in global markets, because we are completely dependent on those markets.
Follow up,
So-
Senator? Another direction?
Yes.
Thank you very much. Your bill states that sets dates, times, 180 days to do this, 150 to do this, 90 to do that, 150 to do this. Basically turning the permitting process on its head. Right now, it's a floor up process, meaning you start here and you file it, and then you break the first hurdle that they ask for, then the next. The more you give them, you get to your permit. This sets it at a ceiling down. This says if you don't get us what we want with 180 days, we're going to do it anyway. That's a problem, because not only are most of our environmental laws based off in federal law, but how are you going to get around the federal laws that mirror and run side by side with our environmental laws, permitting laws?
Good question. So I worked with Commissioner Loism on that particular language. In terms of the process and how this monkeys with it, I would say the timeline is functionally acting as a way to prioritize these projects in the stack of projects that the department looks at for everything. And that is the goal of making it a policy priority of the state of Maine to get these energy projects through the door in the department as a priority. As it pertains to the federal stuff, that's still going to have its own timelines. That's going to be separate from what's under the DEP's purview.
I'll have more. I'll wait unless you. Thank you.
Thank you. Any other questions from other members of the committee for Representative Kessler?
One more.
Okay, Senator Martin, one more.
It seems like this amendment has left out anybody having to show any financial capability for doing a project. Why was it left out?
The bill is meant to be about the permitting process itself and the requirements for all of the environmental stuff that you look at with a permit. It has nothing to do with the financial ability of a project developer. Those issues get worked out in other avenues as well. We also have the PUC process that looks at a lot of these things as well. So, and there's honestly, there were so many other things that people wanted in this bill that felt were relevant, but did not get included in this bill. I wanted it to be about the actual permitting of the projects. So.
Okay, thank you.
So I just want to follow up so I can completely understand what you just said, Representative Kessler. Financial assurance on solar projects is still happening, but in a different section of law. Am I understanding that correctly?
Yep.
Okay, thank you. All right. Another one, huh, Rep. Sobolewski? Okay. Just again, a reminder to committee members that we have two big bills here.
And this one's a big one, Senator. Thank you, Senator. My question is, next question is, I'm concerned about our environmental impact. I'm concerned about the laws that we have in place right now, such as our Natural Resources Protection Act, our Site Location Development Act, our Maine Endangered Species Act, which mandates conservation of endangered species, our Wildlife Habitat Act, things that over and over, environmental lobbyists have come in here and demanded and talked for, and I've endorsed some of those, and I've co-sponsored some of those as well. This steps right over every bit of it. It says we're just going to develop as we please. Those are issues the DEP controls and oversees. So how do you justify going past our environmental rules and laws?
I respectfully disagree with your loaded question.
It's a fair question.
Fair question, though.
It's a very fair question.
It doesn't change the requirements that these folks need to meet. All of the environmental protection laws will still be in place. Nobody wants to weaken our environment. Nobody wants to weaken our environmental protection laws, myself included. So just know that.
Saying if you can't, the DEP can't go through their process to ensure that you're in compliance with every bit of that is stepping by our environmental laws, Representative, and it's extremely troubling. Thank you.
All right. Seeing no further questions from the committee, we appreciate your testimony and bringing us this bill, Rep. Kessler. It's a very interesting one.
Thank you.
Thank you.
Like to keep it spicy.
And we stay frosty, as they say. Okay, so I am now calling on departments. I think there are several who may wish to speak to this bill. So we'll start, yes, with Director Wood from the DEP.
All right.
Welcome, Director Wood.
Thank you
Nice
very
to
much.
see you again.
And you as well, Senator Tepler and Representative Dudera and members of the committee. Good to see you. I am Rob Wood. I'm the Director of the Bureau of Land Resources with the Department of Environmental Protection. We are testifying in opposition to LD 2174, specifically the sponsors amendment. But before I get into the details, I'd just first like to note that we do greatly appreciate Representative Kessler's work on the sponsors amendment and that he sought input, significant input from the department. So we did meet with Representative Kessler a couple of times. The sponsors amendment incorporates a lot of the department's feedback, and so I think it's significantly improved from the originally printed bill. And really our opposition to the bill is exclusively tied to sections 1 and 2 of the bill, which deals with automatic approval of renewable energy permit applications. So I'll get to that, but with first, I do want to speak to the other provisions of the bill first, which we support in part. So the three elements that I want to speak to are first, the establishment of a site law permit by rule for solar energy developments. Secondly, processing time limits in general for renewable energy permit applications. And then thirdly, I'll get to the automatic approval of renewable energy permit applications when those processing time limits are exceeded. So first, the department does support the establishment of a site law permit by rule for solar energy developments. We have the existing authority to establish a site law permit by rule. I'll just call it a PBR moving forward. So we do have that existing authority. This bill would facilitate the creation of the PBR, which is a streamlined permitting pathway, by clarifying that rulemaking to establish a site law permit by rule is routine technical rulemaking, and by directing the department to initiate rulemaking by the end of 2026. I will say that regardless of the final disposition of this bill, the department does intend to initiate rulemaking for a site law PBR this year. And we intend for the site law PBR to cover certain solar energy developments, as well as other types of developments, including residential housing that can meet specified standards. Section 11 of the bill proposes eligibility criteria for solar energy developments to qualify for a site law PBR, including a 100-acre size limitation, and that an individual NERPA permit is not required for the project. The department believes that the 100-acre size limit is appropriate. We would prefer more flexibility to determine through rulemaking whether requiring an individual NERPA permit should be eligible. A project requiring an individual NERPA permit should or shouldn't be eligible for a site law PBR. So we just like a little bit more flexibility on that part. The department is also supportive of the processing time limits for solar energy developments and energy storage system developments that are proposed by LD 2174. Title 38 already contains processing time limits for expedited wind energy developments, offshore wind power projects, and tidal energy projects. For other types of permits and licenses, the department must establish processing timetables annually, and the processing time for stormwater applications cannot exceed 90 days by statute. The bill's proposed processing times for solar energy developments and energy storage system developments, we believe, are reasonable. So getting to the department's concern with the bill, and the reason, again, that we are opposing the bill is the provisions in sections 1 and 2 that could result in automatic approval of permits if the department does not issue a decision within the applicable processing time. So for example, site law applications would be deemed approved if a decision is not issued within 185 days for expedited wind energy developments or 180 days for solar energy or energy storage system developments. The department does understand the motivation for this provision. It would create a strong incentive for us to meet processing times, and it would provide certainty that a licensing decision will be issued within the specified time period. However, it also sets up the possibility that if the department fails to meet a processing deadline, a large development, which is a development of statewide significance or regional significance, could be automatically approved, even if it does not meet licensing standards that are established in statute or rule. This is particularly problematic when considering appeals. Judicial review of an automatic approval would be difficult because there would be no findings of fact and no articulated standards applied to the facts. In another context, the Maine Law Court has instructed that, quote, there cannot be meaningful judicial review of agency decisions without findings of fact. Without such findings, there is a clear danger of judicial usurpation of administrative functions. Courts outside of Maine have said that when there is an automatic approval of a permit application, the court is required to review the merits of the application and issue its own findings of fact and conclusions of law, either affirming or reversing the automatic approval. However, such a procedure lacks precedent in Maine. It's unclear whether an automatic approval could be appealed to the Board of Environmental Protection like a normal licensing decision or only to the courts. And it's also unclear whether potentially aggrieved persons, such as abutters to the project, would be provided notice of the automatic approval and opportunity to appeal, as would normally be the case to ensure due process rights. Another concern with deemed approval is that under Title 12, the Land Use Planning Commission, who I believe you'll hear from today, must certify that a proposed development in the unorganized territories being reviewed by the department under the site law is an allowed use within the applicable subdistricts, and that it meets any other land use standard established by the LUPC that is not considered in the department's review. If the LUPC does not provide this certification within the required department processing time, and the development is automatically approved without LUPC certification, that automatic approval under Title 38 would be in conflict with the certification requirement in Title 12. Given all of these concerns about automatic approval of permits, we believe that the most likely outcome of automatic permitting is that the department would deny more applications as deadlines approach in order to prevent automatic approval. As Representative Kessler alluded to, when deadlines are missed, it's often because we're missing information. It's not necessarily because we haven't gotten to the review yet. It's often because we're missing information or we're seeking modifications from applicants to ensure the licensing criteria are met. Rather than allow projects that don't meet standards to be automatically approved, the department would be compelled to issue denials. However, the department does acknowledge that deadlines are sometimes missed because we're simply not acting fast enough. That may have provided the impetus for this legislation. There may have been applications that we simply didn't act on fast enough that have contributed to longer timelines for project development. And we understand that. We understand that timely permitting is critical for applicants, and we are actively working to accelerate permitting timelines. For example, we recently expanded NERPA permit by rule eligibility for coastal resilience activities. We also established predictable standards for shoreline stabilization projects, which are the highest volume individual NERPA applications we process. So that should help those move along. And we are now utilizing outside third-party vendors to support department staff in completing application reviews. The department plans to continue building on this momentum by initiating rulemaking to establish a site law permit by rule in the coming year, again, regardless of the outcome of LD 2174. So I appreciate you considering our testimony. Again, appreciate Representative Kessler for all of his work in consultation with the department, and we would be happy to answer any questions.
As usual, I'm raising my hand for a question I have, even though I'm running the meeting. So apologies. So I'm wondering if the department has suggestions for other tools rather than automatic permitting that might help move along the process in a way that's going to move us more quickly towards electrification.
Sure. Thank you for the great question, Senator Tepler. So the site law permit by rule would be a really meaningful tool to accelerate processing of solar energy applications. I also mentioned that we are actively developing a site law permit by rule that would apply not just to solar energy development, but to other types of development as well, including residential housing, which we understand is a priority for legislators. So the site law permit by rule could really significantly accelerate permitting for smaller projects. For some of the larger projects that would be, solar energy developments larger than 100 acres, or let's say really large wind energy development projects, sometimes those take more time to review. They're very large developments. That said, as I mentioned, we are contracting with third-party vendors. So we, in 2025, developed a third-party vendor list. We have about a dozen vendors on the list that we are actively working with to support department review of applications. We've already issued more than 50 permits using third-party vendors, and that is proving to be a really useful tool as well to accelerate permitting.
Is there a public statement or announcement about the stages through which a permit is going? Is there something on your website that says, for example, waiting for additional information from the applicant?
Yes, there is actually. So last year we introduced the Maine Enterprise Licensing System, or MELS, which is our new online permitting system. The Land Bureau and the laws that we administer were the first integrated into that system. So almost all of the permits that are issued by the Land Bureau are now integrated into MELS, and all pending applications can be viewed by the public in MELS. You can see all of the application materials, any comments that we've received on those materials, comments that we received from other state agencies. And then you can see whether the application is in process. That's most pending applications are going to be in process. But if we are seeking additional information from the applicant, we can change the status to action required, which again, the public can see, so that the applicant and the public know that that application is still pending and we are awaiting action from the applicant to provide missing information or otherwise modify the application as requested by the department.
Okay, I'm just wondering if there's any more that we can add to that would clarify for folks who want to find out what the status of something is. Let's say it is one of these issues where just having enough people in the department is part of the problem. Is there something you can put on there that would indicate sort of pending, expected to be finished by such and such a date.
Yes, and I should clarify that, so every application that has been accepted as complete for processing has a published processing deadline that is found in MELS. And so if you search for any pending license application, you will find the processing due date. And so that is the date by which the application must be, a decision must be issued on the application. If we don't hit that deadline, there is already a remedy in statute, which is that we must refund half of the processing fee. If it goes another X number of days, we have to refund the full processing fee. So that it is addressed in statute. It doesn't achieve the same outcome as automatic approval, but there is a remedy in statute for missed processing deadlines. And the expectation, I should say, for the department and for all of our staff is that we hit processing deadlines. We have had a backlog of applications, in part due to the solar energy boom that started in around 2020. And then as we were just coming out from under the solar energy boom, we had the January 2024 storms, which has resulted in a lot of NERPA applications, which led to some of the rule changes that I referenced in our testimony. And so we have been backlogged with those applications. I think we're just starting to get out from under that backlog as well.
Can you give us the website for MELS so that
Yes.
anyone could go on and see it? Could you make sure that at the work session, we get some kind of sheet of paper with that on it?
Sure. I could recite it now if you would like.
Okay, that would be great. Sure.
Let me see if I can remember. It's www.depmaine.gov. MELS.maine.gov. All right. MELS.maine.gov. I really had it at the tip of my tongue. Different on the back.
Okay, MELS.maine.gov. Thank you. That's important information. Okay, Rep. Sobolewski, and then was there someone on this side? Okay, Rep. Campo.
Thank you, Senator. Good to see you, Director.
You too.
See you again. How many permits does the department issue a month across the board?
Oh, that's a great question. So we usually count by all permitting decisions issued, which includes permits by rule. And typically we're looking at about 200 to 250 per month. And I should say this is for the Land Bureau, not counting all of the other licenses we issue. So for land licenses, around 200 to 250 permits issued per month. And the majority of those are permits by rule. For individual permits, we're looking at maybe 50 to 100 per month.
Okay. And because of the fault of the department itself, not waiting for information, can't get information, that type of stuff, how many are late? How many do you miss deadlines on?
Yeah, I could provide some, more definitive data for you on that topic. I mean, I personally sign the majority of our permits that are individual permits. So not permits by rule don't require a formal approval. It's just a 20 working day processing period or a 14 calendar day processing period. So for individual permits, the permits that I've signed recently, the majority of them have been hitting the processing deadline. When we miss the deadline, it's by, let's say, a month or two. I mean, but I will certainly acknowledge that, in the past several years, we have missed some application deadlines by a pretty wide margin. And again, I would say it's due to a structural backlog that we have been facing. And that was the impetus to go outside the department and develop a list of pre-qualified vendors. They have helped us a lot to work through the backlog. And I think some of our recent rule changes have helped as well. So we have seen the light at the end of the tunnel and we're coming out of the tunnel. Again, I could get you some hard data if you would like for the work session.
In prioritizing the permits, you issue a lot of them, I'm sure, and fix natural disasters, build a home, build a hospital, whatever it may be. What would this system do as far as prioritizing goes? Meaning that it will prioritize renewable energy over and above any other type of permit. So what would it do in that respect?
Yes, that is certainly a consideration. So if we are mandated to issue a permit or it would be automatically approved, it's going to go to the top of the priority list so that automatic approval doesn't happen. And then that does result in other applications being bumped down, a step on that priority list. We do prioritize applications just using our best professional judgment currently. So, if an applicant tells us that they must start construction by the end of this month or the project dies, we do take that into consideration. So we're constantly kind of triaging and prioritizing and juggling based on the information that we have. So this, obviously, a statutory mandate would play a role in that prioritization process.
Thank you. Last one, Senator. Is it a personnel issue? Do you have enough people in the department to handle permitting?
I would like to think if we were fully staffed and we had 100% staff retention for several years, that
How
the
many are you
answer would be
down?
yes.
How many are you down now?
We have, I believe, 18 land licensing positions. Those are project managers who are doing the review. And then there are 3 regional licensing supervisors who oversee those 18 project managers. Currently, we have 14 of those positions filled. So 14 out of 18 is not bad. We are posting the other 4 imminently. And, part of the challenge is just that, as many other sectors of the economy and other government agencies are encountering, we've had a wave of retirements in the recent past, and many of our staff are, relatively new to the job, and so it takes a while. There is some art to land licensing, and so it takes a while to climb up that learning curve and really become seasoned. And so I think, again, we're doing a decent job with hiring and retention, and I think with time we can continue to improve. I would say we could certainly use a few more positions.
Thank you.
Any other questions from the committee for Director Wood? Yes, Rep. Campbell, I'm sorry, you raised your hand before and I forgot.
That's okay. Thanks, Senator. Always nice to see you.
You too.
And the information you provide. I guess it's just one simple question. This bill happens to address timeline and concerns. Do you or does the department hear a lot of concerns about the fact that things aren't being processed in particular areas? I've always been a proponent of getting you more money and more staff because I do think you're doing a good job. Are you hearing that there's a problem, and do you need more than what you have to address those problems?
I think it's fair to say that we, hear critiques about processing timelines. Absolutely. And we take them incredibly seriously. We are working on a range of strategies to accelerate permitting, reduce processing timelines, get decisions done and out the door in a timely fashion. So I outlined a number of strategies in our testimony. Certainly additional staff capacity would be helpful. Absolutely.
In terms of statutory or mechanical needs for change, are you seeing anything you need from us?
There's a lot to unpack in that question. I mean, certainly, I think the site law permit by rule is really where we would like to focus in the next 6 months to see what we can do with that. It's an idea that I know the department has considered and contemplated in the past. We've never developed a site law PBR, but there's a lot of potential. I do think that the majority of issues that we run into with processing timelines tend to be site law projects, and that is why developers try to avoid site law. One of the reasons why. And so I think if we have a good site law PBR that has appropriate standards, but that could help ease some of the pressure that we experience with renewable energy projects, with housing projects, and other types of development as well.
Now maybe I can focus on the from us part. We're only here for a few more months.
Sure.
So 6 months is well beyond that. And then 6 months beyond that is well beyond that. So it's
Right.
you know,
Well,
if you got something coming, let's see it soon.
well, this bill, LD 2174, would establish that a site law permit by rulemaking is routine technical. So it wouldn't come back to the legislature. I should state on the record, that is our current interpretation. So there's not explicit clarity on that question in statute. So we like the fact that this would provide that clarity. I think our interpretation would be that a site law PBR actually is routine technical rulemaking, but this would codify that. And that would allow us to get it done faster.
So we should make it major substantive.
No,
All right, seeing no more questions, thank you
Thank
very
you.
much, Director Wood, for your testimony. Okay, and the next department is the Office of the Public Advocate.
Senator Tepler, Representative Dudera, distinguished members of the Joint Standing Committee on Environment and Natural Resources. My name is Heather Sanborn. I'm here today as your public advocate, testifying in support of Representative Kessler's amendment. I am here today on behalf of Maine's utility ratepayers. The Office of the Public Advocate represents the interests of those consumers, advocating for fair rates, services, and practices in regulatory and court proceedings under our authorizing statute. Our work is primarily conducted before the Maine Public Utilities Commission. We're a law office with 5 attorneys, and additional participation in proceedings before the Federal Energy Regulatory Commission and ISO New England as well. And we testify before the legislature, usually in the EUT committee, on utility-related matters and provide information as well on utility services directly to the public. I say all of that because you guys don't know the Office of the Public Advocate, maybe over here in the ENR committee, as well as my friends down the hall in the EUT committee. And I want to make sure that you know that your constituents can reach out to our office directly. We have someone who answers the phone and answers email all week long to provide help, particularly with utility bills or with community solar subscription issues as well. So you have all seen your own electric bills and likely heard from your constituents who are struggling to afford the dramatic increases in electricity rates that we've seen over the last several years. I provided a chart on the back of my testimony that you may want to flip to as I go through this next part. I want to focus your attention on the green part of the bar in the chart on the back of my testimony. That green part represents the cost of the supply portion, the electricity itself of a CMP residential customer's bill. The verse and breakdown would be very similar for this portion of the bill. And you can see that the supply costs bounced around at a pretty low level between 6.5 cents and 9 cents in the years before 2022. In 2022, the supply price jumped to almost 12 cents. And then in 2023, it rose even higher. And prices have stayed stubbornly high ever since. So what happened in 2022? Well, in February of that year, in fact, 4 years ago yesterday, Russia invaded Ukraine and the global market for natural gas went into turmoil. In Maine, our electricity supply rates are still almost entirely determined by natural gas. In most hours of the year, as you heard from Representative Kessler earlier, natural gas generators set the wholesale market price for electricity, and their costs are determined by the cost of their fuel. Maine doesn't really have any tools available to us as a state to fix the global natural gas market, or frankly, even the constraints within the New England natural gas market to lower those fuel costs. But we do have a critical tool available to us to make those fuel costs far less impactful on our electricity supply costs. We have to build more grid scale generators and grid scale energy storage facilities that do not have any fuel costs at all.
As more and more of those facilities come online, we'll reduce our dependence on expensive and volatile natural gas and save ratepayers money. Right now, the mature, commercially viable technologies that can be built affordably in Maine are the solar, wind, and energy storage facilities that are referenced in the bill. At the OPA, we're not experts on the ins and outs of permitting reforms, so I'm not going to comment on the specifics of that bill and leave it to Mr. Wood and others who are those experts. But we are experts on what drives electricity costs on your bill. And delays in building more solar and wind and energy storage facilities and getting them connected to our grid will directly cost Maine ratepayers money. The longer we continue to allow natural gas fueled plants to set the wholesale electricity price in Maine, the longer we will be at the mercy of global markets that we cannot control. If instead we can efficiently permit and swiftly build renewable energy and storage projects and get them connected to our grid, we can drive down costs. As we see it, that is the simple and compelling rationale for this bill, and the urgency is real. The affordability crisis is here now. I urge the committee to dig in and see what can be done to ensure that permitting does not stand in the way of our ratepayers getting some relief. I welcome your questions, preferably about energy costs, and would be pleased to provide any additional information I can for the work session.
Yes, Representative Dudera, you have a question for the public advocate?
Yes, I do. Thank you.
All right.
Welcome. Thanks for being here today. I was down the hall at lunchtime listening about geothermal, so I'm very interested in these alternate energies. And I mean, I think we all agree it's a good thing we should be doing. But you know, in this committee, we're charged with protecting the Maine environment, so we have to think about that. I just wanted to see what was your reaction to what Director Wood said, that a consequence of this passing could very well be that rather than more permits going through, as the sponsor would hope, there'll be more denials because they'll be afraid that they cannot make the deadlines. So I'd like to hear what you think on that.
I have sort of thought about that, chatted with Representative Kessler about that yesterday, and I think that's a concern. And like I said, not really in the weeds on the specifics of how permitting reform should be structured, but here to just emphasize and underline the importance in terms of affordability of ensuring that whatever the most efficient way that we can do an appropriate review of these projects is, because I do appreciate that permits are needed. We should have permits, but clear and predictable timelines and clear and predictable standards, I think, are the key. I was heartened by what Mr. Woods said about permit by rule. I think that's a great idea and maybe an opportunity for this bill to make some headway. And I think I'm also, I guess, I'm hopeful that there's continuity. We know that we're moving into a next gubernatorial administration, which means turnover in commissioner level appointments, et cetera. So I'm hopeful that the committee can help ensure that a streamlined and efficient process continues, because I heard Mr. Woods saying that a lot of progress had been made on that in the last 2 years. So encouragement for continuing to use third-party reviewers, for example, in order to expedite timelines seems to me, just in listening to how the discussion has unfolded so far today, that there may be a package of those types of ideas that could help ensure that that streamlined permitting continues to develop in Maine.
Representative Sobolewski and then Representative Campbell.
Thank you, Senator. Hello.
Hello.
You've talked about costs and you've talked about rate savings to the ratepayers. Quite frankly, over the last 3 years since I've been on this committee, going on 4, there's absolutely nothing that the Public Advocate's Office or anything to do with solar or wind has done to balance out or reduce my electric bill. There seems to be, what you're suggesting is that we do away with home rule and just build whatever we need whenever we want to, and do away with the permitting process through the DEP so we can build whatever we want to and build more and more and more. And all that's going to happen is my bill is going to go higher and higher and higher. And every ratepayer that I represent, that bill is going to go through the roof. I don't believe what you're saying, unfortunately. So please, Tell me exactly how littering our landscape with more of this trash is going to bring my rates down.
Again, representative pejorative. And if you need me to explain that, I think I can.
I've already asked my question, Senator. Thank you.
So Representative Sobolewski, let me see if I can take two pieces of, I think, what you said there. Number one was that the OPA over the last 3 years had done nothing to bring rates down, and I frankly take offense to that. But I want to point out that the Office of the Public Advocate, prior to my leadership and under my tenure, I think over the last 12 months since I've been in this role, has been extremely vocal about the mistakes that were made in LD 1711 and played a critical role in negotiating a rollback and a termination of that program that occurred during the last legislative session with bipartisan support. I want to emphasize, and Representative Kessler said it earlier, but that I provided this graph because I think not only did I want to draw your attention to the green section of the chart, which is driven by wholesale electricity prices in New England, but I also wanted to draw your attention, if I had a question like yours, to the orange part of the chart down at the bottom. And that orange part of the chart at the bottom represents NEB costs. Okay, so you can see, and I'm not going to argue that it exists and it's on there, but I think it's really important to note two things. Number one, that it goes down in 2026, and that's a direct result of the OPA and the legislature's efforts to scale back and start to wind down the community solar program. But it's also a less than 5% of the total electricity bill. The piece that we are, in my mind, able to really pull a lever on here today is to say that the way we bring down that green portion of the bill, which today represents 43% of a CMP residential customer's bill, the way we pull on that much bigger problem is by building zero fuel cost generation. And you mentioned SMRs earlier. I am agnostic as to what kind of zero fuel cost generation, and SMRs may someday be that low or zero fuel cost generation that we should put into our grid. Right now, they are neither affordable nor commercially viable. People are working on that. They're working on it in other states. And as soon as it's proven out, let's have that conversation about whether that's the most affordable generation. But today, the most effective way to make that green section of this chart smaller is by bringing in new wind, solar, and energy storage projects. You can disagree with me, but that is the economic reality of the way our wholesale energy markets work.
Earlier, you mentioned the mistakes made on 1711. Would you explain how that's affecting what's happening now, please?
How that's affecting what's happening now with regard to what?
With our development of solar and wind with this bill, what those mistakes are and if they're affecting what's happening now.
So I don't think that 1711 has anything to do with this bill because we have closed our front of the meter distributed generation program that was established in 1711 in 2019. It was closed and is over to new development as of the end of last year. So there are no new projects to be permitted that have anything to do with that aspect. If you're asking how it impacts our electric bill, it's in the orange piece of this chart.
Thank you.
Rep. Campbell.
Thank you, Senator. Thank you for being here. We've got a law on the books that says that we need to be 80% renewable by 32 and 100 by 40-ish, or whatever it is. What percentage of our energy production is so-called renewable right now?
So there are a number of different ways of answering that question. If you ask me right now at this moment, or sort of annually, or that we buy credits for to offset our usage. There are a lot of different answers. And really,
How much solar and wind energy are we producing in this timeframe? How much have we gotten to? I know the answer. Do you?
So
This is important.
again, there are different ways of answering that
okay,
question. I
okay,
think
so
our,
let me
why
ask
don't you tell me what
Let me
answer you're
ask
looking
another
for,
one.
Representative Campbell?
Let me ask
Go
another
ahead.
question. What part of our high energy bills are determined by the subsidies that we have on solar and wind?
Yep, it's in, that's a great question, and it's all contained within the stranded costs in the orange piece of this graph. The stranded costs includes both the power purchase agreements, which last year cost Maine ratepayers about $4 million, and the NEB costs largely from the 1711 front of the meter program, which last year cost Maine ratepayers in that orange piece of the graph about $200 million.
So in other words, the subsidies don't really factor in your graph to the high costs of energy.
They do. They add a cent and a half this year, that's substantial out of, a 30-cent bill. 1.5 cents is substantial. That's a lot of money.
Thank you.
Yeah.
Okay, thank you. Are there any other questions for the advocate? Okay, one more.
Good afternoon.
Good afternoon.
You're advocating for lower costs for consumers, and I think that's a great thing.
It's my job.
I think that something might have got left out of this amendment, and I'd like to know what you think about that, is the 100-megawatt cap on hydropower, which is something that's a base load thing. And we've got a cap on all the dams that can produce more than that. What's your thoughts on maybe something like that getting amended into this bill?
So I know that the EUT committee has taken up that question about larger hydropower. There have always been concerns, I think, in that committee about the cross-border implications of lifting such a cap and having different Canadian hydro impacts from that. It was discussed last year in the EUT committee. And like I said to Representative Sobolewski, the OPA is agnostic about the type of generation. We're looking for the lowest cost. So we have supported any changes to regulation that would lower the cost for consumers. And so we're in favor of maximizing the hydropower that we have in Maine. We're in favor of maximizing the hydropower we get from Canada if it's the lowest cost resource as well. My office is purely concerned about affordability.
Thank you.
Okay, thank you. I think I've got to remind the committee that we need to keep our questions to this bill, even though it's good to ask. And go ahead, Rep. Sobolewski.
It's quick. I think it is important to it. You mentioned earlier stranded costs. Is OPA doing anything to relieve us of that?
Absolutely. So I worked pretty tirelessly over the last year on LD 1777, which, as I mentioned, puts an end to the front of the meter solar projects under 1711, and also made adjustments to the compensation retroactively for those projects that already existed in order to ensure that the compensation would be more right-sized and not have the bonus that they were receiving from Ukraine oil prices, et cetera. Take some of that back and then ensure that costs over time would not rise in lockstep with our retail electricity prices going forward. So we made enormous steps. In fact, we quantified it at $1.2 billion last summer of the savings over the next 18 years that Maine ratepayers would see in their stranded cost number from the actions of the legislature, bipartisan, passed both houses under the hammer last year, and we worked very hard on that bill. So the other thing we're doing on a forward-looking basis about stranded costs is that all future procurements of any sort of energy storage, other things that we might procure as a state on behalf of our ratepayers has to go through a ratepayer beneficial test so that the net costs of that project to ratepayers have to be less than the net benefits of that project to Maine ratepayers, not to the world, not to global climate change, but to the ratepayer. And we are going to be working on ensuring that those standards are met this year and in future years at the OPA. That's our job.
Okay, are there any other questions, or can we let the public advocate sit down? Okay, thank you very much. Do we have any other department folks here who wish to testify? Thank you.
Thank you. Sorry, I can't see you without my glasses, and I can't see what I wrote with them on. So I'm at that awkward period of life.
I have that same problem, interestingly.
So we
Yes.
do a lot of shuffling, and
Yes.
just apologies up front. Can you hear me okay?
Yes,
Okay.
and
Yes.
I've noticed it does not say, oh, yes, it does, Mr. Godso.
Yes, I should start there.
Thank you.
Senator Tepler, Representative Dudera, members of the Joint Standing Committee on the Environment and Natural Resources. My name is Ben Godso. I'm the Acting Executive Director of the Land Use Planning Commission within the Department of Agriculture, Conservation, and Forestry. I'm here today to testify in opposition to the newly proposed amendment to LD 2174, an act to replace the Maine Waterway Development and Conservation Act with the Maine Renewable Energy and Associated Transmission Development and Conservation Act. LUPC serves as the planning, zoning, and land use permitting authority for the unorganized and deorganized areas of the state, including all townships, most plantations, and certain small towns. These areas either lack local government or have chosen not to administer land use controls at the local level. LUPC is the primary permitting authority for solar energy development in the unorganized territories, except when the Site Location of Development Act or site law applies to a proposal, and therefore the DEP has authority. Smaller solar projects, non-grid scale wind, and standalone battery energy storage systems, microhydro and other similar proposals in the unorganized territories that do not trigger site law thresholds are permitted solely by the LUPC. When site law is triggered and DEP is the lead permitting authority, LUPC's role is to A, certify to the DEP that the proposed use is allowed in the zones at the site, and B, that the project meets any land use standards in the Commission's rules not already considered by the department in its review. And this process is called site law certification. LUPC's zoning covers nearly half the state and the most rural portions of Maine. Existing development zones often lack sufficient area to accommodate future growth. If a proposal is not an allowed use or exceeds the area zoned for such development, the proposal must seek rezoning approval from the Commission before it can apply for a permit and before the Commission can issue a site law certification. The rezoning process includes an assessment of the proposed location's suitability for the new zone. For example, new development zones for solar energy facilities must be proximate to interconnection points with transmission lines and within reach of emergency services. This makes the regulatory review for projects that trigger site law a two-step process, where LUPC first designates appropriate zoning if it does not already exist. Following rezoning, DEP can then issue a permit, which includes the LUPC certification. The timelines called for in the bill apply only to the DEP review process. including language requiring automatic permit approval if no action is taken within a certain time period could be problematic if an applicant has not yet completed the rezoning process, and particularly if the commission denies their petition to rezone. Because a section of LD 2174 touches on DACF authority to permit solar developments on high-value agricultural land, we also solicited input from our sister bureau, the Bureau of Agriculture, Food and Rural Resources. And so I have a short paragraph from them as well. But I'm not an expert on agriculture. They could be at the work session if needed. The Bureau of Agriculture asked us to raise these points. First, when DACF receives an application, the permit can either be approved, denied, or provisionally approved pending final approval of a management plan. The Bureau of Agriculture asked that the bill clarify that granting provisional approval within 150 days would satisfy the agency's obligation to issue a decision, and that any ongoing work to craft an acceptable management plan would not be construed as a failure to issue a decision within time limits. Second, DACF forwards approved permits to DEP for calculating any compensation due. Again, the Bureau of Agriculture requests clarity that the time DEP may require for calculating any fee occurs outside of the 150-day window. Lastly, Section 2 could result in automatic approval of site law permits if the applicant hasn't proposed adequate compensation for high-value agricultural lands or high-value agricultural impacts, land impacts, excuse me. The site law permit would be approved anyway if agencies miss the processing deadline. And Bureau of Agriculture staff will be available at the work session and would be happy to work with the committee to ensure no proposals inadvertently conflict with this new important program. In closing, DACF agrees that a consolidated, efficient permitting process for renewable energy projects that also prevents undue adverse environmental impacts is in the best interests of the people of Maine. A thoughtful approach is needed to specify jurisdiction in the unorganized territories and to ensure that we are upholding environmental review standards. Thank you for your time, and I'd be happy to answer any questions now or come back at the work session.
Representative Dudera has a question for you, Mr. Guzzo.
Thank you. Thank you for being here. I just wanted to make sure you brought up some new information here from DACF. But your concerns for the LUPC, were they covered adequately in Director Wood's testimony? Because he brought a lot of what you said.
Yeah, so there we share the same concern about appealability of a final agency action. Also, the automatic issuance of a permit, I think just creates confusion around the status of a project, particularly if it's, it ends up in the wrong zone because the rezoning process hasn't been completed, or if the commission hasn't issued a certification. I think as Director Wood mentioned, there you'd have two pieces of statute that are in conflict, and so it does create a bit of gray area, I guess.
Thank you. Thanks for being here.
Sure.
Representative Sobolewski has a question as well.
Thank you, Senator. Permitting in the unorganized territory has got to be tough. A lot of forest, a lot of wetland. It's got to be tough. 150-day window. How do you guys do it? Are you on time? Are you, I asked the same kind of question to Director Wood. How are you doing with it?
We also need staff. I would lead with that.
I wish we could help you.
It can be complicated, and because the commission zoning system is structured the way that it is, which is different than in a municipality. In a municipality, you have zones that are intended to accommodate future growth, but in the unorganized territories, zones for development tend to be where development already exists, and sometimes where it existed when the commission was created in the 70s. And then new proposals go through a reactive rezoning process where the commission uses criteria to apply the new development zone, and then they can issue a permit because they're now an allowed use in that new zone. So it can take a bit of time, and for larger development proposals, it tends to be a two-step process. And particularly if something triggers site law, there's an established route in statute and in rule for us to issue a site law certification alongside DEP, who would be the lead permitting agency in that case.
About how many a month do you do?
We do not do many. We cover, again, the most rural parts of Maine. I think the number of large-scale rezoning certifications that we've issued is under 10 probably, and I could get you the exact number if you're interested, but it's really just not many.
Thank you.
Are there any other questions?
Thank you, Vicki.
No. Okay, thank you. Thanks very much.
Thank you all.
Okay. It's a tag team effort here. Okay.
Proponents.
Okay, thank you for reminding me where we are. And I believe we've heard from all the departments on this bill. Are there any other departments present to comment on the bill? Co-sponsors. Are there any co-sponsors in the room who would like to testify or in the holding room? No?
No, Ashley says no.
No. Okay. Okay. Oh, really?
Yes, there's lots of people for the next.
Okay. So next we'll turn to proponents of this bill. Is there anyone? Yes, well, I think you
Run,
just
Jim.
have to run for the,
Jim.
run for the,
Run. You're gonna be Patrick.
I got it.
Thank you very much, Honorable Mr. Boyle, for your tribute.
My pleasure. I've been a recipient of a few. There are nights when that's what you have for dinner, right?
Well, we're gonna be here a while, I think,
Yeah.
so it's good to.
Let's just see what he brought. Oh, yum. Lesson.
I wrote a 3-minute speech, so I'll try to zip through it.
Thank
Senator
you.
Tepler, Representative Dudera, and distinguished members of the Environment and Natural Resources Committee. My name is Jim Boyle, and I live in Gorham. I am testifying in support of LD 2174. I believe all of you know me, some of you from my time serving as Senate Chair of this committee in 2013 and 14, and some of you from my service in the House from 22 through 24. In 22, I was on this committee, except we met by Zoom. 23 and 24, I served on the EUT committee. So there's a lot of familiar concepts being bounced around for the things that I've done here in the legislature. I support the proposed amendment to LD 2174 because it introduces significant and necessary changes to streamline the permitting process for renewable energy developments, including solar energy, energy storage systems, wind energy, and high-impact transmission lines. I strongly believe that these changes will foster the growth of renewable energy projects in Maine and ensure a more predictable and efficient regulatory process. Here are key reasons to support the proposed changes. Improving permitting timelines. The amendment establishes clear and reasonable processing time limits. Shouldn't have looked up. For permit applications under various laws, including the Site Location of Development Law, the Natural Resources Protection Act, and the Stormwater Management Law. By setting specific deadlines, I won't go into them because you've heard them. The amendment ensures timely decisions, reducing delays that can hinder renewable energy projects. The provision that deems applications approved if the commissioner fails to issue a decision within the specified timeframe is a critical step toward reducing permitting delays. I've heard some commentary that there's some concern about that in the department. I understand, and I think they've, Mr. Wood has elucidated those well, so I won't go into that some more. I think you can work on maybe some amended language or Mr. Kessler can going forward. The amendment prohibits municipalities from enacting or enforcing local ordinances or standards that are more stringent than state laws for renewable energy projects. This creates a consistent regulatory environment across the state, preventing overly restrictive local regulations that could stifle renewable energy projects. I guess you'll have to read the rest. Thank you for listening, and I support the amendment.
Thank you very much for being here, Mr. Boyle. Questions from the committee for Mr. Boyle? Yeah, go ahead and ask the question I know you're going to ask, Representative Campbell.
Thank you, Senator. No, I forgot my question.
You were going to ask, does he want to say anything else?
Oh.
If we change the limits on these two generation function solar wind, shouldn't we do that for all energy permits?
Change, I mean, not have automatic approval?
Or what other provision, what specific provisions are you asking about?
Well, for other.
Oh, for
other
solar and
productions of
wind, you mean,
energy,
and storage?
Waste energy, nuclear, whatever.
I would say that the kinds of other energy creation projects like, well, there isn't nuclear in Maine, so we're not really expecting to anticipate, although unless we do small modular at some point, which as Ms. Sanborn said, is off in the future somewhere, and she's agnostic, and I think I would be too, to a certain extent, as long as they're cost effective. And then waste to energy, probably unlikely to do a lot more permitting there, other than modifications of existing plants. This language does not address modification of site law, for example, or even stormwater or NERPA applications. But I think those would, if they're facilities that are existing and in place and have an existing license, then those, I think it would be appropriate to license those with a modification that's not as all-consuming as a new application for a large new renewable energy projects are. I would also add that others may correct me if they come up after, but I believe that now stormwater permit deadlines are statutory. So the ones that you see on that Mel site that Mr. Wood was referencing, if it's, I can't remember the numbers. Let's say it's 150 days. That is in statute. So it's added in this language, but it may not be necessary to add that. Stormwater, I mean, a site and NERPA are not in statute. Those are, as he said, annual calendar dates that are put on licenses or application for processing that are somewhat at the discretion of the commissioner. I don't know if discretion is the right word, but they're controlled by the commissioner. And by the way, I've been doing DEP and federal and local municipal permits since 1986. So I've dealt with a lot of these and a lot of the delays and timelines. And a lot of the delays are certain specific portions of applications, so particularly under the site law. And particularly most recently, things like visual and actually noise at certain types of facilities. Those things, and now wildlife and potentially agricultural soils. A lot of the others are pretty standard that when you're doing a whole site law application for a huge project, you've got a cadre of engineers and visual experts and sound experts and all of them, managed. And typically, most of that information, when the application is presented to the department, is fairly well cooked in by the professionals who know how to do that and do it on a routine basis. And then what happens is that the department staff and the other agencies like agriculture and fish and wildlife and maybe marine resources, they then weigh in to support the department staff and saying, we think there's too much wetland impact, or can you move some of the project, this road a little bit over here so they're not crossing the stream and things like that. That's the kind of back and forth that happens that takes time. But most of the things don't. So I think that's probably why I didn't know about the PBR stuff until I saw this amendment or this bill. But I think why it might work well for the department and for the applicants is that a lot of the things are pretty standardized, and they're things that engineers and other professionals present to the department as part of the application.
I have a lot of respect for your thoughts and perspectives. So today, apparently, we're just talking about solar and wind. What about other sources of energy?
This bill references energy storage as well, I believe.
Do we need to adjust those timelines as well?
For other energy projects? I don't think so. We're not likely to have a new oil-fired facility in Maine generating electricity or energy. The ones that generated electricity from biomass, that they were actually part of the purchase power agreement problem that are still stranded many decades later. There's still money being paid for those stranded, investments. So those are not likely to happen again within the foreseeable economic future. Small modular, again, are somewhere off in the future and would have to compete financially with solar and wind. Waste to energy is, again, I think probably, not going to be new waste to energy plants added. So I don't know there could be changes to some hydro facilities, I guess. There could be some technology about tidal power that could benefit from something like this. But that would be either added to a future legislative bill. It's really not something that you have to address now because there's no foreseeable, use of that type of technology in the next 5 or 10 years, let's say.
I guess my point is, if we do it for one, shouldn't we do it for all?
I suppose you could add, the department or Dan or somebody could add language that is more inclusive, even of those things that we don't anticipate now, as long as they're, as Ms. Sanborn was saying, as long as the least cost alternative is the one that you're preferencing. And actually, it isn't just the getting back to the costs that Rep. Sobolewski and others asked about previously. It's not just the PUC who looks at costs, but the DEP does too, and so does the Army Corps. A lot of projects that the DEP approves are approved by the DEP under authority under the Federal Clean Water Act, delegated authority from the EPA and the Army Corps of Engineers, but some of them are not delegated. And so I guess the larger point is an applicant has to show the economic viability of their project. The DEP just doesn't say, yeah, you've protected the environment, therefore go build whatever you want kind of thing. They do look at the economic feasibility as well.
Okay, there are seeing no further questions from the committee. Thank you very much for your testimony and your treat, Mr. Boyle. Thank you.
Good to see you all.
Good to see you too. All right, other proponents of the bill.
Jumping up here.
Good, you got it.
Good afternoon. My name is Patrick Woodcock. I'm president and CEO of the Maine State Chamber of Commerce. I do appreciate Representative Kessler for bringing this legislation forward. We always appreciate efforts to create clear and consistent permitting processes. I will point out from Representative Campbell's questions, we do think the bill should be expanded to be more technologically agnostic. At the heart of the bill, when I look at the structure of it, it reminds me of a number of states that do have statewide permitting preemption. And I chaired the Energy Facility Siting Board in Massachusetts for a number of years that has a similar structure to this, that looks at the energy and environmental for threshold energy projects. And that's natural gas projects, renewable projects, any power plants above 100 megawatts would be eligible for Energy Facility Siting Board preemption if a project sought that jurisdiction. Municipalities would engage in that process, and ultimately sometimes there was an agreement between the municipalities and the project proponents. So our recommendations with the bill would be, one, expand the resources that would be subject to this, make this all renewables. Natural gas projects, ultimately it comes down to sometimes a project that is serving a, this comes up with transmission projects, but also pipelines. It's traversing a municipality, but is serving a customer outside of that municipality. And I do think having statewide jurisdiction sometimes makes sense to look at the statewide ramifications. My time is short here. The other aspect that we do want to emphasize is hydropower resources, that we've heard over and over that the regulatory environment is not working for relicensing. That is 700 megawatts of clean energy. And I have not seen any climate plan, any clean energy plan that doesn't predicate the future with retaining those assets. So we need to look at those aspects as well. Happy to answer any questions from the committee.
Thank you, Mr. Woodcock. I actually do have two. You are testifying in support of the bill as it exists, or you're only testifying in support of it if it includes the amendments that you have specified?
As always, we support the legislation. We have recommendations. If the committee were to go to work session, we would be happy to come up with those amendments.
Okay, and okay, that's, yes, Representative Campbell.
Please do.
Please do.
Come up with your recommendations.
Please do, question mark. Yes, Rep. Sobolewski.
I was waiting for an answer on that. Thank you, Senator. Pat, the home rule question here.
Yeah.
Which we haven't really talked a lot about. We've talked about energy costs. Do you believe that this is valuable enough to the point that it should negate home rule?
I think there's a threshold question for this committee. Not everything should meet the statewide standard. You know, a 500 kilowatt project, 10 kilowatt, a 500 megawatt project, a nuclear power plant. Should a municipality be able to preempt any statewide consideration? Now, I think about the Midcoast. We lost Dragon Cement when a developer was going to bring an energy solution to that facility, a natural gas line. They closed because of energy costs, because a municipality indicated they would reject the project. That has statewide implications. Ultimately, you as the state legislature, I think, should create a threshold that should be preempted in some situations. Obviously, that is not all energy projects. I think a home rule should be, you know, these communities know their communities best, and we should respect that. But it does get to a threshold where it has statewide impacts.
What about the permit by rule part of the DEP?
I wasn't here for Director Wood's testimony. We are fully supportive of permit by rule in LD 128 that passed through the Housing and Economic Development Committee that would establish a permit by rule effort. We are certainly supportive of that effort.
Further questions for Mr. Woodcock? Seeing none, thank you very much for your testimony. Is there anyone else who would like to speak in favor of this bill? Oh, this is...
Good afternoon, Senator Tepler, Representative Dudera, and members of the ENR committee. My name is Luke Frankel, and I'm the staff scientist with the Natural Resources Council of Maine, or NRCM. And on behalf of our nearly 20,000 members and supporters, I'm here to testify in support of the sponsor's amendment to LD 2174. As Representative Kessler and the public advocate very clearly outlined in their testimony, there is an urgent need to expand renewable energy here in Maine, and permitting reform plays an important role in making that happen. Making clean energy permitting faster and more predictable while not sacrificing the integrity of our environmental protections is challenging. However, we believe that several of the common sense changes included in the sponsor's amendment to LD 2174 do strike this balance. More specifically, we support two of the primary initiatives in this bill to, one, update the timelines for key permits required for solar energy and energy storage system developments, and two, establish a PBR, a permit by rule or PBR process under the Site Location of Development Act, often called site law, for solar energy developments that are less than 100 acres and do not require Tier 3 wetland review. I know this committee understands how establishing a PBR process will streamline permitting, so I'm not going to dive into the details there. But I would like to mention that since this streamlined PBR would only apply to projects that are less than 100 acres and do not trigger Tier 3 wetland review, more complicated projects with the potential for more significant environmental impacts would not be eligible. Additionally, other laws like the Natural Resources Protection Act and other provisions within site law will continue to guide solar developments toward the areas where they're best suited, which is why we believe this provision kind of strikes that appropriate balance. I'll also mention that the bill also includes language that would prevent municipalities from enacting local ordinance stricter than statewide standards and automatic permit approval if DEP fails to issue a decision prior to applicable processing timelines. We are not prepared to support these provisions at this time, since they would represent significant policy changes that deserve more time and for review and analysis. And then just real quickly regarding the automatic permit approval, if processing times are not met, we oppose that provisions of the bill. And I just want to mention that DEP already has a financial incentive to meet these processing times, because if they fail to do so, they're required to refund 50% of the permit or license processing fee to the applicant. So with that, I'll gladly take any questions.
Any questions from the committee? Yes, Representative Campbell, of course.
Do you have another point you'd like to make?
Let me see. I think I kind of summarized it at the end there. Thanks.
Representative Sobolewski.
Thank you, Senator. So did I just hear you say that NRCM is against changing the permitting process at the DEP? You think that that's sufficient enough? Did I hear that correctly?
Changing which
The permitting process.
the permit by rule
Yes.
process? We are in support of changing the permit by rule process as outlined in the amendment. The timeline portion is that's also another portion. We are not in support of that provision. We believe that there are circumstances where that renewable energy projects, they're complex and that oftentimes the department needs that time. And as I kind of quickly mentioned towards the end there already is a mechanism in place to incentivize the department to meet those timelines, where if they don't meet it, they currently under statute, and I referenced the section of statute in my testimony, they're required to refund 50% of the permit or license processing fee to the applicant if they don't meet the deadline. So we're in support of updating the deadlines as outlined, but not guaranteeing that a project will be permitted if the deadlines are not met, if that makes sense.
That does make sense, actually. Follow up. And the other side of this, the two sides, it's the home rule as well as the permitting. So on the home rule side of it, what does NRCM stand on that?
Yeah, as we outlined, and I kind of skimmed over it due to time, but we are not currently believe we're at a position to make such a significant policy change that would be kind of removing that home rule authority. We think that there are concerns that we've heard here today that, warrant some merit, but that is a pretty significant policy change. And we believe that more data and information would be needed before that type of step is needed. Research about what ordinances are out there, how many there are, and what issues are happening in communities that are not covered under the statewide standards.
Thank you.
Okay, I see another question. Go ahead, Rep. Anklese.
Thank you, Madam Chair. Thank you for being here. I missed earlier parts of the hearing, but as people were speaking, I went back and read a bunch of testimony. And when I was reading the DEP testimony, I noticed there was sort of an anxiety around having the flexibility taken away with respect to when something needs a NERPA permit or not. Can you speak to that a little bit from NRCM's perspective?
So my understanding is the amendment the only thing it changes with NERPA permits is that the permitting timeline, so that the NERPA permits would still kind of apply a separate thing. The PBR process is just for site law, so that, and sorry if I'm not understanding your question, and we kind of view that having NERPA still in place and still apply will help to ensure that even if there is this permit by rule process under site law, that these solar developments are designed and kind of like push towards the areas that have the less impact to natural resources.
Okay, are there any other questions for Mr. Frankel? Looks like no. Okay, thank you very much. Do we have anyone else who's in support of the bill who wants to come up?
Good afternoon, Representative Dudera and members of the committee. My name is Eliza Donahue, and thanks for the opportunity to present comments in support of the bill on behalf of the Maine Renewable Energy Association. Though I've come before this committee before, just briefly, MREA is an association of over 70 companies, including wind, solar, storage, hydropower, and biomass generation developers and generation owners and developers of such projects. And also companies that provide services to those folks, such as environmental engineers, general contractors, electricians, etc. So as you've heard from many folks before me, renewable energy development in Maine is critical to meeting the state's renewable energy goals, to building our clean energy economy, and to stabilizing rising electricity costs. Indeed, renewable energy development is a key component of making energy costs more affordable. You've also heard that natural gas is by far the largest fuel source for our electric grid and is the primary driver of electricity price increases in Maine, along
with increasing storm costs, aging infrastructure, inflation, and others. But again, the volatility of natural gas is the primary driver. Transitioning to homegrown renewable energy sources will reduce Maine's exposure to this volatility, these volatile costs. And not only does having more homegrown renewable energy reduce our exposure to price volatility, but it also brings other benefits. I've included in our testimony some statistics about Maine's renewable portfolio standard, which is the law that has Maine to incorporate renewable and clean energy into our energy mix, has saved ratepayers $21 million annually in electricity costs, and has some great statistics in there about job growth. But to get to those benefits, and this is the heart of MREA's testimony, man, 2 minutes is much different than 3 minutes. For those looking, we've got like, anyway, but to get to those benefits, the benefits of, would you like me to wait for a question? Are you confident in my ability? Okay. Maine needs to attract investment. And because at the end of the day, the majority of these projects, if not all of them, are private investments. And the number one thing that investors want to reduce is risk. And state permitting is a big risk. It is such a risk that it either dissuades investment altogether or increases project costs as a hedge against that risk. That idea of attracting investment, that is the heart of MREA's support for this bill. Reducing risk is incredibly important to attracting investment. And for that reason and many others, we support the bill. And thanks for your grace.
Thank you very much, Ms. Donahue. Quick question for you myself. What do you think about Director Wood's concern that more projects will be turned down and denied, given that particular part of the bill that requires decision-making within a certain period of time?
I think that that's a real concern and one that is very much worthy of additional conversation. I think it does need to be balanced against additional incentive to meet those timelines. So I think that there is an in-between there.
Thank you very much. Okay, other questions from the committee for Ms. Donahue? No. Nope. Okay, so thank you very much for your testimony. Other proponents of the bill? 2174. Yes, okay, welcome. Squeeze out behind the pole there. These brooms were not built really well for this kind of activity.
All right. Good afternoon. Is it afternoon?
Yeah,
Senator
it certainly is
Representative
afternoon.
Dudera,
Not
members of the
quite
committee.
evening yet.
Yeah, not quite. I am Dale Knapp. I'm the head of development for Walden Renewables. We are a renewable energy company, and probably not surprisingly, I'm here to speak in favor of this bill. I think just a couple quick things. I know 2 minutes left, so I'll try and be quick. Hopefully you read my testimony. I wrote it myself. I think there's a lot of useful information in there. One of the issues I think we need to tackle is what we're doing right now is not working. I think it's pretty clear that there are laws in the books pushing us to move toward renewable energy to meet our increasing demand. And projects are just not coming online to feed the standard offer rate. And so that's one of the reasons why we continue to see this increasing cost of energy. Everybody has this perception that like, oh, look, all these solar projects are out there. But they're not utility scale projects. And so they're not entering into a 20-year power purchase agreement to feed the CMP bill or the Bangor Hydro bill that we all receive. And so I didn't hear anyone mention that earlier, but these grid scale projects enter into a fixed price contract for that power long term. It really has an effect on suppressing the standard offer rate because it's not every year. Natural gas goes up, oh crap, we're spending 15 cents a kilowatt hour. Fixed price, 20 years. I think the public advocate covered that real well. So probably better than I could. And the other item I think that's worth mentioning is we do oftentimes go into a municipality very early on. They have an existing ordinance on the books. We're talking with the select board. We meet with the planning board. We meet with members of that community and we hear like, this is a pretty good idea. And so we work on that project for 2 or 3 years. And then all of a sudden somebody hears that we have a project in their community and they decide it's a terrible idea, it's going to ruin everything, and we hear this I directly hear, I'm very supportive of renewable energy. I think it's a great idea, but not here. It's what they say everywhere. And so we got to figure out a way to cite these projects that benefit all ratepayers in the state of Maine. That's 2 minutes.
Thank you very much, Dr. Knapp. And is there a question from the committee? Yes, I see Representative Campbell has his hand up. Go ahead, Representative Campbell.
Thank you, Senator. So it's been said, terms get thrown around here.
Sure.
It's been said that this solar and wind is no cost energy. Tell me how do they conclude that?
Well, I mean, there is a cost. I think it's no supply cost. And so the initial cost is upfront when you build the facility. And so, we as a developer, we essentially pay or finance to build the facility, and then we get a fixed price for the power that we produce over 20 years. And so once it's kind of built, it's set it and forget it. And so if I could fix the price I pay on my electric bill today for 20 years, I do it in 2 seconds because it takes that volatility out. And a lot of corporate off-takers are doing that because it benefits their bottom line. And I think what this bill is trying to do here is give residential ratepayers access to that same kind of hedge against increasing price volatility. Does that answer your question?
So let's go back to the no cost term.
So no, Representative Campbell, I think you are a bit confused. I do want to say that I believe what they said was no fuel cost. So do you have a question around that?
Done.
I'm sorry.
I'm done.
Okay. I just wanted you to understand that was what was said.
No, I don't understand that. Thanks for clarifying that. I'm done.
Okay, then. All right. Are there other questions for Dr. Knapp?
Great.
Thank you, Dr. Knapp, for
Thank
your
you.
testimony. And now I will call other proponents of the bill. Are there any other proponents of the bill in the room? Seeing none, do we have proponents online? Okay. All opponents. Okay, so with that, we will turn to opponents of the bill. Are there opponents of the bill who would like to give testimony right now? Please go ahead when you're ready. I have to turn something over to other legislators.
Thank you. Senator Tepler, Representative Dudera, and distinguished members of the ENR Committee. My name's Eric Rolfson, and I'm the chair of the Albion Transmission Line Committee. I testify today in opposition to LD 2174. In 1988, the legislature passed the Comprehensive Planning and Land Use Regulation Act. This law was successful precisely because it didn't dictate how towns should grow. Instead, it empowered local communities to answer 10 fundamental questions based on their unique local visions. In Albion, a dedicated group of volunteers spent 3 years on this process. We emerged with a plan that reflects our community's deep respect for its natural resources and a commitment to preserving our rural character and economic base. More recently, Albion joined a dozen other towns along the proposed LS Power Renewable Gateway Corridor to address the inevitable expansion of energy infrastructure. We recognize the importance of renewable energy goals and have spent the past 3 years drafting ordinances to ensure that development is conducted in ways that protect the health, the safety, and the property rights of our residents. My family was stirred by the threat of having 140-foot towers bisect our certified organic maple syrup operation and thereby negate 50 years of hard work, dreams, and investment. These resulting town ordinances are not anti-renewable. Rather, they are reasonable, best practice standards for the construction, operation, and decommissioning of necessary energy facilities. The amendments to this bill represent a significant retreat from the Home Rule Authority. Our ordinances were not drafted by lobbyists or developers. They were researched and debated by local volunteers and vetted by town attorneys. In many ways, this reflects the same citizen legislature tradition that you represent here today, a system where ordinary people step away from their jobs and families to serve the public good. To discard the years of works our volunteers have contributed to is to dismiss the very civic spirit that defines Maine's government. Albion is not Bangor or Portland, nor are our neighboring towns. The one-size-fits-all approach to energy generation, transmission, and storage ignores local conditions and erodes the civic trust of those who've invested in local governments. We urge your committee not to centralize this authority at the expense of Maine's town-led democracies. Thank you for your service and for your time. I'm happy to answer any questions.
Well done, Mr. Rolfson, in keeping to the time. I just
Thank
didn't
you.
start it quite in time, though. There we go. Okay. All right. So, Mr. Rolfson, I have a question for you. Thank you. So would
Welcome.
the new limitations on high-value agricultural land have saved your farm regardless of the issue in this bill?
No, what saved our farm was that LS Power withdrew their bid because they were not able to do it for the original price. They basically drew a straight line through the corridor. Through about 3,500 people were impacted. They're both landowners and abutters. And that didn't go very well with people who had 3-generation dairy farms, for example, and forestry and agriculture and organic operations, as do we. But they decided ultimately they couldn't do it for that price, so the PUC withdrew the bid. Now there's a new RFP out. 2 new RFPs, actually. One from Pittsfield South that ISO New England is managing, and one the PUC is managing from Pittsfield North.
Thank you, Mr. Rolfson. More questions for Mr. Rolfson from the committee? Seeing none, thank you for your testimony. Oh, I'm sorry, Mr. Rolfson, Representative Campbell does
Yes,
have
sir.
a question for you.
Thank you, Senator. Do you have any indication that there are other towns beyond your reach here that might agree?
We have about 12 towns that formed committees, transmission line committees, and Preserve Rural Maine is an organization of which I serve as well on the board, has about 1,000 people on a Facebook group and a number of members too. So there's a lot of interest in doing this right, doing it the right way, because while the short-term costs are less expensive for aerial AC lines, the long-term benefits of putting it underground, running DC lines, and using existing corridors, if you look at what FEMA says, if you look at what NextGen says, these costs are comparable and much more acceptable to people who value their resources.
Thank you.
Any other questions from the committee for Mr. Rolfson?
Thank you all so much.
Thank you for your testimony. Other opponents of the bill? She's.
Thank you.
Good afternoon.
Good afternoon.
Senator Tepler, distinguished members of the Joint Standing Committee on Environment and Natural Resources. My name is Amanda Campbell, and I'm submitting testimony on behalf of the Maine Municipal Association's 70-member Legislative Policy Committee in strong opposition to LD 2174. Municipal officials are opposed to the proposed sections that would enact new preemptions on municipal home rule authority as it is outlined in Section 8, Part 2 of Maine's Constitution. This bill's blatant preemption of local decision-making processes would prevent municipalities from having prospective conversations surrounding clean energy development within their communities that could be more stringent than state law. It would also declare already existing voter-approved municipal ordinances that include more stringent language as void and with no force of effect. Of Maine's 483 municipalities, 87% function under a town meeting form of government where enactment and amendment of local ordinances must be approved by a community's voters. Just for reference, that is 425 of the 483 communities. This bill's one-size-fits-all prescriptive approach to clean energy permitting completely disregards the important work that communities have already done through the enactment of ordinances that were carefully developed to balance renewable energy goals with local impacts. In January of this year, the Department of Energy Resources published the Solar and Energy Storage Handbook for Maine communities. The handbook's introduction recognizes that, quote, every municipality in Maine has a unique geographic, economic, land use, and community context, and explains that the information provided therein is also, quote, intended to meet communities where they are based on their own circumstances so that each community can make informed local decisions and can consider specific benefits that they'd like to achieve through solar and battery storage projects. Rather than restrictive and prescriptive statutes that stifle community conversations, municipal leaders ask for collaboration and partnership with state agencies in developing actionable opportunities to both promote state policy priorities and maintain local decision-making capacity. The Department of Energy Resources has taken an important first step by providing municipalities with a valuable tool regarding clean energy development, considerations for local policies, and model ordinances to aid in community discussions.
Ms. Campbell, we forgot to start the clock.
I know, I'm
We-
done.
Yeah.
Considering all these points ought not to pass. I'm happy to
Thank you
take any
very
questions.
Yes, I'm sorry, I really need my co-chair. She's much
I
better
kept
the
looking at it
clock
too,
than
and I'm like,
I
it's
am.
not going.
No, I messed that one up. Sorry. But thank you for finishing when you were asked.
Thank you.
Appreciate it.
Certainly.
Questions from the committee for Ms. Campbell of the Maine Municipal Association? Oops, seeing none. Thank you very much for your testimony. Okay, other opponents of the bill? Jump.
I apologize. I don't have written testimony. I will submit it for the committee's review.
That was a lot of.
Good afternoon, Chairs Tepler and Dudera and members of the Committee on Environment and Natural Resources. I'm Jason J. Shedlock, and I'm here to testify in opposition to LD 2174. I join you as president of Maine Building Trades Unions, a regional organizer and secretary treasurer of the Laborers Union, Local 327, based right here in Maine, president of the Southern Maine Labor Council, and board member of the Maine AFL-CIO, among other roles in the labor movement and the community. Among others, I represent Mainers who build things. As a general rule, people who build things tend to be supportive of initiatives to allow them to build more things. The Laborers Union, as well as every other trade of the 19 other affiliates of the building trades, have been at the center of permitting reform, both nationally and in states and localities across the country. That's why I hope the committee will consider our reasoning for our opposition to this bill at this time. As referenced multiple times this afternoon, it's a large and complicated issue. I appreciate my friend and representative from South Portland's work in raising this issue and starting the conversation. It's important. And the very existence of this bill and starting the conversation is helpful. And the bill is exactly that, a start. Put simply, if we're going to make meaningful thoughtful, and collaborative changes in the way we build Maine, especially as it pertains to accelerating that work, it's going to take time to explore and address the real world outcomes of that policy and regulatory change. It's going to take more time than you have. Stated that we should be making decisions that, quote, do the greatest good for the greatest number of people, knowing that there'll be negative impacts on some. The bill as written, while doing good for some, can and must do better to ensure energy development is driven by local workers, earning wages and benefits that sustain their families and their communities. That's assuredly a community benefit and one that would be a win-win for the community. We also talked about things penciling out so that developers can make a profit. I would ask us to consider how they pencil out for working Mainers. I'll close in appreciating your attention to this and certainly have some more testimony to send, but thanks for your time, and I'm here to answer any questions you might have.
Thank you, Mr. Shedlock. Rep. Campbell has a question for you.
Thank you. Do you have one more point?
I do. Thank you. The point is this, and it's I think it's a parallel that's maybe kind of digestible. I've never been to Disney, but I hear that if you get a fast pass at Disney, there's a financial investment. You have to pay a little bit more in order to cut the line. I would like to think that maybe this committee and a larger process would give us the opportunity to consider the investment in Maine workers as perhaps a way that we can collaborate with the development community as well as the departments that testified today to make sure that Maine workers aren't left behind if there's a rush on development. So thank you. Thank you.
Any other questions from the committee? Seeing none, thank you very much, Mr. Shedlock.
Thank you.
Yes, sir.
Thank you. Are we making legislators go last? They can go, can't they?
I have a copy given to me by our analyst of the joint rules, committee rules of procedure that we agreed to at the beginning of this session, and it says only the sponsor and co-sponsors of the legislative document may testify before members of the public, except that for bills exempted from co-sponsor limits under.
That's okay. I just didn't, I don't remember us doing that.
Yes, the answer is yes, they have to testify at the end. So I'm sorry, that's just, we agreed to that before we realized the consequences of it. So. All right. So welcome, sir, and thank you for being patient with us.
Oh, I've got all kinds of patience. Thank you very much. And I haven't testified for a long time. My name's Jim Lebrecht. I'm here in opposition to the bill. I used to be Governor LePage's technical advisor on energy for his 8 years, and I still get quite involved with energy analysis and so forth. And I want to make a few comments. Back when I was working for the governor, I took upon myself to make put a lawsuit that I filed or prepared to file against the Ledge Council for its violation of constitutional rights dealing with unconstitutional bills. And I say that this is improperly, this bill is improperly before this committee because it is an unconstitutional bill. In fact, this whole document here is just my filing that I made for a lawsuit. Fortunately, they pulled the bills that I made complaints about, and they pulled them off, so we didn't end up not going to court or having to file court. But this has been going on for a lot of years, from the Expedited Wind Act of 2008 is an emergency bill. Emergency is for the necessity of the preservation of the peace, health, and safety of the state. In the second term, that's what it's supposed to be. And if somebody puts in an emergency bill and then they pull off the preamble and say, nah, it's not an emergency, it doesn't cut the line. It's got to go back to back into next year's session. So we had the expedited wind bill in 2008. We had Senator Tom Seviello was on this committee, chair of this committee, 1504. It was a violation of tax constitution. He was a senator, put in a revenue bill. This was a revenue bill that would
that would actually raise money from one group of people to give to another group of people. And that was a definition by the US Supreme Court as a tax. You know, you were not able to opt out of it. Then there was 1711, which is, I worked so hard for all 8 years to keep that out. And that was also another senator that put in a bill. So there's a lot of reasons for that. And I just want to bring up just 4 little points real quick to offset some of the stuff I heard here today. Maine total carbon output is 0.1% of the US global output. I mean, carbon output. And our electricity is only 10% of that. You're talking 1/100th. And so I will take so this all this energy that we're trying to generate, the very expensive, and it is very expensive energy, is to take out a teeny weeny little bit of carbon.
Mr.
from the
Lebrecht,
atmosphere.
you're
I'm all
over
set.
your time.
Yep,
sir,
all right.
So thank you.
It's happened before.
Okay,
Yeah.
I believe Rep. Campbell may allow you to speak a little bit more, but maybe not. We'll see what his question is.
No, easy.
Do you have one more point?
One more.
Well, yeah, you know, we talk about right now, I just looked on my app, electricity with mostly from natural gas, you know, it's 5 cents a kilowatt hour. All last year, it was 5.5 cents a kilowatt hour. When you look at this chart, there is a lot of hidden things in it that you don't see. For instance, the capacity factor isn't figured in here. Solar only has a capacity factor of 15%. What's that mean? It only produced 15% of what it could if it was working 24/7, because it's dark every night of the year and all that stuff. So the cost for a transmission line where you're going to be building it for solar, it's 7 times more expensive than the NECEC line. That doesn't show up in here. There's a lot of hidden cost in these numbers. And so if we look, we're giving $178 million a year for renewable energy credits. We just eliminate that. You know, it's $178 million off everybody's bill. There's so many things that can be done to lower costs. And I hope the next governor that's in here is my guy that I'm working for, and we can do it. We can have that stuff happen. So thank you. Oh,
Yes, sir, I'm sorry. I just want to ask you to please keep your remarks relevant to the bill. Thank
Yes.
you. And Rep.
Oh.
Sobolewski.
Yep.
Thank you, Senator. I'm glad that you're here. The public advocates chart here, do you have a copy of that?
Sorry.
Yes, I wouldn't get
Would you
one, yes.
take a look on the right-hand side here? This is about stranded cost distribution transmission. Would you go through that quickly and give me your assessment of those numbers? They seem very optimistic.
Well, yeah. So there's for instance, Bangor Hydro, sorry. Versant has built a big capacity system way down east. That's to take care of all of the intermittent sources of power that has no flywheel effect. There's no mass. And so they have to put in a very expensive system that will add to the flywheel effect of our grid in order to, when solar and wind and things like that are willy-nilly going up and down, the cloud goes over the solar farm, those things have to be maintained, okay? When the cost of maintaining the equipment, the voltage regulators, they're finding out across the states here now, voltage regulators are points that go across taps on a big transformer. And as you need more voltage, it goes up. And so what happens is that as wind slows down or speeds up, these tap. As solar, the cloud goes over, they tap, they burn out, and they cause all kinds of power outages and so forth. There's just so many details and all this kind of stuff. You just can't look at this in its most broad sense. You have to look at this as an analysis. And I want to say that the problem that we have here is the fact that we have now put all the stuff in the legislators' hands. It used to be short, medium, long-term planning was the responsibility of the power companies, and it was the PUC that held their feet to the fire on the cost. And it was best interest and cost base. That's gone. Now it's free for all.
Thank you very much.
Any other questions for Mr. LeBrecq?
You must have one. You were quite. Yeah, go
No,
ahead.
not
No,
right
no,
now.
go
No,
ahead.
I don't have one right now. Thank you very much.
All right, thank you very much.
Thank you. But you know, if you're here later, I'll think of one.
Okay.
Thank you very much. Appreciate your testimony. All right, I'm looking for other opponents of the bill.
Sorry, I'm writing as fast as I can. Okay. Senator Tepler, Representative Dudera, and members of the committee, my name is Tanya Blanchard. I'm here to present testimony in opposition to LD 2174. I'm speaking on behalf of Preserve Rural Maine. It is a 100% volunteer bipartisan organization dedicated to protecting Maine's rural communities. I've submitted written testimony for your reference, and I'm not reading it. I hope you all will. This bill preempts municipal home rule across multiple statutes. It might even violate the Maine Constitution. The bill declares any solar, wind, energy storage, and high-impact transmission line ordinance to be void and have no force or effect. It eliminates local discretion over setbacks, noise limits, visual impact, road use, blasting, decommissioning, protection of rural residential neighborhoods and working landscapes, and fire and safety training and equipment. Residents rely on local laws to protect farmland, neighborhoods, scenic resources, and public safety. For rural towns with limited staff and volunteer planning boards, these ordinances represent years of public process. LD 2174 erases that work in one single sentence. This kind of authoritarianism, backed by the argument that the state knows best, it creates resentment, division, and deep mistrust in government. This also raises a serious constitutional question. Maine's constitution explicitly grants municipalities home rule authority over local affairs. Local ordinances are not obstacles. They're an important part of local government that are constitutionally backed since 1969. At minimum, this bill invites legal challenge and uncertainty rather than the predictability the proponents are stating. Maine's strength has always come from respect for place, for people, for the idea that those closest to the land should have a say in its future. And LD 2174 moves us in the opposite direction. In fact, this bill reads as a last-ditch Hail Mary effort from large corporate developers to get projects built. Preserve Rural Maine urges you to oppose this bill, though even in our opposition, we have suggested some amendments that I've included in our testimony. Please don't solve one problem by creating another problem that rural Mainers will live with for decades. Thank you for your time. I'm happy to answer any questions.
Thank you very much, Ms. Blanchard. Thank you for being here. Are there questions from the committee for Ms. Blanchard? Yes, Rep. Campbell.
Thank you, Senator. So at the end of your testimony, you've got a list of towns that are involved.
I do. So very quickly, so I found out about this bill Sunday and have tried to gather as much information as I could. There are over 480 municipalities in the state of Maine. These are towns that I was able to very quickly pull that said have any kind of ordinance, solar, wind, energy storage, or transmission line ordinance that would be null and void as a result of this bill. And that's a partial list of all municipalities.
Thank you.
Any other questions from the committee? Seeing none, thank you for being here. Other opponents to the bill? Oh, okay, you're leaving, not opposing, yes, sir, you're,
Oh, sorry. Go right for it, miss.
Okay.
All right.
Yes.
Hello, committee. I am Heather Donahue. I'm a resident of Freedom, Maine, and I have a couple of 100 hours in developing our town's energy ordinances. A rigorous, transparent, and thoughtful act of stewardship that this legislation seeks to void. Freedom's relationship to renewables is not theoretical. We have one of Maine's earliest wind farms, and it did not make us less poor. It did not drop our energy rates, and it only sowed division in our town that continues to this day, 20 years later, almost 20 years later. The amendment makes 3 structural changes to environmental permitting, and they are not minor. First, it converts missed agency deadlines into automatic approval. If the department does not act within the statutory timeframe, the permit is deemed approved. Second, the amendment imposes ceiling preemption on municipalities. Any ordinance more stringent than the state minimum is declared void and of no force or effect. Now, several people were up here talking about how, well, are we going to, is there some sort of decommissioning bond? What are the specifics necessary for a solar array to go in? Now we have permit by rule for a solar array of 100 acres. We thought about all of that over a long year with transparency and diligence. And when you think about all of the different towns that actually took the time to do this, over 60% of towns, that's over 60% of municipalities whose voices you are going to silence with this legislation. People who've worked hard and diligently and honestly to create what they wanted for their future vision of their town. And considering we've also had housing legislation this year that eviscerated home rule further, this legislature has truly done a remarkable amount to eviscerate home rule. And it's exhausting the level of vigilance we need in our towns to actually protect ourselves from our own legislature. And we wish it was not that way. Sorry. This bill is justified by renewable targets. Oh, I'm out of time. Well,
yes, you're out of time. Thank you so
structural
much.
reallocations affecting environmental review should not be embedded in a second session.
Thank you, Ms. Donahue. Can you wait one
Oh, yeah,
second
sure.
while we see if anybody has any questions for you? Any questions from the committee for Ms. Donahue? Nope, seeing none. Thank you very much for your
Thank
testimony and
you.
thank you for signing in. Okay, are there other, yes, sir, you're another opponent of the bill.
Yes, give me a second to sign in.
Absolutely.
Thank you. My name's Will Niels. I was born and raised in a small settlement called Peastown in the northern St. George River Valley in the municipality of Appleton, Knox County. I've been coming here since '95 when I was 18 years old. And I have to admit, this is one of the most offensive and obnoxious proposed legislation I've seen in that 30 years. I think there's been great representatives of the common folks here who are speaking well. I'm not going to talk about the technical aspects. I'm going to make a point very, very clearly because this is important. I understand how Augusta works. We recognize that Severin and the backhanders over at Pretty Flaherty have put up somebody who's not running for re-election to put this in, okay? But it's also worth pointing out that not one citizen of the state of Maine spoke for this bill today. Every single person who spoke is either an employee of the state and was sent here to do their jobs, whether that was pro or against, or they were a specific employee of a lobbyist group or an energy company. Okay, I think that's sort of important when we think about these things because you're elected by your peers in the community. I ran for the state legislature in 2014 for what was called House 95 at that time. Okay, if I'd been elected, I would have taken that charge very, very seriously. Your neighbors elected you. And they elected you basically to work for the good of the community, right? We all understand that, for the good of the community, for the larger state of Maine, and to do what? To protect our Constitution. It's really, really crucial. It's one of the most important things you can do. And so I would just ask you to remember that if you're to undertake voting for this exorable thing that's like Severin walked a Chihuahua out and they put muddy paws footprints and did duty on our Constitution, then just think about how your neighbors are going to think of you, okay? Because our Constitution should matter. It should matter to every single person who lives here and each and every one of you.
Thank you so much. Good job making your time.
Any questions from the committee for Mr. Niels?
I'm sure there won't be.
And seeing none, thank you for your testimony. Okay, is there anyone else in the room who'd like to speak in opposition to LD 2174? Seeing, oh, are you speaking in opposition? Oh, yes, I'm sorry, I didn't see. Is there anyone else in the room who would like to speak in opposition? Okay, thank you. Yes, I'm not counting legislators yet. Thank you.
Hi, good afternoon, Representative Tudera and Senator Tepler. My name is, excuse me, and members of the committee. I'm just going to grab my water.
All right, we certainly understand the need to coat your throat at this point. We saw you,
no,
we
sorry.
saw you sneeze once also, so yeah.
Well, I hope I'm not sick. I think it's just because I'm sitting and not getting
This
fresh
very
air at the
dry
moment.
room or this very dry room?
Yes. Okay, thank you. My name is Holly Noyce and I'm from Albion, Maine. My family owns a dairy farm and we've been shipping milk every single day since the mid-1950s to Portland, where it's consumed locally here in Maine. We milk 100 cows and raise another 100 heifers and young stock. My grandfather and father worked unbelievably hard to turn what was once a dilapidated homestead in the 1920s when my family purchased the parcel, and it had no water, no running water, no electricity, and they worked so hard to turn it into the farm that it is today. That's more than 70 years of milk every single day. Now, my husband and I are transitioning into running the farm. We work on the farm, and I have the most enormous shoes to fill. I know there's a lot of issues here with 2174, but for time purposes, I'll just focus on one. I think this legislation is the wrong solution for the situation we have, and particularly, I think the transmission line should be removed from this bill. In 2023, we were contacted by LS Power about a new transmission line corridor, and we were terrified. We need more land. We don't need less land. Albion has 10 active dairy farms right now, and every field is still in use. There's no idle land waiting for infrastructure. Transmission lines are fundamentally different than solar, wind, and battery storage projects. Those are voluntary agreements between a landowner and developer. Landowners can say no. Transmission lines are not voluntary, and they carry the threat of eminent domain. I think I'll summarize because I got 8 seconds. Speeding up the permitting process for that, for a project that goes hundreds of miles, I think really puts landowners in jeopardy with, a developer saying this is where it's going, and farmland is very highly targeted because it's easy to permit.
Thank you very much, Ms. Noyes. I will say we understand how difficult it is to run a dairy farm these days and how much hard work's involved. Are there questions from the committee for Ms. Noyes?
I have one.
Representative Campbell has one and Senator Martin.
Thank you.
Thank you, Senator. Thank you for coming.
Thank you for your time.
It's crucial for us to hear from citizens who are affected by our actions. Many times, ramifications of our actions don't occur until they're written into law. So, do you have anything else you'd like to add?
Yes, I would just like to add that, through that process of being contacted about a transmission line, it's never been clear to me why we can't use existing corridors. There's a transmission line that runs through Albion right now. And it would be really great if that could get upgraded and put the lines there because it's already a disturbed area. You're not expanding and blazing new trails. I don't know why we can't look at options like that, or putting it, next to state roads or on highways where, there's already a permitting mechanism and scheme in place. We should look at
how we can fit that there as opposed to, disrupting and potentially, putting farms like me or, other people. It's not just me. And I think you lessen the number of parties involved. So if you are, dealing with state roads or something, you don't have 500 impacted landowners fighting and being told what they're going to be doing.
Great point. Thank you.
Senator Martin.
Good afternoon.
Good afternoon.
I'll tell you what, I really love dairy farmers. I think they're the greatest people on the planet.
Thank you.
I was listening to you and I looked at your testimony here, and it seems to me like your concern is that this bill will put eminent domain in the realm of permit by rule. And somebody will just come in and make apply for a permit by rule and take your property. Is that what you're getting at here?
My concern is that I don't think the bill addresses transmission lines here. Most of the conversation today has been about solar. So that's why I started with why are we discussing transmission lines? DEP didn't even comment on the transmission line permitting here. So I think in the effort with this bill to speed up all permitting, developers will come and say, this is the path we've already put forth, and this is where it's going to go. And there's not room for a landowner, it's easy being in an engineering firm out of state, looking at a computer screen, saying this is where a line's going to go, or this is where a project's going to go, and not seeing, how the land actually is and how it's being used and that local knowledge. We have over 100 years of local knowledge here on the lands and parcels that we use. But I think the other crucial point is that, Albion, I was in a meeting a couple weeks ago with a developer that reached out, National Grid, and they said, we responded to an RFP through ISO New England. We're going to put another transmission line in your town. And what we're doing is, we can't tell you today where that's going to go, but we've already put it in and we can't change anything. So through that conversation, they noticed that they didn't actually look at our ordinance in the town, which we developed 3 years ago, to site transmission lines in a respective way if it was outside of the existing corridor. So it needed to be underground to mitigate the impacts. And another developer has said that, well, we'll just go to the PUC and we'll get a waiver to, not use your ordinance. And, the ordinance is very clear about how it can thoughtfully and respectfully go through our town.
Okay, thank you very much for explaining it better. I appreciate it.
Seeing no further questions, we appreciate your coming and offering your testimony, Ms. Noyes. Thank you.
Thank you very much for your time.
Okay, and are there any other opponents of the bill in the room? Okay, seeing none, I'm going to move to those online, and first up is Mr. Cuddy. So please go ahead and present your testimony within the 2-minute time limit.
Absolutely. Thank you very much, Senator Tepler, Representative Dudera, and members of the Joint Standing Committee on Environment and Natural Resources. My name is Scott Cuddy, and I am the Policy Director for the Maine Labor Climate Council. The MLCC is an affiliation of 16 public and private sector unions. We seek to fight climate change while creating good union jobs. I'm here to testify in opposition today to LD 2174. The Maine Labor Climate Council is not taking a position on the merits of the measures to change how we permit projects in Maine. We are generally supportive of efforts to build more of the infrastructure that we need to build the clean energy future that we have to have. Our opposition is due to the fact that this legislation will allow for more projects to move forward in Maine without addressing the conditions that the workers building them will labor under. We are aware there is an amendment to this piece of legislation out there that would add labor standards, and were that amendment to be included in the final text of the bill that gets reported out of this committee, we would change our position to one of support. Unless that language is added, though, we would ask that you vote ought not to pass on this bill. I'm available to take any questions you might have and drafted my testimony assuming that we are going to have a lot of testifiers today, and so I would be under at least a 2-minute limit.
Well done, Mr. Cuddy. Questions for the committee, from the committee for Mr. Cuddy? Seeing none, thank you for your testimony.
Thank you.
Okay, do we have other folks online? Okay, let's bring them in. Good afternoon. Please state your name and present your testimony for in the under 2-minute timeline.
Rumson.
Oh, is this Ms. Rumson?
Yes, thank you. Senator Tepler, Representative Dudera, members of the committee, thank you for the opportunity to speak. My name is Rachel Lynn Rumson. I'm from New Gloucester. I'm speaking as a resident today, although I am an elected official in New Gloucester. I'm here to urge you to reject LD 2174. First, let's be clear. Maine's Constitution gives municipalities the power to govern local land use matters. Home rule is not a courtesy, it is a constitutional structure. LD 2174, sorry, would wipe out any local ordinance deemed more stringent than the state standards and even automatically approve permits when the clock runs out. That's not streamlining, that's sidelining the people who know their landscapes best. Second, I want to point you to the cautionary tale of Minnesota's boundary waters, which you can read about in the headlines right now. The federal government voted to reverse the mining bans, protecting those lands. And so now the watershed is vulnerable to contamination. This is what happens when higher governments override local ones. LD 2174 risks putting Maine on that same path, silencing communities exactly when the stakes are the highest. Third, the world has changed. AI data centers are driving the strongest multi-year surge in electricity demand since 2000. According to the U.S. Energy Information Administration, data centers could consume 8 to 12% of U.S. electricity, a staggering shift that utilities are already scrambling to incorporate into their load forecasts. This is not the moment to strip down the tools that protect local aquifers, shorelands, and historic landscapes. And those local tools matter. Under Maine's mandatory shoreland zoning act, municipalities must adopt and enforce ordinances that safeguard water quality, habitat, and historic resources. Towns are explicitly allowed and often required to
Ms.
apply.
Rumson, we would ask you to start wrapping up. Thank you.
Yes, to apply more stringent standards. You rely on these municipal protections as a committee. This legislation would dismantle them. Please don't create a system where Maine communities lose their voice just as high impact energy development accelerates. Maine people are sovereign in the state. Developers should need our consent before reshaping our environments and our economies. I urge you to oppose. Thank you.
Questions from the committee for Ms. Rumson? Seeing none, thank you for testifying today.
Thank you.
Okay, whoever is next.
He's there.
Okay, who is this? Is this
Mr.
Mr. Lee? Okay, welcome, Mr. Lee. Your sound is off. You're on mute.
I knew that. I was just testing you.
Yeah.
Greetings,
I've been tested many times, Mr. Lee.
No more tests today, I promise. Except this one we're talking about. Greetings, Senator Tepler, Representative Dudera, and members of the ENR committee. Thank you for your time. My name is David Lee of Vassalboro. I'm here to oppose LD 2174. First of all, wow, it's really hard to take off time from work to be here, so I hope you recognize the difficulty and inaccessibility in providing in-person testimony for working Mainers. This bill claims it will provide electricity expense relief to Maine households and promote development of renewable energy. I am here to suggest this is fundamentally disingenuous of an argument designed to pave the way for something else entirely. This bill does nothing to lower your energy bill or mine. It fast tracks a 5 megawatt or greater gold rush for one specific customer, the AI and data center industry. These facilities are behemoths that will consume vast amounts of power, straining our grid and competing for supply. When demand spikes, prices follow. Ratepayers will not see relief. They will see higher bills to subsidize the infrastructure these corporate giants require. And while we don't have to imagine what's we don't even have to imagine what's coming. Right now in York County, a massive data center is being proposed for Sanford, a 100 to 300 megawatt facility that would be one of the largest industrial developments in recent memory. Its developers plan to generate their own power, initially using natural gas because they know connecting to the grid would drive up electricity bills for every Maine family. Let that sink in. Even the industry admits their facilities would hurt ratepayers. This project would consume 300 to 500,000 gallons of water daily from the Moosomin River every single day. A typical hyperscale data center can use between 1 and 5 million gallons per day, equivalent to a town of 10 to 50,000 people. Let's talk about what this bill sells itself as renewable energy. But some renewables being touted, like biomass, are deeply problematic. Environmental advocates have called biomass not a climate solution and questioned whether it can even be truly carbon neutral. The United Nations climate bodies have warned that substantial new development, even of renewables, if not sited and scaled, can undermine the climate mitigation efforts. This would strip our towns of any meaningful say. Section 4C2 prevents municipalities from enacting ordinances with standards more strict than state law. I know I'm at time, so I just want to come back to this thought experiment. If you imagine that a child 20 years from now looks back at these hearings, will they see a legislature that thoughtfully balanced progress with protection, or will they see us handing our water, our quiet nights, and our local control to distant corporations, all while wrapping it in the language of green energy? We have an obligation to be discerning and judicious. This bill is not about renewable energy. It is about handing our renewable resources and constitutional traditions to an industry that operates in the shadows. Thank you for my time, and sorry for going slightly over.
Thank you, Mr. Lee. Any questions for Mr. Lee from the committee? Seeing none, we appreciate your testimony. I would like to say I need some definition from the department for the work session on whether or not there's any inclusion of data centers in this bill.
Okay, Matt Gilly next.
Okay. Mr. Gilly from Harpswell, welcome.
I guess that
Please
means
go
you know who I
ahead.
am.
Yeah, of course I do. I'm also chair of Marine.
That's fair. That's fair. I'm sorry I couldn't be there today. You'll understand why shortly. Dear Senator Tepler, Representative Dudera, members of the Joint Standing Committee on Environmental and Natural Resources. My name is Matt Gilly. I serve as a member of the Select Board in Harpswell. I also live in Harpswell and make my living as a commercial lobsterman. I am here on behalf of the town of Harpswell and our Select Board to offer testimony in opposition to LD 2174. We want to be clear at the outset that we are not opposed to renewable energy. Maine should pursue clean energy, strengthen grid reliability, and reduce long-term costs for ratepayers. But this bill does not simply modernize permitting. It fundamentally shifts land use authority away from local communities and concentrates it at a state level in a way that is deeply concerning. Zoning and land use planning have long been core municipal responsibilities. Towns like Harpswell have adopted land use ordinances after years of public process, hearings, and compromise. Those ordinances reflect local geography, environmental constraints, working waterfront needs, and the community character. This bill explicitly prevents municipalities from enacting or enforcing ordinance that prohibits siting of large renewable projects, adopting standards stricter than law, using moratoria to pause and study impacts. This is not coordination. This is preemption. Communities most affected by these projects would be reduced to submitted comments while the Department of Environmental Protection becomes the sole permitting authority. For towns with fragile coastline, fisheries, tourism economies, and limited infrastructure, that loss is meaningful and significant. This bill requires the DEP to issue a decision within 105 working days. If it fails to do so, the permit is deemed approved automatically. This is a major policy shift. Large-scale renewable projects and transmission corridors can have complex impacts on the environment, the economy, and community-wide. Automatic approval, if an agency misses a deadline, prioritizes speed over scrutiny. That may reduce delay, but it also increases the risk of an inadequate review. In a state where natural resources are the backbone of our, I'll finish it up right now.
Okay.
Backbone of our economy, fisheries, tourism, and forestry, the trade-off deserves careful reconsideration. I submitted the rest of our testimony in writing, and I'm sure you guys will review it after, but that's my 2 minutes.
Thank you very much, Mr. Gilly. Questions for Mr. Gilly? Nope. Seeing none, we appreciate your testimony, sir.
Thank you.
Okay, and next up is
Ms. Spencer.
Spencer. Okay. Ms. Sasha Spencer. Please go ahead, Ms. Spencer.
Hi there, thank you. My name is Sasha. I live in Vassalboro and I'm testifying in opposition to LD 2174. I appreciate this opportunity to speak. I'm a small business owner and a farmer, and I'm speaking here as a citizen. This amendment seeks to streamline the process for national and transnational corporations interested in energy domination in steamrolling the voices of impacted communities and their expectation of environmental oversight over essential shared natural resources. A major issue here is the significant push for energy-intensive AI data center development across the state and the country. This amendment would significantly short-circuit public input for those projects, and it feels deceptive that this is being discussed as though it is only about clean energy and cutting costs for ratepayers. By allowing energy project permitting to be streamlined in this way, this bill doesn't need to say it is prioritizing AI data centers to be doing so. Furthermore, even if this proposal were the best way to lower costs, which is highly debatable, the idea that addressing high energy costs now should require the sacrificing future oversight of public resources and environmental protections is a false dichotomy that should not be entertained. To be clear, the bar for impacted communities to have a voice in decisions that affect them is already too high. As an example, this opportunity for public feedback today occurs in the middle of a weekday. While it may be our civic responsibility as concerned citizens to pay attention to the happenings in the State House, we are not resourced like paid lobbyists are. Many voices are left out of the rooms and the conversations by default already. We don't need to raise the bar any higher. This new bill, disguised as an amendment, would make it easier for out-of-state and transnational interests to use Maine as a resource colony, leaving residents without a voice. I thank you in advance for opposing LD 2174.
Thank you very much for keeping in your time, Ms. Shedlock. Questions for Ms. Shedlock from the committee? Seeing none, thank you very much. And please know, I'm sorry, what?
Spencer.
Spencer, I'm sorry.
That's okay.
I got you. Yes, there was a previous person named Shedlock. I'm sorry. So sorry, Ms. Spencer. And Ms. Spencer, I have asked the department to assure me that AI data centers would not in any way be included in this bill in the work session, just so you know that.
Well, can I speak to or just ask a question about that? I mean, I don't have to. Maybe other people can bring a question.
We have too much testimony to get through, so thank you very much.
Yep.
Okay, so who else is online?
There are two more, neither for nor against. Do you want?
Yes, I think, is there anyone in the room who's neither for nor against? Okay, there is one person in the room. We always take the people in the room first. So, Mr. Thatcher, if you want to go ahead and present your testimony. Tell me about it.
Very impressive, 3 straight hours. Remind him about 2 minutes.
Yes, you're on the 2-minute clock also, sir.
Thank you.
Said that hydropower was the only main indigenous resource that we could use for energy. And we are now in the 2020s, and I thought that's out of date. Maybe we should update the Maine Waterway Development Act so that it's not just hydro, but some of the other renewable resources that this legislature has already said are renewable or clean. That's where this started. It sort of has morphed in different directions, which is why I'm neither for nor against. I do not represent any client here. I was not paid when I had the idea to begin with, nor am I today, to be clear. I have researched the issues that have been coming up today. I'm happy to answer questions because I know I can't do it all in 2 minutes. That's also why I provided you some materials. But on home rule, I know that there are existing statutes that address some of these issues that have come up. Happy to answer any questions on that. Representative Campbell's question about what about other sources of energy, I can address that as well. The issue of, is this changing environmental standards? It is not. It's a procedural bill, not a substantive change bill. The labor point that was brought up by Mr. Cuddy and Mr. Shedlock, I can address that as well. There's no state law like a permitting bill that has those standards in it. And last and not least, I can also address precedent with respect to deadlines, how they're enforced or not enforced. And with that, I'm staying by my deadline of under 2 minutes. So thank you very much. Happy to answer any questions. And I will also give you materials that you'll have time to look at later. And I'll try to be at the work session once you decide when that's going to be.
Thank you, Mr. Thaler. Questions for Mr. Thaler?
And it goes by Thaler, by the way.
Thaler,
That's
sorry.
okay.
Thank you, Mr. Thaler. Yes, Rep. Sobolewski.
Thank you very much, Senator. Sir. Thank you. Earlier when the sponsor was speaking, Senator Martin asked him a question about the constitutionality of the home rule. He said that in number 6 on his testimony here, that the inhabitants of any municipality shall have the power to alter and amend their character on all matters not prohibited by constitution or general law. And he inferred that that general law is what allows that a bill be written to supersede the Constitution. Is that your legal interpretation of that?
No, it's not. I don't think a law can supersede a constitution because that would be unconstitutional. So let me give you an example. And this goes actually to your morning discussion about landfills and the need for more landfills in Maine, which again, I was involved with early on. There's an existing statute, 38 MRSA 1310-U, that says a municipality may not have stricter standards in an ordinance than the state when it comes to citing landfills. That has been litigated up to the Maine Supreme Court and upheld as not being unconstitutional. So the language about not being stricter than the state that is in what is in the sponsors amendment was also early on, it is not unconstitutional. And so I just want to clarify that, at least as I read the effort, it's not to wipe out home rule or not to say that a municipality cannot have an ordinance, but just like 1310-U, there's also the other thing, I'm sorry to go on at length, but just there is another statute, 30-A, MRS section 3001, that's the home rule statute, subsection 3. That says that municipalities cannot enact, it's a long day, ordinances, quote, that would frustrate the purpose of any state law, unquote. So that's existing law. So that is a limit in state law on what a municipality can do or not do. And that's constitutional as well.
So you're saying that's the argument for being able to write a law which will supersede that?
Well, I'm not sure supersede what. If a municipality,
home rule.
no, it can't overrule the Constitution.
I'm trying to understand it, where the legality is of being able to do it.
I think the legality
You're
is
perfect. You're an attorney, so.
Well, I'm trying to explain, and a former law professor. I'm trying to explain that, you don't have the power to ignore the Constitution. I don't either. I've represented towns all over Maine and Washington County. But the legislature has said, even under home rule, and home rule is also a state provision implementing the Constitution in 3001, that a municipal ordinance is not supposed to frustrate the purpose of any state law. Now that's general, that's a broad statement. I don't disagree with that. I didn't enact it. But the landfill law is one example. Totally different somewhat is what I think maybe you or others mentioned about affordable dwelling units or accessory dwelling units, or just last session in June, chapter 385 was the housing density law that was passed. That wasn't per se preempting home rule, but it was making towns do things they might not have wanted to do otherwise. So I know my town, where Mr. Representative Bell is, and others are now having to react to being told you must do X. I don't know if that'll be upheld in the Maine Supreme Court or not, but there's also that precedent.
Other questions for Mr. Thaler? I got it right.
You did get it right. Thank you. Thank
Seeing
you.
none, we appreciate you being here.
Thank
you. And thank you for the information about the court ruling. Very interesting.
Yeah, I can go on anything more later.
Okay. Okay. Neither for nor against, Ms. Gundrum?
Yes.
Thank you.
There's a lot before you. I'm not going to read it. Obviously, it's 5 pages long, so I'm going to summarize. Representative Dudera, Senator Tepler, members of the ENR committee. My name is Chess Gundrum, and I'm the Director of Advocacy for Maine Audubon, testifying NFNA on this legislation before you on behalf of our 30,000 members, supporters, and volunteers. Maine Audubon is a strong supporter of renewable energy development to help combat climate change. Policies that allow for the rapid deployment of renewable energy without unraveling the strong environmental regulations that safeguard Maine's natural resources from development are key to Maine's current and future biodiversity and climate resiliency. We believe this bill offers several logical and measured modernizations to the permitting process for solar energy and energy storage system developments. However, we take issue with several proposals. So I'm going to list those out quickly here. Section 1, the automatic approval, specifically for DEP. We respectfully disagree with this proposal to automatically accept applications for these kinds of projects should DEP not reach statutory defined review deadlines. You already heard from DEP why we oppose that as well, but there's some more information for you there. Section 2, permitting timeline revisions under Site Law, Natural Resources Protection Act, and stormwater management. We support the revised review deadlines for solar energy and energy storage system developments. However, we continue to oppose automatic approval, again, of projects that require review under these laws. Automatic approval, should DEP fail to meet deadlines, should be really reserved for PBR projects only, which is largely where it's held now. Sections 3, 4, 5, 7, and 10, that's the local standards and zoning ordinances pieces. This proposal is indisputably a bold and challenging concept to address. To our knowledge, there is some precedent, as you just heard, for legal limitations on municipalities enacting stronger environmental standards than state standards. That's for solid waste management, which you just heard about, and other kinds of critical infrastructure. Decisions regarding how to embrace development of these projects at the speed and scale they demand of us collectively must be made thoughtfully and with wildlife and human communities in mind. It's our understanding that well thought out solar and other renewable energy projects have been stifled by overly restrictive local standards or zoning ordinances in our state. This isn't good. Renewable energy development should not be singled out with disproportionately stricter and scientifically unfounded local limitations. And I will wrap up. There's a couple more points here, unfortunately, but just to close out this section, we respectfully, I'll stop now. Thank you.
Okay, questions for Ms. Goodrum. I'm going to ask Rep. Campbell to go first.
I'm gonna go first.
Yes, do you have another point?
Thank you, Representative Campbell. I'm going to take a breath and make just a couple more really quick points. Thank you. So for the
Ms. Goodrum said one.
One. Okay. One. So, all right, you heard my pieces about the local issues. Respectfully, just take a beat and let's review this in a different venue. And then the last point I would make relates to the PBR. So for Site Law, my organization has been vocal about our concerns about establishing a PBR for Site Law, as those projects that get reviewed under Site Law are only triggered when the project is 20 acres or more. Obviously, with the guardrails you see here now, that would be different, 100-acre projects, and you wouldn't be allowed to do a PBR for solar under these guardrails if triggered NERPA or Tier 3 wetlands review. So despite our reservations with this proposal generally, when carefully reviewed and established with adequate stakeholder feedback, and you heard that's going to be happening in this year, DEP rulemaking, we do see a role for PBRs under Site Law if activities are specific to lower impact renewable energy development projects. And we do, as a final closing point on this section, an area that's close to 100 acres in size that did not trigger NERPA review would hopefully very likely include areas that we enthusiastically support for renewable energy, like brownfields, landfills, sand and gravel pits, and other disturbed, developed, or degraded lands. Those are great, great, great places for solar. So a couple more points in there for you to peruse at your leisure. But thank you so much for your time and consideration.
Thank you, Ms. Goodrum. And I believe Rep. Riggio has a question for you as well.
Well, I will say that Representative Campbell beat me to it, but I would also have to observe that your initial 2 minutes of testimony reminded me of one of those radio commercials where they have to speed up the tape to get everything they're legally obligated to say within the 2 minutes.
Thank you. It is a requirement of this job.
Isn't that so? Thank you. All right. With that, thank you very much for your testimony,
Thank
Ms.
you.
Goodrum. And do we have anyone else, neither for nor against? Maybe some folks online? Okay, we have to turn to them first, and then our poor legislators who've been waiting and waiting will get their opportunity. I think he's neither for nor against. Welcome, Mr. Perry.
Thank you so much, everyone. Representative Dudera, Senator Tepler, committee members, it's so great to be with you. My name is Seth Berry. I live in Bodenham, and I'm here as the executive director of Our Power, which is a small Maine nonprofit that advocates for affordable, reliable, and locally controlled power. That mission is in conflict when it comes to this bill, because on the one hand, the measures that are proposed would help somewhat with affordability and arguably reliability, but they would certainly remove local control. So that's why I'm here, neither for nor against. Even with home rule, I want to note that big energy projects are possible here in Maine. If you take away home rule and local control, you really would eliminate the one tool that Maine communities have to stand up for their own interests in the face of development pressure by large, well-financed interests, many of which are serving load outside of Maine. And by the way, that load could be for AI data centers or for other purposes. Maine is only 9% of the regional load, and the generation projects that need to be built over the next couple of decades to serve projected demand, over 90% of that will be from out of state, and Maine is kind of in the crosshairs. So maybe last Sunday you saw an op-ed about this. Dr. Richard Silkman wrote in the Press Herald that Southern New England has an extreme thirst for clean energy, and that this thirst will grow exponentially in coming years. And Maine is where much of this new generation will need to be sited in order to meet the needs cost effectively. So we can throw open the door and become generation land, as Silkman puts it, or we can enact policies that protect Mainers and adopt community benefit standards to make sure that Maine is treated well in the equation that is in front of us. Just quickly, I want to observe that predictability is important to developers. If we were to adopt standards in Maine for community benefits, and they can take many forms, we could provide that predictability to developers and at the same time create a rising tide that lifts all boats. We can make sure developers know what the standard is, are all meeting it. They engage in competitive procurement, so they're looking to keep their prices down.
Thank you, Honorable Berry. You're out of time.
Thank you. I'll just end there and say that we are happy to help with whatever form you want to take with this bill and suggest benefits, specific community benefits that could make sure Maine is well treated if we go forward with something like this. Thank you very much.
Thank you, Mr. Berry. And I see that Rep. Riggio has a question for you. He and I were discussing the Dr. Silkman op-ed earlier.
And along those lines, I would invite the witness to provide us with some written thoughts with regard to the Silkman, let's call it the Silkman commentary on how Maine protects itself and potentially takes advantage in a fiduciary fashion on all of the energy resource we're going to have that we don't want to see exported out of Maine without some benefit to Maine. If you would be willing to do that, Seth, that would be helpful.
Absolutely. I'll bring something back for the work session, Representative Riggio, but just quickly, in my written testimony, which is online, You'll find the op-ed that I referred to. For those that are interested, it's I think pages 3 through 7 of my testimony. And then referenced in the testimony itself is a study which was recently done by the Northeast Grid Planning Forum. Our Power contributed to that work, and it really explores the kinds of community benefits which could help pave the way for the building that we need to do. And I think we all understand we need to build. And whether you think it needs to be gas pipelines or solar or wind, I think we can all agree we need more energy infrastructure, even to meet the demand we have now. Never mind the data center demand, which I mean, that is another topic, but it's coming, and it also needs power. So thank you. We will contribute as requested.
And any other questions for Mr. Berry? And Ms. Malsbury, do we have Rep. Berry's Honorable Mr. Berry's testimony in our packets?
Yes, I wasn't able
to. Okay, thank you.
Sorry, I have it electronic, but I will put it.
Great. Okay, great. Thank you. That's what I wanted to know. Okay. I think we have, is that it? Do we have anyone else online?
Yep, one more.
Oh, okay, great.
Good afternoon. Excuse me, been riveted to the testimony that's being given. My name is Kat Taylor. I'm a resident and property owner in Argyle Township, unorganized town about 20 miles north of Bangor. I have, hang on a second, I did actually write things down, and I will submit written testimony. I said I'm neither for nor against this bill because it has some good aspects and it has some questionable aspects, and they've all been covered here today. So I'll just add, as a Northern Maine resident, all of these projects that are planned seem to be in the north and be connected by long transmission corridors. I do agree we need more generation created, but we need behind the meter solutions for residents, just like LD 1730 that promotes battery with solar so that every resident can lower their energy costs and can have stable, uninterrupted power supply. And I do agree that Southern Maine has a thirst for renewable energy. Unfortunately, the North doesn't share that thirst. We are tired of being the target of renewable energy development that costs us money and takes away our land, takes away our views, and disrupts our wildlife. If you want to build renewable energy, if you want onshore wind, if you want solar farms, then they should be built in the South, because transmission corridors, T&D, is the most expensive element when you're developing new energy. So put them where they're supposed to be located, as FERC is making PJM do. If you want power, build it, use it. It has to be close to the user. This is the only way that we can avoid the ratepayer hikes that we're seeing in the inequitable arrangement we have right now in the return for equity with the utility companies. So I will be submitting written comments. And I appreciate your time. Apologies for being brief. I'm sure you won't mind.
Not at all, Ms. Taylor. Thank you. Questions for Ms. Taylor from the committee? Okay, seeing none, we appreciate your testimony. Thank you very much.
Thank you.
Do we have anyone else online, Ms. Malberry? Okay, I think now it's time for us to call our legislators who have been waiting, but Penny Beebe Center, Senator Penny Beebe Center is first up. Thank you. She asked first. First come, first served.
Thank you. Senator Tepler, Representative Dudera, and distinguished members of the Environmental and Natural Resources Committee. My name is Penny Beebe Center, and I have the honor of representing Senate District 12, which covers nearly all of Knox County. Today, I'm here to testify in opposition to LD 2174 as it is amended. I fully support accelerating renewable energy deployment in Maine, but this bill represents a dangerous and unprecedented assault on municipal home rule authority, the constitutional structure of our state, and community-driven land use governance. The Maine Constitution, Article 8, Part 2 states, each municipality shall have the right to exercise any function in the conduct of its local affairs except as prohibited by law. This guarantees municipalities the authorities to regulate local land use, include the ability to adopt standards stricter than state minimums to protect public health, safety, and welfare. LD 2174 explicitly overrides this constitutional guarantee. It's repeated notwithstanding any provision to the contrary, and void and no force or effect clauses that are categorical nullifications of municipal authority. This is not a minor regulatory tweak. It is a constitutional power grab. Blanket preemption is also bad energy policy. Renewable energy deployment is most successful when it is locally informed, predictable, and legally sustainable. A 2024 study by the University of Maine Renewable Energy Policy Lab found that 42% of utility-scale solar and wind projects were substantially revised due to local siting concerns, including setbacks, visual buffers, and soil protection. Municipal ballot measures from 2023 and 2025 also show that communities consistently want a meaningful say in siting decisions, not unilateral imposition. Natural data confirms that broad preemption often increases conflict. States with stronger preemption experience more litigation, delays averaging 8 to 12 months longer, and fewer negotiated community agreements. By contrast, states with clear local involvement frameworks see higher community support and faster compliance. Stripping local authority often slows development, the exact opposite of this bill's stated intent. The deemed approved mechanism in LD 2174 further rewards bureaucratic inaction. If a permit is not issued within a statutory deadline, it is automatically approved. This creates a perverse incentive. Agency understaffing becomes a licensing advantage for developers. Environmental review is bypassed and public input becomes irrelevant. This is not predictability. It is punishment for agency slowness, and it undermines state and federal environmental safeguards. In 2174, it also eviscerates municipal zoning authority. Currently, towns can adopt stricter setbacks, protect prime agricultural soils, maintain scenic and historic buffers, regulate stormwater and surface water impacts, and mitigate noise and wildlife disturbances. This bill would nullify that authority for renewable siting projects. Protections for aquifers, shoreline, historical landscapes, and unique community patterns would no longer exist. Maine courts have repeatedly held that home rule preemption must be clear and justified, yet 2174 does so expressly across municipal statutory frameworks with no demonstrated emergency or compelling state interest. This committee should reject or substantially amend 2174. If the goal is to support renewable energy, the legislature can do while preserving municipal voice and tailored local standards, meaningful environmental review, negotiated solutions that prevent litigation, and state-local coordination frameworks. Amendments could include removing automatic deemed approved provisions, allowing municipalities to adopt stricter standards supported by documented environmental concerns, and incorporating dispute resolution mechanisms before approval. In conclusion, I support renewable energy expansion. I do not support this constitutional overreach. LD 2174 in its current form undermines home rule, invites litigation, weakens community buy-in, and does not deliver predictability. The predictability it claims. For these reasons, I urge the committee to oppose LD 2174 as drafted and instead work on a balanced alternative that respects both state policy goals and municipal authority. Thank you for your time and consideration. I'm sorry I went over.
Well, thank you, Senator Beebe Center. I must say that one of the things about having to wait so long is that we don't run a clock on legislators. So thank you.
I wouldn't have read it so fast.
You waited till the end, but you got as much time as you needed. Are there any questions for Senator Beebe Center?
Thank you.
Thank you. Okay. And next up, Senator Searway. I'm just getting ready to drip again.
Go take a break.
Oops, this isn't.
Good afternoon, Senator Tepler and Representative Dudera and esteemed members of the Joint Standing Committee on Environment and Natural Resources. I am Senator Scott Searway and I represent District 16, which is comprised of Albion, Fairfield, Oakland, Waterville, and Winslow. I am here today in strong opposition to LD 2174 to defend the rights of municipalities to make their own decisions regarding citing ordinances for energy projects. Maine has a strong tradition of local control. We take pride in understanding the principle that decisions are best made by the communities impacted, and problems should be solved at the most local level possible. Unfortunately, the bill before you is a departure from our long-held beliefs, and it betrays towns who have passed ordinances in line with their values and plans for development. The town of Albion has an ordinance that requires lines to be underground. Other towns have guidelines on the siting of solar arrays. These policies were created after careful consideration, debate, and voting by members of the communities that created them. The member of the community should not have their decisions made null and void by an overreach of state policy. Local ordinances around energy projects often protect people's land and livelihoods. I know of 13 different farms in my district which would have lost land in proposed projects. Thankfully, in my district, and thankfully subsequent ordinances now protect them. Should this bill pass in its current form, these farmers will be at risk once again. In addition to protecting the values and economy of the community, these ordinances also serve to strengthen public safety. Many towns have fire prevention codes which are absent in the state regulations. Should this bill pass, the safety standards are overridden. Local fire departments and EMS may be stretched beyond capacity, forced into dangerous situations, or must fight fires without proper equipment. Each town has different sizes for fire trucks, different terrain, and access concerns and capacities for training. These unique situations simply cannot be addressed by a one-size-fits-all state policy. Maine is a large state with many different communities. Each community has unique conditions that require careful considerations. What is good policy in Portland might be harmful for Albion. What is good policy for Albion might be harmful for Caribou. Does this body not trust the people in each municipality to decide for themselves how to zone for energy projects? When we tackle problems at a state level that are best handled at a town level, we all lose. For these reasons, I urge you to vote ought not to pass, and thank you for your consideration, and I would be happy to take questions.
Thank you so much, Senator Searway, and thanks for your patience in waiting for us.
No problem. Thank
Do we have any
you.
questions? We do. Rep. Ankleys has a question.
Thank you. Did you make some deal with Senator Tepler to have the senators go before the House members?
No, I didn't. I do have a kind of emergency. I gotta go do another bill in criminal justice right now, my own bill, but yeah.
Okay, just checking.
That's what it was, really.
I think a deal was struck, and that's what we're here to do. I think she made a deal with Senator Bibi Center, so that's okay. Any other questions? No? Okay, thank you very much.
Thank you.
Okay, it's time for my fellow representatives. Come on up.
Oh, you saved the best for last.
Yes,
Okay.
we representatives like to say we're saving the best for last.
Yeah. Good afternoon, Senator Tepler, Representative Udera, members of the Environmental and Natural Resources Committee. Of course, I have remarks which you'll see, which honestly, after all these remarks are probably a little boring. So instead, I'll go ahead and tell a story about my communities of China, Windsor, Somerville, and Palermo, and about what they faced when transmission lines threatened to come through their communities and deface their fields, beautiful rolling fields of my district. I am incredibly proud of my district and these other rural districts that stood up and said, no, we're not going to let this happen. We are going to gather together. And they were so incredibly intelligent about how they took on the power line fight. They met night after night, day after day. They made signs professionally done. They talked about policy. They looked into legal ways of what they could do. And they took that and tackled that head on. And then what did they do? They went ahead and put ordinances into place in their towns. In Palermo, the electric transmission facilities ordinance, in Windsor, a utility scale solar ordinance, and in China, a solar energy systems ordinance. So they took the time and their resources in their town, and the intelligent people in that town were able to get together, and the people with heart to protect their towns, and they created these ordinances. And this bill would completely take their voice away. It says the time that you spent, the time that you devoted to protecting your town is not good enough for us here in the state, that we know better, that we know that if we go ahead and put a solar field in that field, your property taxes, your property values aren't going to go down when we know that they are. We know our towns best and our people know our towns best. By the hundreds, they came out, and at no time did they say, gee, we'll put all this work in, and if the state wants to change it, we'll go ahead and let them just because we're nice. I mean, this bill doesn't even talk about the talks that they should have with the towns, what they need to reach in order for them to override the towns. We had an eminent domain bill in our last session. We didn't completely take away eminent domain, but we put guardrails against it so they couldn't come in and just say, we're gonna take your field. And this bill doesn't just ignore their voices. It says, you know, there's no safeguards that we're going to put on for the ordinances you have. And so I'm asking you to look at this, and the permitting aside, that it's not respecting the people of Maine. If Southern Maine wants to go ahead and continue to look at renewable energy, then they can go ahead and do it, but they don't need to do it off the backs of our rural towns who care about their communities and care about their vistas and their water and their land, just like they did with PFAS and Fairfield. We care about those things, and we are overlooking that. I appreciate that you all are the Environment and Natural Resources Committee, but you're not in our towns, and we deserve to have that voice. Thank you very much, and please vote not to pass on this bill. Thank you.
Thank you, Representative Smith. Questions for Representative Smith from the committee? Yes, Representative Campbell.
Thank you for waiting all day.
I'm not used to
Appreciate
it, I
it.
must say, not being on a committee.
You had
so.
one more point.
Do I have one more point? No, I just think that we're doing a great disservice to the people of rural Maine. And so often the people of Southern Maine and their great energy consumption seems to override our needs and our desires. So.
All right, thank you very much. And thank you for waiting. I agree with Rep. Campbell. And one more legislator who's been waiting a long, long time. So thank you so much, Rep. Caruso, for being here and
thank
all
you.
day with us.
That's okay, just since 1 o'clock.
It got me out of judiciary for a little while, so.
Okay.
And they ended early, so I really didn't miss that much. Thank you very much for your patience and for your time. All right, so here we go. Good afternoon, Senator Tepler, Representative Dudera, and honored members of the Environment and Natural Resource Committee. My name is Elizabeth Caruso. I represent House District 72, which includes 9 towns and 20 townships and plantations in northern Somerset County. I live in the beautiful rural town of Caratunk, where I've served as the first selectman for over 20 years. Since 23, I have worked for Somerset Economic Development Corporation, which encompasses meeting with all Somerset towns on a variety of economic topics. And for the last 33 years, I've worked in the outdoor tourism and hospitality industry and even co-founded the Forks Area Chamber of Commerce. During my years in local government, Caratunk has enacted many ordinances, including the Caratunk Energy Systems Ordinance, which covers solar, wind, and transmission projects. I was also the principal author of our 2020 comprehensive plan. As you may or may not know, all municipal ordinances, which are select board approved, and land use ordinances, which are resident enacted, must support the comprehensive plan as approved and enacted by the local legislative body, the voters. In general, this bill seeks to extend the state's preemption for hydropower projects to all energy projects because, well, only energy projects that they picked, wind, solar, and storage and electronic transmission lines. Because hydropower projects can cross municipal boundaries and have wide-ranging implications under both state law and the National Clean Water Act, the Maine DEP has had long-standing authority to regulate this space. But make no mistake, the author of this bill wants to preempt local jurisdiction for all energy projects to create a fast track for project genesis and completion, including wind and solar. It makes no mention of the requirement to abide by the comprehensive plan of a municipality. By design, this bill would not just weaken home rule, but actually make statewide radical changes to how Maine towns operate, self-regulate, and whether Maine people have a say in where they have chosen to call home and/or establish their businesses and livelihoods. Specifically, the bill does the following. It prohibits municipalities from enacting and enforcing an ordinance, standard, condition, or requirement that's applicable to solar, wind, or energy storage development and high-impact transmission lines that is more stringent than your state statute or rule. It states that local regulation is void and has no force or effect if it violates this restriction. And as we've heard multiple times, I don't have to go through it, if the commissioner fails to issue a decision, the application is deemed approved regardless of any qualifying merit or criteria. It favors some, but not all, by creating special processing times. In essence, this legislation is unconstitutional, but first and foremost, it picks winners and losers. It only lists solar, wind, storage, electric transmission lines, energy sources except natural gas and nuclear. It prioritizes and favors for-profit corporations and developers over citizens who have exercised their constitutional rights to vote, thereby usurping and negating their voice, their rights, and their votes. Although I'm sure it was not the sponsor's intent, but this language disenfranchises our constituents by using the legislature to sidestep true representation of the Maine people. I can't tell you how many times I have heard Mainers complain about Augusta mandates and the dictatorship of state government by passing laws that disregard the democratic will of citizens on laws they actually raised their hands for, laws that were determined at the grassroots level. Many of us hold the view that Maine's vast land and privately owned landscapes can be of statewide value and interest. It's apparent that one's perspective of land value and interest can vary depending on where you're from, rural or urban, the county, coastal, western, or down East Maine. I fundamentally disagree with the premise of this bill that municipalities lack the perspective, passion, vision, or as the sponsor questioned our wisdom, and expertise to best guide decisions that effectively plan for our future. Local decisions are best made by local people, not those who live away or work hours away. Maine is not monolithic, and one size does not fit all. What's good for Portland or other urban areas is not the same as Kingfield, Searsport, Caratunk, Machias, or the county. So regardless of whether I look at these changes through the lens of a municipal officer or a legislator, it's terrifying and insulting. But as an elected local and state representative, I fear that there is no stopping the coming loss of rights if this bill passes. And so for these reasons, I strongly urge the committee to vote ought not to pass. And also I have attached the inside cover of my comprehensive plan. And as you can see there in the bottom of the picture, it's certified by the state of Maine, the Bureau of Resource Information and Land Use Planning. So for a comprehensive plan, it takes months and planning and money to make this happen. And it is developed in conjunction with the will of the people. And every town is different. So for example, the town of Caratunk is 53 square miles. It has 19 ponds and lakes, 6 streams and brooks. The DEP classifies our water quality as having no impaired waters. They are Class A. It is very different than Portland or some urban area. And there's no reason why someone sitting in an office somewhere should be able to determine what goes on in that town, especially when the will of the people was voted on. It was decreed when they voted on the ordinances. Our energy systems ordinance, we worked on, it took about a year and a half. We developed it with experts from KV-COG. It's 47 pages and it had public hearings. And there's no reason why it should be dictated and mandated from someone here.
Yes, thank you, Ms. Representative Caruso. Representative Dudera has a question for you.
Yes.
I just wanted to say hello.
Hi.
Representative Caruso and I met when I was in my first year on the Energy Utilities Committee, and she would come in and testify as a select board member. And my question is, do you remember those days? I sure do.
I certainly
years
do.
ago.
Yes.
Thanks for coming today, and thank you
yes.
for your patience with us.
Thank you very much. Appreciate it.
Thank you very much. Are there any other comments or concerns from anyone out there who wants to speak to this bill? And seeing none, are there any issues the committee would like to have brought to us for the work session?
I would like that Mr. Taylor to be here.
Mr. Taylor.
Taylor. Yeah.
No, sir, we just like you to be present if you could be.
Just let me know when, as soon as you can.
Okay, thank you. All right, well, that brings that public hearing to a close.
Sorry, wait. One
Oh,
thing.
sorry.
When we're just getting the analysis and stuff, because we've had so many suggestions and stuff, particularly where there's overlap, I would like to kind of see which groups kind of align with the certain suggestions or proposed amendments, whatnot.
I'm confused about who you're asking to do that work.
When presenting like for the OPLA analysis before us.
Okay, he should pick which groups chose which.
If there's overlap and
amendments.
stuff, I just want to see the overlap.
Okay. All right. Are there amendments that people can agree on? Is that what you're
Yes,
trying to
that's
say?
that's what I'm trying to,
Okay.
yes, that's what I'm
Okay,
trying to
thank
say.
you. All right. That brings our public hearing to a close. The committee will take a 10-minute break and come back for LD 474. I will do mine.
I appreciate
Takes longer than that to get to the bathroom.
We did a lot of work. Yours is closer.
Oh, yeah.
Why is that not
My son worked there for a couple of years.
I had a house in Bel-
Hi, everybody. Okay, we're going to get going right now on LD 474 and open up the public hearing on that. And to introduce the bill is our very own Senator Tepler. She's looking a little confused.
Again?
I'm sorry, we're on 2187. Maybe that's how I messed you up. I thank you to my right-hand man here who helped me with that.
So apologies, I don't actually have written testimony to introduce this bill. It is a department, well, it's a committee bill, but it was created by the department and the Board of Environmental Protection following the Water Quality Standard Triennial Review. And I am submitting an amendment to the bill. And the amendment is to include a section of the Androscoggin River from the Gulf Island Pond Dam in Auburn to a line formed by the extension of the Bath Brunswick boundary across Mary Meeting Bay in a northwesterly direction, and to upgrade that to Class B. That is the amendment. It is only that. And otherwise, the bill is as it was presented to us as part of the triennial review. Thank you. Questions?
Thank you very much. Anybody have any questions? Yes, Rep. Campbell.
Yeah. Yes, Representative Campbell.
Do you have another point you'd like to make?
I have a blouse you can have. Yes, actually, there is one point, there is a section of that section that I just referred to that already is Class B, but this changes a larger section to Class B from Gulf Island Pond to the Warumbo Falls, which is currently Class C. And I'm adding that and moving it to Class B. Also, I guess if I have to add anything, it would be that this seems like a very good time to do some water quality upgrades because federal law is not helping us here in Maine with water quality upgrades. So we have to do it on our own. Thank you.
Wait a minute.
Thank you very much. Any other questions?
Oh, no.
Yes, Senator Martin,
Okay,
what do
Senator
you want to say?
I have you now.
Yes, you do.
We talked about this before, and you didn't have it in the amendment. The stretch of river from the top of the Rumford Falls to the Rumford Point Bridge was, I asked if it could be kept the same classification as what it is above there.
That is not in this amendment, I believe, but there is from the Maine, New Hampshire boundary to the confluence with the Ellis River is Class B.
Yeah, and it should be all the way down to the, it's another 6 or 8 miles down the river to the top of the dam. And below that is the mill.
Okay, well, this just has it to the confluence with the Ellis River.
That's in Rumford Point. That's what I'm talking about.
Okay, so beyond that is Class C.
Yeah, it should be upgraded all the way to the dam.
And I'm sorry, but I don't know about that section of the bill. You'll have to ask the people who come behind me who wrote the rest of the bill.
Okay, thank you.
Thank you, Senator Martin.
Any other questions? All right, then. Thank you very much, Senator. Do we have the department to come up and speak on this bill, on this amendment?
Senator Tepler, Representative Dudera, members of the committee. I'm Brian Kavanaugh. I'm the Director for the Bureau of Water Quality at the Department of Environmental Protection, and I'm speaking in support of LD 2187. In the interest of time and noting that much of my testimony was discussed at the ENR briefing on this issue on January 21st, I will not be reading all of my testimony. If you're following along on the hard copy, I'm not going to read anything that's shaded out. This bill is the final state-based step in the triennial review process. The triennial review required by the Clean Water Act and Maine law is a comprehensive periodic review and potential revision of Maine's water quality standards. This current process was started by the department in March of 2024 with a request to any member of the public to submit proposals for potential changes to Maine's water quality standards. That was followed by an extensive public process that involved review of those proposals by DEP staff and the Board of Environmental Protection, or the board. The board conducted a public hearing and a comment period, a deliberative session, and finally a vote that resulted in the board's recommendations to the legislature in a formal report and in this bill. Maine's water quality standards describe what designated uses, such as recreation in and on the water or fishing, are appropriate for certain water body classifications, and which criteria and anti-degradation measures are in place to protect those uses. There are a variety of criteria that may be numeric or narrative. Examples of numeric criteria include dissolved oxygen, pH, phosphorus, and bacteria. And examples of narrative criteria include characterization of habitat and aquatic life. LD 2187 has 13 sections. I'll briefly summarize the sections with the intent that this summary can serve as a guide to the structure of the bill. You should also note that the board's report has detailed information regarding the water quality revisions proposed in the bill. As a high-level overview of the bill structure, sections 1 through 8 deal with changes, additions, or clarifications to water quality criteria. Sections 9, 10, and 12 deal with upgrades to water body classifications, and sections 11 and 13 are essentially non-substantive edits that clarify names and locations for certain water bodies. I'll briefly summarize specific water quality criteria proposals by the type of proposal and the section it is found in. The same type of proposal may be found in various sections by water class. Sections 1, 2, and 5 provide clarification of the department's existing interpretation of the narrative criteria for aquatic life of classes AA, A, and GPA respectively. Sections 2 through 5 add a pH range of 6.5 to 9 as criteria for freshwater classes A, B, C, and GPA respectively to be consistent with EPA recommendations. This is in addition to and consistent with the existing statutory pH standard that applies to the issuance of waste discharge licenses to fresh waters. Section 6 and 8 likewise add pH range of 7 to 8.5 as criteria for marine classes SB and SC respectively to be consistent with EPA recommendations. This is in addition to and consistent with the existing statutory pH standard that applies to the issuance of a waste discharge license for marine waters. Section 3 modifies the existing dissolved oxygen criteria for Class B. This change is based on recommendations from interested parties and department staff. The department and external partners have found that Maine's existing DO standard for Class B waters of 7 parts per million, or a saturation of 75%, is not always met, even in natural reference streams and rivers. This revised criterion is still appropriately protective of cold water fish and other aquatic life and supported by EPA's 1986 criteria. Sections 2, 3, and 4 clarify language for the existing dissolved oxygen criteria for Class A, Class B, and Class C waters to be consistent with the department's longstanding interpretation of the existing language for concentration and percent saturation. Section 7 clarifies language for existing designated uses in Class SC waters to be consistent with language used in other classifications. Moving on to classifications, Sections 9 and 12 each upgrade one water body from Class A to Class AA. Section 10 upgrades one water body from Class A to Class AA and upgrades 3 waters from Class B to Class A. These 6 upgrades were recommended by department staff, generally due to the high-quality habitat for endangered Atlantic salmon, good water quality, and largely undeveloped nature of the watershed. In summary, all the criteria changes and classification upgrades included in the bill were recommended by the board to the legislature. The board also provided additional information in the board's report cover letter that summarizes the board's final vote and thoughts on some of the water body classification proposals that received much public interest and testimony, but that ultimately were not recommended by the board. These were the Lower Androscoggin River, the Penobscot River, and Chandler Bay. I expect you may hear testimony on some or all of these today. In closing, LD 2187 is the result of an extensive public process. It contains a variety of recommendations from the board that would update Maine's water quality standards, make them more consistent with the Clean Water Act, and provide clarity, and to reclassify certain water bodies consistent with the latest data and highest use of these waters. I'd be happy to answer any questions now or at work session. Thank you.
Thank you, Director Kavanaugh. Appreciate it very much. Questions? Yes, Senator Tepler.
Yes, I would like to ask the committee's permission to ask a question, even though I brought this bill forward. I'm not really the writer of this bill. So is everybody okay with that?
No, should we take a vote?
I don't think there's a vote on that, but okay.
Yeah.
All right, yes, seeing no objections, I will ask a question. So, thank you very much for being here, Mr. Kavanaugh. I have a question about Chandler Bay. What is the current designation of Chandler Bay?
SB,
Okay, as opposed to SA.
yes.
Okay, I've heard some concerns from other legislators that the proposed land salmon farm in that area has the potential to degrade the water quality in Chandler Bay, which is also a source of lobster and other aquatic species that are harvested by Maine harvesters. Do you feel that maintaining Chandler Bay at the SB level is going to protect those waters when the salmon farm goes in, that there will be adequate attention to discharges from the salmon farm?
Yes, so that permit was ultimately approved by the department and then, or actually approved by the Board of Environmental Protection. It's drafted to be protective of the SB waters, all the criteria that it's currently classified as for habitat, aquatic life, dissolved oxygen, all the criteria that are required. That permit is protective of those uses.
Okay, and if it were upgraded to an SA standard, what would that do in terms of the way that you would protect those waters from effluent of any kind?
Sure. SA is essentially a preservation standard, so it does not allow any licensed discharges. So if it was upgraded to SA, that arguably it may be a legal issue, but it would not be able, that facility would not be able to discharge. It's not built at this point, it's licensed. I think they're waiting for this proceeding to end to see how it finally comes out. But if it was upgraded to SA, there could not be a discharge into those waters.
And if, one more follow-up, if there were potential harms to aquatic life in Chandler Bay as a result of discharge from that salmon farm, what sort of enforcement mechanisms does the department and the BEP have for those waters, for protecting those waters?
Sure. If it was due to a violation of the permit, certainly that could be an enforcement issue to enforce the permit, which can include monetary penalties and corrective actions. If it was operating in compliance with the permit and was causing non-attainment, there's the potential to reopen the permit and make it more restrictive to correct that.
Thank you.
And go ahead. Yep.
Thank you, Director Kavanaugh, for your stamina. I want to speak to the latest proposed amendment that Senator Tepler introduced. And I remember we had some conversation about this back the last time we reviewed this. I didn't come away with a clear understanding then, and I'd like to have one now as to what the potential impacts might be in this upgrade from C to B in the lower section of the Androscoggin on any licensed discharges, wastewater treatment facilities or private outflows. And also for my clarification, for those to be impactful, do they necessarily have to be in the section of the river that we're talking about reclassifying, or could they be upstream? Could there be impacts upstream to other discharges if this section of the waterway was upgraded in its classification?
Yes. So in any kind of wastewater licensing procedure, we have to make the finding that the discharge will not cause or contribute to non-attainment of the receiving water. And that's the direct receiving water, but also any downstream waters where we could measure or project the potential impact. So in this particular case, if the upgrade started at Gulf Island Dam and went down to Merrymeeting Bay, there's three discharges of size that are significant above Gulf Island Dam. That's a paper mill in New Hampshire. That's the Rumford Nine Dragons Mill, and the now defunct J Mill, which is under new ownership. There's no, at this point, that discharge is just from the treatment plant that is accepting stormwater and leachate from the landfill. And I believe there is discussions from the current owner or investigations of what could be developed there. It's not quite clear ultimately what's going to be on that property. So those are three discharges that we would have to take a look at. We have projections that we put from the last triennial review and consistent with this one in this triennial review package of projected reductions in limits. That's an example of an allocation that could be used to reduce the loading to ensure that the water flowing over or through the dam, which then is going into this upgraded section, it goes from Class C above the dam, if it was upgraded to Class B below, that the dissolved oxygen would meet the Class B standards. So there may need to be some reductions in the upper discharges. That example allocation I put that is in the report is subject to change because the J Mill now is a completely different facility than it was. So
was it the department's position up until this time, and maybe it still is, that you do not support this upgrade?
I would say it wasn't our recommendation to the board, but this is a multi-stage process, the triennial review. And each entity, the department, the board, and the legislature has a different role. And this was clear from the board's deliberations that they wanted to convey this to the legislature. So our role was looking at the data and asking, does the water body meet that next highest class based on the data that we have? And if the answer to that was no, we were generally drawing a pretty bright line and saying we weren't recommending that upgrade. The board deliberated on what their role should be. And my takeaway was they felt they should oversee our work, but not go into policy development and voting on an aspirational upgrade. If they didn't believe the water body was meeting the next highest class, they didn't believe they should necessarily make a recommendation, but they were kind of torn. There was a mixture of opinions from the board. And you can see that in their deliberations if you watch the video. So they pretty much endorsed the department's recommendations, but made sure that they conveyed to the legislature that you can certainly upgrade that water body if you wish, because either you believe it's meeting its class, the next highest class, or you believe it's close enough, or you believe you want it to be the next highest class. And that could be a goal or an aspirational. So that's within the jurisdiction of the legislature. You can do that. So it's at this stage, it's not the department's position to object or oppose
Okay,
that. It's really
so
a
that brings
policy
me
issue.
back full circle to what are the potential practical impacts of us as a policy body making this particular decision, which we typically defer to the experts to do.
In terms of the impacts, as we just talked about, there could be reduction in discharge limits for the facilities upriver of the dam, and below the dam, the one discharger of size is the Lewiston Auburn Clean Water Authority. And likewise, we put a potential reduction in the packet for them of about 25%.
So we'd be doing this without knowing that those things were going to occur or not occur.
Based on our evaluation now, our evaluation is if it was upgraded, there would be a reduction in Lockwood that would be required of about 25%. And for the up gradient mills or the upriver mills, that's a little harder to say exactly what that allocation would be because the J mill is no longer operating under the discharging as much as the current permit allows. There will be some sort of redevelopment there. The allocation this is kind of like a pie, right? It's a pie, and you have to. Everyone gets a piece of the pie, and the size that each discharger gets is also based on what the other ones get. So if the J mill needs much less now, that means there's more room or a bigger piece of the pie for the Rumford mill and the New Hampshire mill. So unfortunately, things are kind of in flux, so I can't give you a definitive answer, but the example we have in the report is an approximation of what it was when the J mill was operating. It'll be something different now.
Other questions? Yes, Rep. Ankleys.
Thank you, Madam Chair. Thank you for being here, Mr. Kavanaugh.
Sure.
Thanks for waiting all this time. I have a couple of quick ones. The first one's a little more complicated. Based on your current data that you did with respect to the lower Androscoggin, how often did your test results return meeting the Class B standards versus not? Like were there times when your test results indicated that it was consistent with Class B quality? And what's the ratio of like yes to no?
Sure. Much of the time it met Class B. There are isolated incidents there's different criteria. So we're looking at dissolved oxygen, bacteria, biocriteria, which is essentially the bugs in the water, and phosphorus. And all of those vary a little bit. For dissolved oxygen, much of the time it met Class B, and there were some isolated incidents where it didn't.
So follow-up, if I might, which is you mentioned 3 dischargers, and one of them is now defunct, or 3 major dischargers. The 2 that are not, if they're bringing it to a point where occasionally it's not meeting Class B standards, what are the consequences for them under a change, right? For how long do they have to bring it under Class B for them to have a sort of consequence from DEP or anyone else before, or do they have a grace period to kind of fix it or wait till it's later, wait till it passes?
Right. So this gets to the licensing requirements that we have to use to draft a license. One is if, the first point is if the classification changes, it's not an immediate reopening of any license that may be impacted. We generally do that when the license comes up for renewal, and licenses are good for 5 years. So depending on where these facilities are in the discharge cycle, any change may come within a few years. In terms of what changes are needed, we're required to draft a license based on a worst case scenario that's specified in law of assuming a low river flow. It's called the 7Q10 flow, which on average would happen every 10 years or so. High temperatures, and assuming that the dischargers are all discharging at whatever loads they're requesting. So it's kind of a reasonable worst case scenario. There's a lot of conservatism built into that, but that's the way the Clean Water Act and state water quality law is structured. So we have to, regardless of the attainment status of the water, we have to draft the licenses for the class that it is. So if it goes to Class B, we have to use that kind of worst case scenario, and the limits are based on that.
Okay. And then finally, was the vote unanimous by the BEP on that particular section of river that's addressed by the senator's amendment?
If you watch the video, they technically the vote was to endorse the report that you got that did not include an upgrade of the Androscoggin, the Presumpscot, or Chandler Bay. But in their deliberations and a straw vote, and that's spelled out in the letter, some people did vote for an aspirational upgrade of the Androscoggin and the Presumpscot. So there was a mixture of opinions amongst the board in a straw vote and deliberations. And they certainly want to convey to the committee that this kind of discussion is what they were hoping for, I think, and considering an upgrade, whether it's because you believe it currently meets that class or because you want it to.
Okay, one or two more questions. Okay, let's let the senator go and then this other senator.
Good evening.
Good evening.
The Androscoggin River from the New Hampshire line down to the Ellis River is one designation. And for 6 or 7 miles of river from the Ellis River down to the top of the dam in Rumford proper is another one. Can you
Yes.
tell me why that is?
It's likely because of the two paper mills that were there, the Rumford Mill and the J Mill. So
No, I'm sorry. I got to stop you right there.
Okay.
This is above the Rumford Mill from the New Hampshire line.
Mhm.
And the water is no different above or below where the Ellis River enters the Androscoggin in Rumford Point. And I think that maybe it was just overlooked, but I'd like you to look into, for the workshop, maybe designating that section of river from the New Hampshire line to the top of the Rumford Falls, all the same. Yeah, all the same
okay.
as what it is from New Hampshire, because that was classified like that, I believe, because of the Berlin Mill up in New Hampshire
Mhm.
and what came out of that. And that little section of river, I'm not sure that it would mess up anything inland fisheries and wildlife, but they have that down to that river as fly fishing only. And the fish, everything's come back really good. So I'd just like you to look at that and maybe make that designation for that last 6 or 7 miles. It's not going to hurt anything. There's no mills in that area.
So you're not asking for just above the mill down to Gulf Island Pond
No.
Dam?
From the New Hampshire line, all wilderness, down to the Rumford Falls.
Okay.
The highest falls, I believe, east of the Mississippi River. Yeah. Thank you.
Sure. Thank you.
Thank you. And if I'm still confused about what's appropriate here, but I have a question about the LA Clean Water District. And what kinds of changes are they required to make under current law to their discharges that would get them to the place where the river would be? What, I mean, even if we didn't upgrade the river now, let's say, are they under some legal obligations to make some upgrades to their discharges of various kinds that will improve the water quality in that area?
They are working on a combined sewer overflow project.
Yes, okay.
But
yeah.
anyone who has a combined sewer overflow has to do that. That's not based on the class of the water body.
Yes.
Other than that, they are licensed to discharge into a Class C water, and they have the infrastructure to meet the limits to do that. So there's no other requirements. There's no other requirements that POTWs continually upgrade their infrastructure just to increase the quality of their wastewater. There's standard requirements across the country for what all municipal wastewater facilities need to meet. And as long as that load fits into that particular water body, that's all they need to do.
But the project for the CSOs, will that result in fewer discharges into the river?
Fewer CSO discharges.
Fewer, but that's overall fewer discharges.
Yes, but it wouldn't impact the quality of their everyday discharge, what goes out of the pipe 24/7. That's, the CSOs happen occasionally when there's big storm events. That CSO project would reduce the number of CSOs.
If the river's already meeting B standards most of the time, what would be required of the district in order to have the river be at a B? Anyhow, I mean, would you maintain their current licensing, or would you have to reconsider their license?
Yes, so as we talked about before, we'd have to set new limits in their license to account for this more stringent criteria. So the big difference between a Class C water body and a Class B water body is the amount of DO that's required. And this standard is much higher for Class B than it is for Class C. So and LACWA has done some looking at this potential implication to them. I don't know if they're here today or not.
I don't think so.
No, okay.
No,
so
which is kind of interesting.
They are aware, and they've done some preliminary estimates with an engineer of what it might take to meet the limits that we said would be a potential limit for them.
Thank you. Appreciate that.
All right, any more questions? Yes, Rep. Campbell, sure.
Good question. The half a sentence, how is the Penobscot?
Mike's off.
Mike, please.
In a half a sentence, how is the Penobscot classified?
Most of it is Class B.
Thank you.
Okay, I think that's it for questions for you. Thank you very much,
Okay.
Director Campbell.
Thank you.
Okay, we don't have any other departments here to testify, right? So we will start right in with folks who are in favor of this bill. So please come up, and we are going to still do the 2-minute clock
I will.
because we are running late here. So thank you for trying to keep your comments at 2 minutes. That'd be great.
My name is Peter Rubens. I'm with Grow LA, the Grow LA River Working Group. We're here today to re-image the Androscoggin from the dirty Lou, L-O-O, up to the dream of Senator Muskie's Clean Water Act of 1972, swimmable and fishable. The Grow LA River Group has been volunteering through RWACS and Friends of Merrimack Bay DEP volunteer program of DO testing along the riverbank for the past 10 years. We have worked with both city administrations, creating walking history tour, trail, museum in the streets, along the walking paths connecting both cities, circumnavigating the Great Falls. The walking paths and history trail brings people downtown to enjoy our natural wonders. The two cities both have riverfront plans for the future, asking Brookfield for 40 timed releases over the Great Falls on Friday and Saturday evenings, and for kayaking at Dresser's Rips a mile downstream. Economics and aesthetics of re-imaging the river to Class B. Many people think that the river is still polluted, and reclassing to Class B will let the public know that the river is mended and invites them down to participate. It is interesting to note that Biddeford, Westbrook, and Skowhegan have all embraced the rivers and developed around them. Lewiston and Auburn both have these goals, with millions of square feet of old mill buildings available on the river to be really developed for housing and commercial use. Precedence has been set. Last triennial, we applied for Class B, and Class B was awarded from Warumbo, Lisbon Falls, down to Brunswick to Class B, and our exact same appeal was rejected up to Gulf Island Dam. We have continued to do the testing along with Friends of Merrymeeting Bay and worked with them on our helicopter testing this past season, and confirmed Class B on all testing runs. We have the data to prove it. The law says when a river meets a higher rating, it must be reclassified to a higher level and not allowed to slip back to degradation.
Mr. Rubens, if you
One
could-
point,
Perfect.
one
Oh, that's
sentence.
great. Go
Our
ahead.
appeal to the ENRC is to vote approval of LD 2187, include the Androscoggin from Gulf Island down to Warumbo in Lisbon as Class B to take effect this summer. Ed Muskie is my hero, and I hope we can put a smile on his face from his grave.
Thank you very much, Mr. Rubens. Hang on, because we might have
Oh,
some
sure.
questions for you. And thank you for your patience and waiting for us today. Do we have any questions for Mr. Rubens? Nope, it doesn't look like it. Well, thank you very much for your testimony. Okay, go ahead, Senator.
Thank you for being here, Mr. Rubens. Are you an economic development organization?
No,
No, okay.
we were saving the mill, and I'm a river organization.
Okay, thank you.
I'm the chair of the Grow River Working Group.
Okay.
All right.
Yep. Senator Tepler, Representative Dodera, members of the committee. I'm Ed Friedman. I chair Friends of Merrymeeting Bay. Thank you for the opportunity to be here. I've submitted extensive written testimony through the website. I'd encourage you to read that, both on behalf of FOMB and myself. They complement each other a bit. So I just wanted to say that I pretty much led the effort to do the intensive monitoring that was done to see whether or not Grow LA's proposal had the data to support it. We collected lots of data points, 7 flights. We're doing a 10 sample site profile in about an hour and a half from Warumbo impoundment up into Gulf Island Pond. To echo Mr. Thaler, more or less paraphrase, if you have questions about any aspect of it, I can probably answer that. Okay. And there'll be other people speaking to some specifics here. But the river met Class B standards 100% of the time in well over 200 data points. I want to touch on something else in the LD that we have an issue with, and that's Section 3, where the department talks about calculating Class B as a daily average. And we have a problem with that because the department is woefully and typically understaffed, underfunded. To a large extent, a lot of the monitoring around the state is done by volunteer groups like ours that operate under the DEP Volunteer River Monitoring Program. And that calculated as a daily average based on discussions at the BEP is really looking at continuous monitoring. I understand the benefits of continuous monitoring, but they're very high costs. Little hobo meter cost over $1,000. You have a ton of data to deal with. I'm very concerned about the either intended or unintended consequences of volunteer groups not being able to go out and provide these data anymore. Related to that, and so that language calculated as daily average really should be just calculated as a geometric mean, in my opinion. The other piece quickly is phosphorus. That came into effect in a rule change. I don't know that it ever came to the legislature or not, but that's a parameter well beyond the capability of anyone but a super expert, financially and technically. And so we have a problem with that becoming a required standard for Class B. It's not in the statutes.
Okay, thank you. Thank you for that, Mr.
So,
Freeman.
any questions?
All right, we'll check in on that. We've got a question from Senator Tepler.
Yes, Mr. Friedman, can you put just those two issues in writing to us? The 70-page testimony you sent is online and available to us. It's just has to be online. We didn't want to print it
Yeah.
for environmental reasons.
And there's a shorter piece that I submitted earlier this morning, just from me, that does speak to what I just said, but
Okay.
not with the specific language, but just that
Oh.
inherent problem with continuous monitoring.
Thank you.
Okay, do we have anyone else here who in favor of the bill? Come on forward. Great.
Sure, I've got all my body parts and notes, since I got 2 minutes now. I am Scott Sells. I'm an attorney and I work with Friends Mary Meeting Bay. So I have a client in this matter, but before you judge, I also grew up on a dairy farm. I know in the last hearing that I brought some points. But I'm speaking in support of the bill and particularly in support of the amendment that Senator Tepler has introduced. I'm taking my time to address really 3 points that relate to an important legal issue. One of which that we have some disagreement with the department on in connection with the statute regarding upgrades of classification. And mainly that the Clean Water Act and Maine's anti-degradation policy require that when the actual quality of any classified water exceeds the minimum standards of the next highest classification, that higher water quality must be maintained and protected pursuant to subsection 3, subparagraph B, and that the board shall recommend to the legislature that the water be reclassified to the next higher classification, and the site on that is 38 MRS 464 4F4. That's all part of materials that were submitted electronically, my testimony included, in case you need to do that. The other 2 points that I want to add with respect to that mandatory statutory language, going to the earlier comment on impacts, is that, yeah, it's as a policy matter, you do want to consider the upstream impact to dischargers, people that have permits to pollute the Androscoggin. I would submit, however, that the positive economic benefits of clean water to those municipalities through tourism, recreation, increased property values, and an increased tax base for more people that want to live there are equally important. And finally, I have 1 point, but I'm out of time. So I'll take your questions.
All right, I'll ask a question. Make your last point. I know it's very hard for especially attorneys to talk in 2 minutes.
I'm not sure how to respond to that.
I was married to one. I was married to one for 38 years, so I can say.
Or what I want to be remembered for saying. Well, the point that I would make is in terms of the impacts is that the department, as Mr. Kavanaugh spoke in connection with, what happens in the context of an upgrade to some of these dischargers, and what are the, clearly there's some financial impact that occurs, but it's not like a stoplight. Okay, this is something that can be phased in over several years, whether you're a water treatment discharger or a paper mill or any other discharger into the waters under the NPDES permit program that they administer, that the department administers. It's not an immediate, okay, you've got to automatically incur the cost to upgrade. And that's a very important part to remember, especially if you're considering the impacts to dischargers. That's my additional point.
Thank you. That is an important point. We appreciate
Thank
it.
you very
Thank
much.
you for being a good sport.
Thank you for being
Do we have any
patient.
other questions? Do you have any questions? Okay, thank you very much. Okay, you've waited a long time. Can't we appreciate it?
I was never on this committee.
So no treats for you. I do want to say how much I appreciate seeing the Honorable Denise Harlow's picture in this room. That sort of puts a little perspective on everything that we do. So, hello everyone, I'm Ken Ackley, son of Monmouth. Was here in the 128th and 129th. And my question for you is a big picture question. It's about what is a real crown jewel of Maine? And I think many people would say that might be Katahdin, Moosehead, or Acadia. Or maybe a real crown jewel is where a generation of people have made its biggest impact, faced its mistakes, and chosen to do better. The Androscoggin River tells this story. It's powered our mills, built our towns. It's carried our industrial mistakes. At its worst, it became a national symbol for pollution. And from that low point, something very extraordinary happened. The Androscoggin helped inspire Senator Muskie to the Clean Water Act legislation that has withstood 50 years of time and remains a cornerstone of our environmental conservatism. Maine has led the way with hard work. We've invested, we've upgraded our infrastructure, we've partnered with industry, we've restored. It's the recovery is measurable and visible. And for those of us who remember the old I-95 bridge crossings, it's even smellable. Upgrading this classification with the amendment accomplishes two things. First, it locks in the gains we've made. Second, it strengthens Maine's long-term prosperity, clean water, fuels, recreation, tourism, community investment in Maine, environmental quality, and economic vitality rise together. It's more about economy, though. It's more about money. This is about whether we pass the privilege of clean water on to our grandchildren. The ability to swim safely, fish confidently, take pride in a river that runs through our towns. So again, what's a true crown jewel? Is it only the places we've never touched? Or is it the river we nearly lost and have invested 50 years in restoring? That's a crown jewel too. If there's one river in Maine that is due an inspirational or aspirational upgrade, it's the Androscoggin River. Happy to take questions.
Thank you very much. So poetic and nice to listen to at the end of the day. Who has a question for the Honorable Ackley? Honorable Mr. Ackley. Anybody? Nope. Thank you so much, Ken. Okay, other folks who are in favor of this legislation, please come forward.
Good afternoon, Senator Tepler, Representative Dudera, and members of the ENR committee. My name is Luke Frankel, and I'm the staff scientist with the Natural Resources Council of Maine, and I'm here today to testify in support of LD 2187. I would like to start by thanking the Maine Department of Environmental Protection staff for their hard work that they put in during this triennial review process. It's been a thoughtful and transparent process throughout, and I'll just kind of skip over the next part of my testimony and just highlight some key points. For the water quality standards side of the triennial review, there are 3 key updates that we support that add clarity and increase protections. These include establishing pH criteria for all surface waters except for Class AA and SA waters, amending the dissolved oxygen criteria for Class B waters to be daily averages of 7 ppm and 75% saturation with a 6 ppm floor, and clarifying that Class A, B, and C waters must meet dissolved oxygen criteria both for concentration and percent saturation by changing or to and. And then over on the water quality classification side, the current proposal includes 3 upgrades from Class A to Class AA, as well as 2 proposed partial upgrades from Class B to Class A. We support all 5 of these upgrade proposals, but would like to recommend that the committee amend the current proposal to include complete upgrades for those 2 partial upgrade proposals, and also an upgrade of the Androscoggin River from Gulf Island Pond to Wumbo Dam from Class C to B, as has been discussed. I have attached several figures and tables to this testimony that display key water quality data for these water bodies taken from DEP's database that can help make the case for these upgrades. I know Representative Ankley, you mentioned a question to this point. I'd be happy to answer questions that you have about this data now or at the work session. And I'd also like to make a couple key points about why other reasons why you should support an upgrade. For the two partial upgrades that I'm proposing be elevated to full upgrades. They're in the Sandy River watershed. As you heard, that's a critically important area for endangered Atlantic salmon. And these upgrades, even though they're tiny streams, would represent would allow, if upgraded, for 46% of the watershed to be to meet Class A standards or greater. And so I see I'm out of time, so I'll leave it at that, and I'll gladly answer any questions that you have.
Thank you, Mr. Frankel. Any questions? Okay, I don't see any.
All right.
Thanks very much.
Thanks.
Ciao for now. Bye. Who's next?
Senator Tepler, Representative Dudera, and members of the committee. My name is Stephen Hines. I reside in Cumberland and coordinate FERC matters for the Maine Council of Trout Unlimited. TU represents 6 chapters and more than 1,500 members dedicated to conserving, protecting, and restoring Maine's cold water fisheries and watershed. Maine TU members fish, boat, guide, and recreate throughout the Androscoggin watershed, and the organization has been deeply involved in hydropower relicensing and river restorations across the basin for many years. I also submit this testimony in my personal capacity as an angler who regularly fishes the Androscoggin River from Brunswick to Turner to wade fishing it at Gilleria. The Androscoggin is one of Maine's great fishing rivers, and its recovery over my lifetime has been remarkable. I am testimony in support of LD 2187 only if amended to include the proposed reclassification of the river. The legislature must correct an error. The legislature has a responsibility to correct a decision that failed to follow both the plain language of the Maine statute and the uncontested water quality record before the Department and Board of Environmental Protection. Maine law is explicit under Title 38, and Scott Sells just explained it. Extensive sampling demonstrates that this segment of the Androscoggin River meets Class B dissolved oxygen and bacteria standards under real-world operating conditions, including during drought conditions. The legal trigger for reclassification has therefore been met. This is not a policy preference, it's a statutory requirement. The classification must follow actual water quality. The Androscoggin was once a national symbol of pollution. Today, it represents one of Maine's greatest recovery stories. DEP's rationale was improper. Water quality classification decisions must be based on actual water quality and designated use attainment, not speculative maximum discharge scenarios, which is what we just heard the commissioner get up here and explain to you. This is important now, and it's because multiple hydro projects within the Androscoggin watershed are currently undergoing relicensing. As the committee knows, FERC licenses last for 30 to 50 years.
I have to ask you to wrap it up. Thank you.
So in conclusion, the science is clear, the statute is clear, and the public benefits are clear, which I wish I would have had time to tell you about. But on behalf of Maine Council, please amend LD 2187 and urge its adoption.
Thank you. And we do have your written testimony, which is great. We can finish. Did you have a question, Rep. Ankeles? Go ahead.
Thank you. Did you have one more point you wanted to make?
Well, I'd just like to tell you what all the benefits that would ensue from reclassification are. We're going to lock in decades of successful water quality recovery. We're going to protect fisheries restoration investments. We're going to support
Atlantic salmon recovery efforts and river connectivity projects. We're going to strengthen recreational-based local economies. We're going to provide regulatory certainty based on real conditions rather than some outdated assumptions. And we're going to protect and enhance one of Maine's premier warm water and emerging cold water recreational fisheries.
Thank you, Mr. Holmes. Thank you so much. Do we have any other questions? No. Okay, thank you very much for being here. Who's next? So we can keep moving along.
Sorry.
Oh, really?
How many more folks do we have in the room who are going to testify? Okay, and how about, do we have any opposed? No. Okay, go ahead, sir.
All right, thank you. My name is Charles Spies, and I want to thank Senator Tepler and Representative Dudora and the members of the committee for allowing me to testify today. A lot of what I was going to say has been said, so I'm going to work on my 2 minutes and just highlight what is essentially important to me. I'm a resident of Brunswick. I live on Water Street. I've spent 40 years raising my family in the lower Androscoggin watershed, including many years in Topsom. I can't help but say my wife grew up on a dairy farm in Turner, and that's important to me too. And she is a fantastic family. As further background, I'm one of the volunteers that collects water sample on the river. I'm also the president of the Free the Andro Coalition, which has 5 founding members. That includes Maine Rivers, American Rivers, Friends of Merry Meeting Bay, Trout Unlimited, and Restore. And we're focused on helping improve fish passage at the first dam at the head of the river as part of the Federal Energy Regulatory Commission's relicensing there. And that's been well documented for almost 50 years now that it does not pass migratory sea-run fish to their native spawning grounds. A lot of facts have been made. I think the ones that I won't reiterate those. What I want to say is build on the 54 years of rebuilding the Androscoggin River and what it means. I have a 4-year-old who lives on the same street as I do. I own property on the river. She's at my house right now having dinner with my family, and I'll get the leftovers when I come home. But she's there, she's living. We swim in the river, and I want to see that there for her when she's my age and hopefully still in the area. A couple anecdotes. A lifelong resident of Topsom, whose father worked in the mills there. She was never allowed to ride her bicycle near the mill back in the 60s because her family didn't want her near that smell or the taint. Another person who grew up in Brunswick, who could look upstream from the dam with her house, and I'm going to be out of time in a second, and I would like to just make one more point if I could. She could observe the Black Bridge where cars used to be able to drive across. And at times, back in the 50s and 60s, cars would stop, they'd get out, and they'd empty their trash into the river. These things are unthinkable today, but there are worse stories. And what I worry about is, as was stated by someone else, many of the folks that live along town or have lived there for a long time still avoid the river. So after what didn't happen overnight, but literally took generations to arrive at, I think it's very important that we do recognize that the data and the legal arguments support upgrading of the river. And I ask that you approve the legislation as amended for that section from Lisbon up to Lewiston. And I could say more about restoring migratory fish, but a lot of it's been said, and what I'm saying to you from the heart right now is I think it's really time to lock in those improvements of what's been a very long road to create something that is much better than the last generation had, that we get to appreciate now, and hopefully make even better for the next generation. Thank you.
Thank you very much for being here with us today. Mr. Spies, do we have any questions for him? Spies, questions?
Don't call me late for dinner.
That's okay, I hear you. You are late for dinner. Thank
Tell
you very
Bonnie
much.
to save me some dinner.
Yeah, thanks for being here. Okay, Mr. Ferdinand.
The testimony, I'm Bill Ferdinand, you know that. I'm a lawyer from Brunswick. I'm here for the Forest Products Council. And because we're limited time, I'm going to jump right. We support the bill as written. We don't support the amendment. The issue, you guys are getting right at the issue. Can this river attain the Class B standards the way DEP does them? What you're hearing is a lot of data coming from people saying it meets that standard now if based on water quality, but the way the department does modeling for attainment standards and for permitting purposes, it does not meet that. And in order to meet that, the discharges that we represent in our membership would have to make significant changes to meet more restrictive requirements for dissolved oxygen in particular. You have Gulf Island Pond and a dam that are next to each other that have this dynamic that even if you went to zero on the discharges, that wouldn't meet that standard the way DEP measures things. If you get in this situation where, according to the EPA standards and the way the DEP does their standards and modeling, you'd have to go into a total maximum daily limit situation where you figure out how much carrying capacity the river would have and divide that among the people who discharge, including non-point source pollution. That means everybody. That means stormwater. That means so the ramifications of moving this, even though we have data showing that it meets that that water quality level now, the way we do permitting in the state of Maine would have to change in order to avoid those impacts that I'm talking about. So as you think about this, think about whether you're asking the DEP to change the way they do things so we don't have those impacts. Otherwise, you're going to have those impacts, which are significant.
Okay, thank you, Mr. Ferdinand. Thank you for coming in on the 2 minutes. And we got some questions. Senator Tepler.
Yes, thank you very much, Senator, I'm making you a senator, Vicky, Representative Dudera, Chair Dudera. Thanks for being here, Mr. Ferdinand. Mr. Ferdinand, is there a reason why the triennial review comes before this committee?
It's a Clean Water Act requirement, and you are and DEP administers it, and you oversee DEP.
Right, and we are the policy setters in this case, I believe. Is that true?
Right, and where are you going with this?
I think I've gone where I want to go.
Okay, well, yes, you get to set that policy. I'm just trying to make sure, it has to follow a EPA set standard. So I would ask the department, what is their latitude to be able to move things around? I don't know how much they have. As Brian said, if we do this, then we'd have to revisit the permits and we'd have to do these things. And even if you do those things, would it attain the water quality standards the way they measure it? I don't know. So.
Other questions? Yes, go ahead. Rep. Rajeev.
So, Mr. Ferdinand, you represent the Forest Products Council, presumably that you're speaking on behalf of the mills. And are you testifying today that your clients believe that there would be burden placed on practical burdens placed on the mills as a result of the upgrading classification of this section of the Androscoggin from C to B?
Yeah, as Brian Kavanaugh explained, when they look at those discharge permits, if it's at Class B, the DO standard is much higher. So they have to crank down what they discharge into the river. And which has, can you do that? Is there, what are the cost implications of doing that? And even if you do that, does the river attain the standard?
Follow up?
Yes.
All right, so I guess what I'm trying to get at is has there been any effort to quantify what the fiscal impact?
How much would it cost?
Yeah, I guess that's another way of putting it.
I don't have an answer for that, but I can get it.
That would be helpful.
Yeah.
Any other questions for Mr. Ferdinand? Okay, I don't see any. Thank you for being here and your patience. Who else do we have?
Yeah, good evening. Senator Tepler, Representative Dudera, and members of the committee. My name is Scott Reed. I live in the town of Turner, and I serve as Director of Environmental Compliance for ND Paper. Appreciate the opportunity to testify in support of LD 2187 as it was originally proposed. So ND Paper owns and operates the Rumford Paper Mill, which has been operating in the valley since 1901, and we employ more than 450 people. Over the past 2 years, DEP has led a thorough, transparent, science-based review of water quality standards. This work included public proposals, comments, hearings, scientific analysis, revisions, and ultimately a unanimous vote from the Board of Environmental Protection. I've spent my career focused on environment in an industry that relies on rivers. The stewardship of these waters and the viability of the mill are both important to me. The recommendations that emerged represent a thoughtful balance of science, environmental stewardship, and practical implementation. DEP's evaluation shows that the Androscoggin does not meet Class B under all conditions, particularly the conditions that they are obligated to demonstrate compliance, which is high temperature, low river flows, and maximum discharge. For an upgrade to Class B would impact all point and non-point sources upstream, industrial, commercial, municipal, and agricultural, as well as dams. So a shift to Class B would significantly reduce our permit limits. According to DEP, it could reduce our permit limits by more than 50%. So from an operational standpoint, while we typically operate far below our permitted levels, these tighter thresholds will create challenges that we cannot meet during certain difficult conditions, such as upsets or process upsets. So we operate a 34 million gallon per day wastewater treatment system, and permit reductions of this magnitude would require major new infrastructure and equipment and substantial cost to comply.
It looks like you're almost done,
Yeah,
so I'll let
so
you wrap up. Thank you.
I'll wrap up there and be happy to answer questions from the committee.
Yeah, I think you had one more paragraph, so maybe you want to just quickly sum it up. Thanks.
So it's important that the recommendations developed by DEP and the board and adopted by the legislature are grounded in science and provide a stable, well-considered framework for stakeholders like ourselves to plan responsibly while we invest in environmental performance. I will wrap up there, and I'll take questions from the committee.
Thank you very much, sir. Do we have any questions? Yes, go ahead, Senator Martin.
Hi, how are you doing, Scott?
Good, thank you, Senator.
Long time no see. What exactly would it entail for the mill to have to upgrade to take care of this Class B classification that they're talking about? Do you even have the land or the infrastructure to put in more clarifying tanks and stuff like that?
So thank you for the question. So according to DEP's estimate of what we've been told, a reduction of 50% is not something, so we operate at a 95% treatment efficiency. So it's a matter of increasing the infrastructure, which is literally doubling the size of our treatment plant, which is large infrastructure, millions of gallons of capacity to add. So there's a substantial cost to that infrastructure. And you bring up another good point, which is there's a lot of other considerations, such as just the real estate available to do that kind of an upgrade at our facility. We're located on a peninsula.
Okay, well, thank you very much. I just wanted people here to know on the board that there is the mill up there does a really good job when it comes to their water. 40 years ago, I was a hard hat diver, and I dove in the clarification tanks before fixing some of the liners and stuff on the clean end of it. And I never got sick once, but they really do have a good running unit up there. Easy on me now. Okay, thank you.
Thank you.
Thank you. Yes, Senator Tepler.
Yeah, I have a question. excuse me, not for you, sir, although I appreciate being here, Mr. Reed, but in fact for DEP. I guess I'm confused and would like to know for the work session, why a river that even by DEP modeling standards meets the B quality standards 99% of the time would require a 50% reduction in the outflows from upriver effluents. And it just completely confuses me, and I think throws a monkey wrench into our understanding of how we gradually move to clean water. And I'm very sympathetic with the idea that we want to keep our mills and want you being able to work. I don't understand how this translates through that. And so I'd like DEP to really respond to that fully at the work session.
Okay, noted, I'm sure yes, noted. Okay, great. Any other questions? All right, thank you so much for being here.
Thank you.
Do we have anybody else? Because we want to keep moving along here, so please come up as quickly as you can. And maybe the next person can be ready to go, so we're ready to move along.
Representative Dudera, Senator Templer, members of the ENR committee. My name is Chess Gundrum, and I'm the Director of Advocacy for Maine Audubon, the state's oldest and largest wildlife conservation organization, testifying in support of this legislation before you on behalf of our 30,000 members, supporters, and volunteers. You've already heard, as you're aware, DEP reviews the waters of the state and recommends improved protections for appropriate water bodies. And these additional protections involve a higher level of classification, which means a higher level of protection from pollution. Maine Audubon expresses our support for LD 2187, as its passage is instrumental in better protecting critical and beloved rivers and streams in Maine for generations to come. Through authorizing the Maine DEP to upgrade water quality protection and classifications, Maine will increase environmental protections for key rivers and streams across the state, and these protections will continue to safeguard our environment while ensuring our rivers and streams remain available for broad uses. In addition to our support for all proposed upgrades, we also offer our support for the identified sections on the Androscoggin River as well as the Sandy River, upgrades to both of those rivers. And I detail that in my testimony. Maine currently has the last remaining wild population of Atlantic salmon in the U.S., and the Sandy River in particular contains some of the best Atlantic salmon habitat in the state. Because of the dramatic decline in this iconic species, it's currently listed as endangered under the Endangered Species Act. Many efforts are underway to reverse this negative trend, including this upgrade. And LD 2187 represents one of many actions that would help. Communities and ecosystems across the state will benefit from the passage of this bill. We urge the committee to support it and consider our suggestions. Thank you so much for all of your time today and patience and consideration.
Thank you, Ms. Gundrum. Appreciate it very much. Okay, any questions? No, thank you for being here. All right, I think we're winding down. Is there anybody else who wants to speak in favor? Okay, do we still have anybody online? Okay, two people. Oh, what did I say?
Somebody
That's in favor?
Opposed.
Oh, yeah, we're gonna do that, but first we're gonna do the in favor people online.
One.
Okay, perfect.
Good evening. Can everybody hear me?
Yes, we can. Go ahead.
Good evening, Senator Templer, Representative Dudera, and distinguished members of the committee. Thank you for the opportunity to testify today. My name is Heather Kenyon. I'm the Science and Advocacy Associate with Friends of Casco Bay. We work to improve and protect water quality in Casco Bay and its watershed. We collect data and we use it to identify problems and inform solutions. I'm testifying in support of LD 2187, specifically the proposed changes to dissolved oxygen criteria to Maine's fresh water quality standards and the proposed addition of pH criteria to marine water quality standards. With regard to the dissolved oxygen changes, we specifically advocated for these changes, which are necessary to eliminate confusion and to reflect the modern and preferred method of continuously monitoring water quality criteria. The language as written stated parts per million or a saturation amount, whichever is higher. However, that language did not reflect the department's longstanding practice to apply both concentration and saturation components of the criteria in attainment assessments. Changing the language to be in line with how the department applied the standard makes good sense. We also advocated for changes to the Class A and B DO criteria to reflect modern continuous monitoring methods. The strict 7 ppm criterion was leading to challenges for us when evaluating water quality, particularly when continuous data sets are available. With regard to the proposed addition of pH criteria, we are quite pleased. Ocean acidification is one of our top priorities, and we spend a significant amount of time and resources monitoring this issue. pH serves as a useful proxy for the chemical conditions that determine whether marine organisms can survive and reproduce, specifically shellfish, oysters, and other calcifying organisms. We maintain 3 continuous monitoring stations in Casco Bay that collect various water quality parameters, one of those being pH. Our station in Yarmouth has been collecting data every hour for 8 years and every 15 minutes for 2 years. The pH data from that station indicate a statistically significant decline in marine waters. We also collect bottle samples of marine water that we pair with the pH data to understand how saturated the water is with calcium carbonate, which is a building block for shell-forming organisms. Our data indicate that for approximately half the year, the water is not saturated enough for healthy shell building, and I know I'm approaching my time. We all love Maine shellfish, so we are happy to see the pH criteria proposed addition. Thank you. and
Thank
I'm
you,
happy
Ms.
to take any
Kenyon.
questions.
Thank you very much. Anybody have any questions for her? No, thank you so much for hanging out with us online and your testimony.
Thank you.
Okay, so we are all set with those who are in favor of the bill. Now we will go to those who are opposed to the bill. So if you are here and opposed to the bill, please come up. And you can start right off. Thank
All
you.
right. Senator, Representative, honored to be here. My name is Kelton Beal, and I'm a fisherman. I live down in Jonesport. I have a house on Chandler Bay, on the other side of the road, so it's cheaper. And I am not actually opposed to this bill. I'd just like it to be amended to include the recommendation of reclassifying it to Class A. I've lived there my whole life, and my family's worked it for generations. I can testify the bay is highly beautiful and highly functional. The water is vacation quality, and the area has never known significant pollution. Lobsters, scallops, clams, we got birds, coastal marshland. Now, given that Dr. Krumholz's work shows the water meeting and exceeding SA standards, why not redesignate it now that the data is available, or is more data needed? And if you're not going to redesignate it, I guess what's the point of having an SA designation? But that's pretty much all I had to say. Thank you for your time.
Hang on, Mr. Beal, we might have some questions for you, right? Jonesport's a lovely town. I had a really
Oh,
good friend who lived there for a long time. Do we have any questions for him?
Yes.
Yes, okay, go ahead, Rep. Brigio.
So I just want to make sure I understand your message.
Oh, yeah.
Because you traveled all the way down here and you sat here all day today. And I commend you for that. You're up testifying in opposition
To the bill, I'm for it in spirit, but I think it should be amended to move Chandler Bay to a Class A quality. I
As
thought that it
opposed to
deserved as an SB, which is the generic one, I think, because the testing takes money and takes time. And now we've got the data and people bringing you the data for free. And
Okay,
I
so
mean, why not?
you want a higher classification? For the
Yes,
A.
I think it deserves it.
Just checking.
Yeah.
Okay.
Oh, sorry, I thought I made that a little more
No,
clear, but
No, that's
but yes, that's why I'm here.
now I get it. Thank you very much. And again, thank you for coming.
Oh, certainly.
Thank you, Rep. Brigio, for clarifying that. Great. Thank you, Mr. Beal. Do we have anyone online who's opposed? Oh, we have someone else. Great, okay.
Okay, hello, Senator Tepler and Representative Dudera. Thank you very much in committee. Thank you very much. My name is Addie Fisher, and I am here on behalf of Protect Down East, which is a local coalition of fishermen, clammers, residents, and people who care deeply about and depend on Chandler Bay. I respectfully urge you to amend LD 2187 to upgrade Chandler Bay from Class SB to Class SA waters. For over 4 consecutive years of monitoring by the Darling Marine Center, Chandler Bay has demonstrated exceptionally high water quality that meets or exceeds Class SA standards. Their 2025 summary concludes that the bay continues to maintain pristine conditions and qualifies as waters of outstanding ecological importance. But this issue is about more than water chemistry. It's about ecological significance and a unique body of water that has been sustaining heritage fisheries in this region for generations. Chandler Bay and its tributaries meet the statutory definition of an outstanding natural resource due to their exceptional water quality, abundant eelgrass, designation as an essential fish habitat by NOAA. Essential fish habitat is not a casual label. It identifies areas that are critical to the survival and recovery of federally managed species, including the endangered Atlantic salmon. Chandler Bay is home to 17 out of 22 endangered finfish species, an incredible claim. A majority of Maine's endangered finfish and marine life depend on high-quality coastal habitat at some stage of their life cycle. Clean, oxygen-rich waters and intact eelgrass systems, like those in Chandler Bay, are not optional. They are foundational to species survival. Maine's anti-degradation policy is clear. When actual water quality exceeds the minimum standards of the next highest classification, that higher quality must be maintained and protected. Chandler Bay is already functioning as Class SA waters. Reclassification would not change its character. It would simply align with the legal standard with the ecological reality and ensure that this pristine system, its endangered species habitat, its eelgrass beds, and its local fisheries are protected and can continue to flourish. The question before you is not whether Chandler Bay is exceptional. The data and the state's own ecological designations make that clear. The question is whether we will protect it accordingly for generations to come. I respectfully urge you to amend LD 2187 and upgrade Chandler Bay to Class A. Thank you very much.
Thank you, Ms. Fisher. I have a question for you.
Yes.
Was Protect Down East involved in the extensive public debate that went on earlier that the department engaged in with, did you talk to the Bureau or?
Oh, Protect Down East did not. Protect it was in an ancillary fashion. It was Eastern Maine Conservation Initiative that wrote the original petition, and the director was not able to come today. And so she did submit an extensive write-up in via online. Yeah.
Thank you. Thanks so much for being here. Questions? Yes, Rep. Reggio.
Just a quick curiosity
Yes.
question. Do you live in Ms. Fisher?
I
in
do
that
not
area?
myself live there. I live in Portland, Maine, but I have grown up and spent 55 years in that region, Jonesport and Beals, and my family has been there for 9 generations.
Thank you.
Okay, thank you.
Anyone else with a question? Oh, hang on. No, I'm sorry. Nope. Nope. Go ahead. You're getting your exercise. Yes, Senator Tepler.
Yeah, I think I'm feeling like we need some clarity on the law here and understanding the purpose of our clean water standards. I mean, if Chandler Bay is already at an SA standard, but it's classified as SB, and any development, I mean, I guess I'm wondering about how we make the compromises between development and clean water in a way that really makes sense. And I think I need more information about that and more clear understanding of the department's role in that and what we're doing. Because it's very confusing to me that we have this situation where things like Chandler Bay are very pristine, but it's classified as SB. And development on the edges of Chandler Bay would be created in a way that would be SB, but that might degrade the water. or it might not degrade the water. I'm very confused about that. So I need more information in order for me to make sensible decisions about this water classification and reclassification. Thank you.
Thank you. I think that would help all of us out. So thank you. Do we have any other? Okay, we don't have any questions because nobody's up there. Is there anyone else who would like to speak in opposition to the bill? Is there anyone who would like to speak neither for? Okay, there's somebody online, and then we'll go to neither for nor against if there's anybody for that. So let's go to our online person, Mr. Krumholtz. Go ahead.
Hi, good evening. Thanks for having me. My name is Dr. Jason Krumholtz. I'm representing Remote Ecologist, an independent consulting firm. I apologize for being remote. We got about 30 inches of snow down here in Rhode Island, and we don't handle it as well as you guys do up in Maine. I'm here to summarize the new work we did in support of reclassifying Chandler Bay as SA. The full report was submitted as my testimony, but the core question we set out to answer here is, can we distinguish water quality between SA and SB waters in Maine, and then use that to predict whether a given water body, in this case Chandler Bay, should be classified SA. So we aggregated about 30,000 statewide coastal water quality observations. We used most of that data to train a random forest model. Basically, we fed it data. We asked it to produce a score for how SA-like a water body is, and then we optimized it to determine the best predictors between excellent and good water quality, because SB is good water quality. The model assigns the highest weight to enterococcus and dissolved oxygen, with lower but meaningful weight to parameters like nutrients and pH. This is really encouraging because entero and dissolved oxygen are two parameters for which Maine has quantitative SA thresholds. So we're measuring the right things here. As an aside, this also suggests the state needs more entero data. It's a powerful predictor of coastal water quality, but fewer than 10% of our observations that we're able to get include entero measurements. We then tested the model on a separate data set. You can't test a model on the data you use to train it. That's like giving students the answers to a test and then telling yourself you're a good teacher because they all got A's. So the model correctly identifies SA waters about 83% of the time. That's really impressive to me because SA classification also involves some factors that aren't just about water quality, and also because most of the state's waters are SB. Only about 13% of our data come from SA waters. So a model that's randomly guessing SA would almost always be wrong, and we were right. The model's right 83% of the time. Finally, after we did that, we ran Chandler Bay's water quality through the model, the water quality collected by the Darling Center that you've heard about previously. Our model scores range from 0 to 1, where high scores mean more SA-like water. The median score for SB waters in our data set is 0.28. For SA waters, it's 0.71. Chandler Bay's median score is 0.83, which means it more closely resembles the quote-unquote ideal SA water quality conditions than the average of all waters in the state currently classified SA for which we were able to get data. The model classified 155 out of 156 individual Chandler Bay observations as above its SA threshold. I acknowledge that water quality is not the only factor in the decision, but in my professional opinion, this analysis strongly suggests that the water quality in Chandler Bay exceeds current SA standards. And while the entero data for Chandler Bay is still growing, there's not a lot of data. The first 3 samples that were analyzed at the state lab all came back well.
Excuse me, Dr. Krumholtz, you're over your time. Thank you.
Thank you.
I'm done anyway.
Thank you. Thank you very much. That was really fascinating. We appreciate it. And maybe we want to have some of these statistics available for the work session.
Yeah.
So we'll let you know when the work session is, okay? We could use your expertise on this.
Sure. I also, the full report is in my testimony, but I'm happy to work session and help out.
Wonderful. Thank you. Does anybody have a question for him? No? Dr. Krumholtz? No. Thank you very much for being here. So we don't have anybody online anymore. Do we have anybody in the room who's neither for nor against? We do. Okay.
I was going to start with good afternoon, but it's good evening. So Senator Tepler and Chair Dudera, members of the committee, thank you for your patience and for cracking the whip and moving things along. Attorney, I'm here for Kingfish, Maine, and I'm going to try and keep within my 2 minutes if possible for council. Let me start with one clarification, which is the species we're dealing with for Kingfish, Maine is yellowtail kingfish, Cereolus lalandi, so it's not salmon. Salmon are also commonly associated with net pen farming. We are not net pen, we are land-based. All our effluent that would be coming from this facility is filtered and treated. So it's a significant difference from what you might be under the impression of. Suffice it to say, Kingfish has been involved in this from a very long time. I've been on the team from the outset since 2019. We've gone through COVID. We've gone through Maine DEP permitting, extremely robust and rigorous, and that put everybody through their paces. Members of the organizations that you heard some testimony from did participate in the comment. They're all in the comments and that you'll see in the permits if you choose to review that. The questions that were addressed being addressed now were addressed then as well. We are also subject to review at for the shoreline zoning ordinance permitting. These issues of water quality figured very prominently in that, and Dr. Krumholz, who we just heard from, he testified in those proceedings as well. And those were then appealed to the Board of Appeals of the town. The findings approving the permits were appealed to the town. Board of Appeals, that was up. They were upheld there. They were then appealed to Superior Court. They were upheld there. The appeals at that point were abandoned as far as the town permits went. The appeals from the the staff appeals on the permits, the staff findings on the permits from the state permitting were appealed to the BEP, then appealed to Superior Court, then appealed to the law court, upheld at every single point along the way. So, Senator Tepler, you asked some very important poignant questions that should be on everybody's mind, including ours, because water quality is critical to what we're doing. But we really appreciate the opportunity to be part of this. We understand there will be workshops on this, and we understand that you'll have questions as well. I see my time is up, but I'm happy to answer any questions because there are more issues to consider.
Thank you for your testimony. Do we have any questions for this gentleman? Yes, go ahead, Rep. Reggio.
Just to get it on the record, your client is based on Chandler Bay, I take it?
Correct. There's a 92-acre parcel that is directly abutting on Chandler Bay. The project is entirely permitted, but because of the appeals and now this process, we are not commencing construction until everything is resolved so that we can move forward.
And is it your understanding that if the water quality standard for Chandler Bay was upgraded from a B to an A, that would put you out of business?
Correct. The SB classification we currently have allows the discharges under which we were permitted. The SA classification prohibits all discharges with the exception of, I believe, some stormwater discharge. So it would basically not allow us to move forward. What that means legally, I don't want to go down that path at this point, but certainly pursuant to the standard discharges from our facility as built would not be permitted. I would just also mention that in terms of the water quality issues, we currently we volunteered 2 additional monitoring stations in addition to the 3 that were requested by Maine DEP. All that information is shared with Maine DEP and with the community in order for full transparency. So we're willing and voluntary participant in that, again, because of the commitment to water quality. The technology used is currently used in the Netherlands on site in a facility that's been operating for a number of years in a conservation area with a blemish-free record. And also with respect to your point about the question you raised before, Senator Tepler, about what if there was an issue, how would that be addressed? I should point out that the standards under which we were engaged for the permitting related to full capacity. That's not going to happen overnight. It would be phased in and allow for any issues that should arise to be addressed as incremental capacity increases as the brood stock grows on the facility.
Okay, thank you. Do we have any other questions? No? Okay, thank you. Thanks for your patience. Anyone else? All right.
Okay. Senator, Representative, and distinguished members of the ENR Committee. My name is Denise Silly, and I'm a 7th generation resident of Jonesport, an elected official, and also the Associate Director at Sunrise County Economic Council, serving Washington County. And the testimony that I will be sharing with you is on behalf of the council. The Sunrise County Economic Council respectfully presents this testimony in favor of LD 2187, an act to update certain water quality standards to reclassify certain waters of the state. In particular, the council supports the recommendation of the Maine Department of Environmental Protection and the Maine Board of Environmental Protection to maintain the SB water quality standard for Chandler Bay and Jonesport. The Sunrise County Economic Council is a nonprofit corporation that works to create jobs and prosperity in Washington County. We're also the economic development arm for Washington County government. Washington County's economy is built on natural resource industries such as lobster, pulp and tissue, wild blueberries, and salmon. Changing the Chandler Bay water quality standard from SB to SA is inconsistent with the working landscape of blueberry barrens and woodlots that make up most of Chandler Bay's watershed. It would also complicate the redevelopment of the biomass to energy facility in Jonesboro and threaten the viability of the proposed Kingfish land-based aquaculture facility in Jonesport. Kingfish Maine is planning to invest over $100 million and create between 70 and 100 jobs in Washington County. The council strongly supports this project because it meets our guiding principles of economic impact, technical feasibility, community impact, and stakeholder involvement. And I'm out of time. I have a couple more points.
Thank you. Yes.
Do you have one or two more points you'd like to make?
I do. Let's see. Let's pick. I would like to point out that Kingfish has worked its way through Maine's rigorous permitting process over the past 5 years, and it has met the town and state standards and successfully defended its permits all the way to the Maine Supreme Court while maintaining strong support from the voters of Jonesport.
Thank you. Yes, I was on Marine Resources and I remember a whole bunch of you came in at one point from Jonesport. So are there any other questions? Thank you so much for being here and waiting all day. Safe travels to you. Is there anyone else wishing to testify on this bill? Okay, seeing no one, then I will declare this hearing finished.